ಬರ್ತಾನೆ ಸರ್, ಬಂದಮೇಲೆ ಇಲ್ಲ ನಿಮ್ಮ ತಾಯಿನೂ ಕರ್ಕೊಂಡು ಮಾಡ್ತಾರೆ ಸರ್. ಇಲ್ಲಿ
Lordship, kindly, my lord. Under 138 proceedings, my lord, warrants has been issued. Fresh matter at 2:30, my lord.
They have been arrested, is it?
Alla warrant issue agide. They are at any time they may arrest.
But
My lords.
yes,
156 of 2024. In this case, kindly this matter may be taken up on 30th, my lords.
yes.
My lords, 1256 of 2024, this matter may be taken up on 30th of 2020. Kindly, maybe it may be posted. my lord.
Extension of time for paying fine amount.
Put.
Matter may be taken at 2:30 or on a criminal arbitration, 11 of 90, 1197 of 2020.
Why at 2?
Even Titu, your honor, our list medical, your honor, 27th. So urgency is suspension of sentence, 2:30.
My lords, we have filed a memo for several times, my lords. Even then, the matter is not being listed.
Yeah, list
Today
on
afternoon,
Monday or-
2:30.
Monday.
Suspension of sentence.
Monday.
My lord, so-
Monday.
Serial number 68, my lord.
In case he is taken up today, arrested, you move it at 1:30 or 2:30.
Okay,
In
ma'am.
case he is arrested. Otherwise on Monday.
Okay, much obliged.
Kodi. Memo togodi.
Sir.
The memos.
Serial number 42, my lords.
Yes.
My lords, kindly have it on Monday, my lords, otherwise. Because the you have
Pardon?
engaged the senior counsel, my lords, but he is out of
What is the
town.
offense? You are ready to argue?
My lords, kindly have it on Monday, my lords.
You are for?
I'm for the petitioner, my lords.
You have complied with the order?
My lords,
Have you complied with the order? Orders complied? As ordered. Go and withdraw it, will admit it and post it for hearing. Merkali, admit, list this matter for hearing. You have withdrawn? You want to withdraw? Any objection?
I'll
Merkali, then at counsel for the petitioner and respondent are present. Counsel for petitioner seeks time, same is granted. Counsel for respondent makes an oral request seeking permission to withdraw the amount deposited by petitioner. We'll stop. The same request to be allowed, accordingly it is allowed. Petitioner is permitted to withdraw the amount. The trial court shall release the amount in favor of respondent, in favor of respondent complainant by way of electronic transfer upon furnishing relevant bank details. Subject to the outcome of this petition, in case petitioner succeeds, respondent shall refund the amount along with prevalent bank rate interest. Registry to send back the trial court records and secure it after compliance of this order. Call the next case. You will decide that or court will decide that?
Lord, serial number 56, my lord. I'm for the petitioner, my lord. Pray for an accommodation, my lord. I've informed the respondent counsel, my lord. I've also complied with the order of this court. Serial number 56.
Yes.
Please.
At
I have
request of-
complied with the order and I have informed that I'll be seeking
Along.
for.
My lords,
Much of.
serial number 57, my lords. I'm praying for a short accommodation in this matter, my lords.
Request of counsel for petitioner colon.
Oblige, my lords.
My lord, serial number 68, my lord. I have filed memo for withdraw the petition, my lord. The matter is settled before the trial court, my lord.
68,
68, my lord.
Mahadev Swami.
Yes, my lord.
Name is Sir Mahadev.
I am the.
That counsel for the petitioner files a memo seeking withdrawal of the petition as the parties have settled the matter. Memo and submission of the petitioner is placed on record. Petition is dismissed as withdrawn. Change it to a petitioner. You're not appellant here.
Yes, my lord.
70, my lord.
Roll number 62. Serial number 62.
Learned counsel for petitioner seeks time. Call this matter on.
56.
Serial number 62.
66.
Yes, sir.
Not well, my lord. Respondent, I have told my learned friend also. Kindly give me some accommodation.
Why did you come? You should have mentioned online. Why did you come? You should have mentioned online.
I don't have that facility so far.
All right. Learned counsel for respondent. Who's appearing for petitioner?
Petitioner, I'm a petitioner.
No objection.
No.
Respondent seeks time on ground of ill health. List this matter after vacation on 29th. Yes. What, Madam Savita, you don't want to argue? Request of counsel for petitioner. All this matter on 29.
62. Yeah, the vacation.
Yes, Chetan. After vacation. Oh, good. You don't want suspension. Wonderful. ಏನ್ರಿ ವೆಕೇಶನ್ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ? Counsel for petitioner seeks time. Hold on. After vacation, you want sir?
70, my lord. Petitioner. Start
Hmm.
After vacation, my lord. I mean, petitioner, my lord.
ಏನು petitioner ಗೊತ್ತು?
Date.
ಏನ್ ಮಾಡ್ಬೇಕು ರೀ?
Raise for time, my lord.
Raise for time. Avoid records, column.
Serial number 72, Your Lordship. Your Lordship, pray for short accommodation. Interim order has been complied, Your Lordship. Have informed the other side advocate also.
Counsel for petitioner seeks time. Follow.
71, my lords. 71. Thanks for time.
Respondent?
71.
71.
He's other side.
You petitioner or
Petitioner.
you are seeking time? You have not complied?
Complaint. They are not compliant. As per my inspection, they are not compliant. They are compliant, my lords.
Then go and execute it.
21(8).
Learned counsel for the petitioner seeks time. Call on.
Lord, serial number 81, Lord. I'm seeking for a short accommodation. I am on the ground of ill health. I inform the other side petitioner counsel also. 81, Lord.
Is not argued?
That last occasion I argued that because of that ill health, I informed the petitioner counsel, Lord.
ಪಾಠಾಡಿಲ್ಲ ಅಲ್ಲ ಪಾಠಾಡಾಗಿಲ್ಲ
ಇಲ್ಲ ಆಗಿಲ್ಲ.
counsel for
Last occasion
respondent
also
seeks
they are
time
not-
on the ground of ill health. He submits he has informed the counsel for petitioner. List this, we call this matter immediately after vacation.
Serial number 82, my lord. 82, my lord. Serial number 82, I appear for the petition in the case. Will be called after vacation, my lord, there is one. So 499, 500, I will see of information. Just seeing if we could close the matter between.
ಮಾತಾಡಾಗಿಲ್ಲ. Counsel for petitioner seeks time. Release. Seeks time, call this matter on 15th.
Serial number 83, my lord. Praying for time in this matter.
For
And for the petitioner. Has been partly heard. Respondents are not appearing.
your side is heard.
Partly heard.
Same, this also, madam, just find out whether it's part heard in the order. Counsel for petitioner seeks time. Follow. If it is part heard, I'll release it. I'm not interested.
88 respondent counsel prays for times. 88 respondent counsel on behalf of the respondent counsels,
This is not heard.
not at errors.
Venkatesh. Counsel for the respondent seeks time. Call on.
Much of this.
My lord, serial number 101, my lord.
Number 30, serial number 91 to 99.
Number 94, my lord, here for the petitioner.
Counsel for petitioner seeks time. Call on.
16th October.
16.
Page number 14, serial number 100 to 109.
Serial number 101, my lord.
Yes.
Seeks some accommodation, my lord.
Counsel for petitioner seeks time. Call on.
102, matter has been settled, we report settlement on.
Appealing for respondent, my lord.
Agidya.
Yes, my lord.
Both the learned counsels are present. Submit. The matter has been settled amicably. They would report settlement by call up on 25th October.
Plus 105, my lords, for petitioner, my lords. Well, also, I request for a time, my lords.
B.S. Sachin,
Time for respondent.
learned counsel for petitioner seeks time. Respondent is present. Call on.
3rd October.
My lord, serial number 107, my lord. I am representing petitioner, my lord. Kindly have it on application.
Request of counsel for petitioner. Call on.
3rd October.
All right. Await records. Call on.
23rd October. Page number 50, serial number 110 to 150.
My lord, serial number 111, my lord. I appeal for petition. I pray for some time. 111. Still,
What is this? Both parties were directed to be present. What is this case?
stage is for final hearing, my lord. One of DV Act, my lord. DV Act, 12 of DV Act, my lord.
You are directed to be present.
Yes, my lord. Because some inconvenience, I'm not in good health, my lord. I've undergone surgery, my lord. That's all.
Learned counsel for the petitioner
Petitioner, my lord.
seeks time. Call on.
3rd October.
Much all.
115, my lord, before the petition, after vacation.
Yavudu?
115.
1500.
115.
115, please, 138, after vacation.
Counsel for petitioner seeks time. Call on.
25th October.
Okay.
Page number 16, serial number 116. List 1 for orders, serial number 1, Sri Rajana C.
I am for the rest.
Yesterday they were brought, same matter.
Yes.
Same matter yesterday. Sixty-one.
161. 161.
The order sheet could have.
Serial number 160.
The petitioner is not brought. Who's appearing for the petitioner?
I appear for the petition.
Where is the petitioner?
Petition is,
Where is the surety?
surety is also
Both are here.
there.
Both were brought yesterday. Nenne karko bandidra? Huh? Day before, yesterday or day before?
Yesterday, yesterday.
Petitioner was not here.
The
Surety
petitioner was
karko.
present. Yesterday, petitioner was present.
Ah,
Day before yesterday, surety was present.
all right. Why you are not present, Mr. Counsel?
Due to ill health, I am not able to appear before this on the court on the last date of hearing, my lord.
You have been continuously absent.
2 days,
From 23.
please.
You are not appearing from 2023.
6/12/23 ಅಂತ ಬರ್ತಾರೆ.
But counsel for the petitioner is present. Respondent,
Yes, I am.
have you complied with the order?
Yes, my lord.
Complied?
Complied.
You have withdrawn the amount.
No, they have to execute the indemnity bond. They sought
They
for.
complied with the conditional order of deposit.
Already complied.
You complied?
Complied.
But we have not withdrawn. it.
Huh?
Amount has not been withdrawn by us.
Petitioner is, and the petitioner and the surety are produced before this court pursuant to the issuance of, execution of the NBW by so-and-so, or ಹೆಸರು ಬರ್ಕೊಟ್ಟಿದ್ದೀರಾ? So-and-so. Learned counsel for the petitioner filed application seeking to release the petitioner on bail. Peruse the application. Being satisfied with the reasons assigned and the bona fides shown therein, the application deserves to be allowed. Accordingly, it is allowed. Petitioner is enlarged on bail. What is the fine amount and check amount?
Check amount
The
is
amount is ₹1 1 lakh, my lord. Fine
Huh?
amount is ₹1 1,50,000. Matter may be settled. I will discuss with my colleague.
1,50,000, na?
1,50,000, 150.
You not deposited any amount.
the
50,000.
indemnity bond execute ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದು. That is no order for deposit of any amount. Only to.
So appellate court also did not direct any deposit.
They have deposited ₹15,000. 15,000.
Deposit 50%,
Please, ma'am.
subject to the following conditions. Petitioner shall deposit 50% of the fine amount
25%. please.
within 2 weeks from today.
25%.
Petitioner shall execute personal bond for a sum of rupees 1 lakh with like sum surety to the satisfaction of the trial court. It is made clear if the petitioner does not deposit the amount within 2 weeks as stated herein. This order would not inure to his benefit. The respondent would be at liberty to execute the order.
Please.
Full stop.
And I may be permitted to withdraw that order.
Learned counsel for the respondent makes a oral request seeking permission to withdraw the amount. You have any objection?
50% of the check amount may be there. Check amount.
Learned counsel for the respondent objects to the same on the ground that it will become difficult for him to recover the amount in case he succeeds in the matter. The check is issued in the year 2009 and the complaint before the trial court was filed in the year 2010. Despite the respondent complainant succeeding before 2 courts, he is unable to enjoy the fruits of the order. Under the circumstances, I pass the following order. Respondent complainant is permitted to withdraw the amount on deposit by the petitioner. Trial court shall release the amount on deposit in favor of respondent complainant by way of electronic transfer on respondent furnishing relevant bank details on proper identification. This order would be subject to outcome of this petition in case the petitioner succeeds in the matter. Respondent shall refund the amount along with prevalent bank rate interest.
Date may be fixed. But
Wait now. You are having surety today to execute the bond and
Yes, my lord. We'll
and
continue
go and
this.
do it in the office.
Please.
my lord, date may be fixed for final hearing. In fact, it was heard.
Every case date is going to be given now, even whether you like it or not.
Please.
That is the order of the Honorable Chief Justice. In all cases.
Right.
16th October. Serial number 2. Shri Manjunath ND.
Lord, so I have filed a retirement memo in this case. I have issued a letter by expressing my dislike to continue as an advocate in this case because of non-cooperation and no further instructions from the client.
What is the offense?
304 EMI.
304 convicted accused.
There is acknowledgement.
Confirmed the order.
Please, but I have produced the acknowledgement also.
ಎಲ್ಲಿದೆ? Postal acknowledgement ನೀವು ಕಳಿಸಿರೋದಿದೆ. ರಿಸೀವ್ ಮಾಡಿರೋದು ಎಲ್ಲಿದೆ?
Still, I have not received it. Acknowledgement.
Learned counsel has filed a memo of retirement after issuing legal notice to the petitioner. Same is not returned yet. All this matter after 2 weeks.
21st October. Serial number 3. Shri R.B. Sadashivappa.
Appear for the petition in this case, my lordships. On the last date of occasion, I've complied with the office objection, my lordships. And suspension of IA was allowed, my lordships. And court is directed to pay 50% deposit, my lordships. 6 weeks time has been granted. Within next week, I'll deposit, my lordships.
Some more objections are raised. 2 more objections are.
I'll do it now.
Counsel for petitioners permitted to carry out the objections within a week's time.
Obliged.
Call on.
14th October. Serial number 4.
Await records.
21st October.
Channa KM.
Serial number 5.
Await.
Archana KM.
My lords,
Await.
with this, no, my lords, the party, my lords, last, your lordship appointed me as amicus, my lords. That 62-year-old lady, my lords, she's been avoiding my phone call since yesterday, my lords. She was supposed to deposit 2 lakhs. She's not.
Not deposited.
No, she's not deposited and she's not, yesterday I called her, I told her, she has to, she said, I've arranged 2 lakhs, madam, I will come. Thereafter.
Pass over. I'll pass over. Who's he?
Respondent now.
This is 138.
138.
You party na?
Respondent.
In ನಿಮ್ಮ ಹೆಸರು?
Hare Ramesh.
Some 35-25 lakhs.
The 39 lakhs is a check.
I'll pass over, call that lady and tell her court is going to issue warrant.
She's not picking my.
Send a message.
I've sent her.
Pass over, pass over.
Please, ma'am.
Till number 6. PC Bhadragowda. 7 objections.
2 weeks time granted to rectify the objections. Fall on.
25th October. Till number 7. Mohammed Usman Sheikh. Petitioner counsel.
Report in again. Notice. The postal acknowledgement shows that the wife of respondent has received the notice from the court. Hence 2 weeks time is granted to facilitate appearance of respondent. Fall on.
Till number 8.
Petitioner
PB Badrinath.
already 1,60,000 deposited. The pending amount is Monday.
Report in again. Await report. Fall on.
28th October. Till number 9.
Yes, I propose the respondent complainant, my lord, on 22/7/24, this Honorable Court has ordered to release the amount in favor of deposited amount in favor of the complainant respondent. Either TCR and order to send back the TCR.
I am for petitioner in this case. So petitioner is the death of 2/7/2024.
Death again.
Death. After death of the petitioner, taken a order of the release of the amount. This is knowledge of the respondent counsel also. But after the abatement of the suit, this honorable court is passed the order of the case on merits.
Sorry, after the?
Death of the petitioner, this honorable court is passed the release of the amount. This information is knowledge as a respondent counsel. I am held up in some other courts, did not appear at that time. This court is passed the order, that is.
So what is the offense?
Merits.
22/7/24.
The offense.
2/7/2024 death.
What is the offense?
138.
138.
This speaker is there?
Yes.
No, where is the speaker? Where is the speaker? Where is the speaker of this mic over there?
Yes.
Here. You are able to hear me?
Yes.
Yeah?
Yeah.
All right. So what's the difficulty?
Difficulty is case.
You have brought LRs on record.
Yes, I am produced the death certificate after bring the LRs.
No, death is now not is in dispute.
Yes.
Have you you are bringing the LRs on record?
Yes.
You are filed wakalat.
Yes.
Wakalat not filed.
Till today, I am not communicated the petitioner wife. Till for information, gather the death certificate, after that file the wakalat and bring the LRs kindly.
ನಾನು ಹೇಳಿದ್ದು ನೀವು
2 weeks
ವಕಾಲತ್
time.
ಎಲ್ಲಾರ್ದು ಹಾಕಿದ್ದೀರಾ ಇಲ್ವಾ?
No, sir, no.
ಎಸ್ ಅಂತೀರಾ ಅದಕ್ಕೆ?
I want 2 weeks time.
ಕನ್ನಡದಲ್ಲಿ ಹೇಳಿ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ವಕಾಲತ್ ನೀವು ಹಾಕಿದ್ದೀರಾ ಹಾಕ್ಬೇಕಾ?
ಹಾಕ್ಬೇಕು.
LRs ಇದ್ದಾರಾ?
LRs ಇದ್ದಾರೆ.
ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀರಾ ಕೇಸ್?
Yes.
ಫೈಲ್ ಮಾಡಿ. What is wrong in him withdrawing the amount?
Case is did not given the opportunity to the trial court for the evidence.
No, that is on merits. You argue on
Merits is there. This
ನೀವು
case is
ಅಪ್ಲಿಕೇಶನ್
transferred to
ಹಾಕಿದ್ರೆ ಹಾಕ್ರಿ ಮಿಸ್ಟರ್ ಕೌನ್ಸಿಲ್.
Yes. That is the serious objection to the release the amount.
All right, you will send back the records you file.
After the amendment of this suit, get the release the amount of fine amount. Taken a order of the respondent counsel. Petitioner is dead.
Taken retrial. On that day, he remained absent. There is a order 22/7.
What is the difficulty and what is illegality or wrong committed?
Yes, my lord, one submission is.
ಹೇಳಿ.
This court is trial court, Bengaluru trial court is a transfer the return to the complaint to the jurisdiction of the Hyderabad within 30 days. This case is not filed within 30 days of the complaint. After that, that complaint is dismissed. Again, the dismissal order challenging the session court. After that, the other dismissed. After subsequently audience of this Amendment Act 138 is coming, again not restore the case, represent to the Bengaluru jurisdiction court. Bengaluru jurisdiction court no power to the review and represent trial court judges not to power to the restore or refer. This is case is very difficulty. Not within 30 days. the case is pending, the case is dismissed. So after immediately suppress the
ವಕಾಲತ್
facts,
ಹಾಕಿದ್ದೀರಾ
file got.
ಎಲ್ಲಾರ್ಸ್ಗೂ ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ
ಹಾಕಿಲ್ಲ sir. That
First
is the
ವಕಾಲತ್
merits of
ಹಾಕಿ,
the case.
ಆಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
Yes.
You have no locus to now to submit.
Yes, yes. That.
Counsel for LRs of the petitioner. What's your name?
Suresh MG.
Suresh MG seeks time to file application to bring the LRs of petitioner who's dead, correct?
Yes.
On record, and he wants to continue to prosecute this case. Hence, call this matter on.
No, this is the trial court
Been-
record to withdraw. There
They
is an
already
order,
deposited the 50% amount
22/7.
here.
There is an order of release, the deposited amount in favor of the respondent complainant. This is a old matter, my lord.
Did you hear his argument?
Yes, sir.
Let's see, consider that and pass orders. He says your petition itself is not maintainable.
Not petition, this is that, the Dasarath thing, Rupert Dasarath thing case alli, where the account was maintainable. Alli jurisdiction is, thereafter.
Argue on 15th.
Huh.
According to him, this petition of yours is not maintainable. That's what he's submitting.
Yes.
That is not correct. And all,
Okay, hear him.
that was overruled.
Next, call next.
Date, maybe.
15th.
Pen for respondent.
Await records.
The process has been paid. I thought for extension of interim order.
Extension. Extension.
410 ಗೆ ತಗೊಂಡಿದೆ 4 weeks.
What's the offense?
138.
Otherly in conditional order.
Conditional order, I have to pay it within 4 weeks. It
Ah.
expires on 410. Before that, I will pay.
410.
410. Because
So pay it. There is still time. Why you are seeking extension?
the interim order may not change the next date of the reason.
Huh?
The interim order is for the next date of hearing.
Huh?
That is the reason.
No. There is no such interim order till next date of hearing. 130 till next date yaar kodtare. Just a conditional order of compliance. If you don't comply, then probably he will execute. So 5-9 is the order.
Yes.
4-9, 4-10 it will expire.
Before that, I will.
So you want to pay before that or after that?
No, my lord, before that I will.
You will pay. Then you still have time. If needful done, issue notice to respondent. Call on.
My lords, I'm for the petitioner.
Hmm.
There is awaiting of notice, my lords. So kindly a date might be given until the notice is served.
Yes,
Kindly.
Mr. Shreyas,
Please, my lords.
for notice to R2 and 3.
How my lords? It's waiting of service
That
of notice.
counsel Shreyas is present on behalf of petitioner. Await notice of R2 and 3 and await records. Yes. Call on. 29th October.
Please, my lords, deeply obliged.
For petitioner,
Yes.
1 week time maybe.
Counsel for petitioner seeks time if needful done within 2 weeks. Issue notice. Mohan Kumar. Await,
LC.
await records. Devendra,
Date maybe. There's
Devendra. ನಿಮ್ದು ಯಾವ್ದು?
14th.
14th await records date.
Petitioner.
Yes.
Petitioner, sir.
ಕೊಟ್ಟಿದ್ದೀರಾ?
One week time ಕೊಡಿ sir.
Huh?
1 week time ಕೊಡಿ sir. Next date ಕೊಡ್ತೀನಿ.
Needful done within 2 weeks. Issue notice to respondent. Prasanna,
I appeal for the petitioner, my lords. I
Ah.
have paid the process fee, ma'am.
paid.
Please, my lord, I paid this morning.
What is the offense in this case?
My lords, the offense is under section 420. 420 read with 409, 468 and 471, 5 PC. Has been discharged. That
Proceed
order
further.
has been challenged. This with respect to the demonetization currency notes, during that time, my lords.
If you speak on the mic, I will be able to hear you. Yes, what is it you want?
My lords, I have paid the process fee. So,
All right, if learned counsel for the petitioner submits, she has paid the process fee for issuance of notice, registry to verify, if in order, issue notice to respondent. 2 weeks to comply.
Lord, serial number 17.
Yes.
Lord, a short accommodation, I will rectify the remaining office objections.
2 weeks.
Grateful.
ಏನಾಯ್ತು ರಿಪೋರ್ಟ್ ಬಂದಿಲ್ಲ await report follow
Filing petitioner, my lord. Kindly have short date. I have not taken the steps, my lord. Notice, my lord.
2 weeks time granted, if needful done, issue notice.
Yes.
Await report.
Then the interim order as granted by minister may be extended.
Interim order extended till next date. ಇದೆಯಲ್ಲ? Till next date of hearing, till next date of hearing. Two weeks time granted, finally, to comply the objections. Follow on.
That in this case, I am for the petitioner, my lord. I filed a EA for extension of the deposit of 50% amount, my lord. Yesterday I filed the EA.
That's not here.
I filed ಮಾಡಿದ್ದೀನಿ.
ಇಲ್ಲಿ ಬಂದಿಲ್ಲ ಬೋರ್ಡ್ ಅಲ್ಲಿ.
Pass on, my lord. I am ready to deposit the 50% amount. 5 days time ಕೊಟ್ರೆ deposit ಮಾಡ್ಬಿಡ್ತೀನಿ.
Time is expired now?
Expire ಆಗಿದೆ.
When?
22 ಗೆ expire ಆಗಿದೆ. This month 22 ಗೆ.
22nd. All right, we will get that matter listed. I'll list it on Monday.
Obliged.
Counsel for the petitioner submits, he has filed application seeking extension of time, registry to list the said application. How long? 30th or 1st? First.
Obliged.
Respondent may be permitted to file a wakalat for the
Yeah,
respondent.
number 23 petitioner, madam.
What's your good name?
Today on the served.
Name.
Name H.S. Ramurthy. H.S. Ramurthy for respondent.
Learned counsel, Sri H.S. Ramamurthy. Files
The
for
petitioner, my lord.
respondent. Yes, Mr. Rajesh Gowda.
Yes, my lord.
The order is passed for the deposit of.
ಏನ್ರಿ ಇದು Mr. Rajesh Gowda? You are sitting in some dark room or you have made yourself so dark that nobody can see you. It is looking like some movie and you are the dark room. ಏನಾಯ್ತು ನಿಮ್ದು ವಿಡಿಯೋ? Rajesh Gowda.
Some, my lord,
You are able to hear the court.
little bit not audible, my lord.
You are not visible. English movie ಬರುತ್ತಲ್ಲ ಮ್ಯಾನ್ caught by the CBI, FBI ಆ ತರ ಇದ್ದಾರೆ ನಿಮ್ಗೆ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ.
Sorry.
This honorable court has passed
Counsel
an
for
order.
respondent has filed wakalat, Mr.
Yes, my lord.
Wakalat.
This honorable court has passed an order, interim order, directing the petitioner to deposit the amount.
Deposit ಮಾಡಿದ್ದೀರಾ ರಾಜೇಶ್ ಗೌಡ?
My lord, another 2 weeks is there, my lord. Within 6 months, my lord. 6 weeks, my lord.
Okay.
4 weeks ಆಗಿದೆ. ಇನ್ನು 2 weeks ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
All right. Call after 2 weeks. Call on. Petition copy ಬಂದಿದೆಯಾ?
Bandis. Nenne on sir. Please.
Call.
Great, my lord.
Appearing for petitioner, my lord. My colleague went to file process in the counter, my lord.
Learned counsel submits, he would do the needful during course of the day. Same is done, registry to issue notice to respondent.
Grateful, man.
Maintain PR Vishwanath. What is this maintainability?
Filed the 397 CRPC, my lords, it may be converted for 482, my lords.
What is the offense and what is the impugned order?
Lords.
What is the impugned order?
In
You are
Sessions
seeking now
Court of-
permission to convert this.
Ah,
Impugned order, Memo hakidira?
No, no, my lords, I will file the necessary.
Application filed under section 45 came to be rejected.
Yes, my lords. May be converted to 528 of BNSS.
Did you challenge this?
Lords, in Sessions
challenge
Court
that order?
only, the petitioner has challenged the criminal review petition, my lords.
Huh?
So in Sessions Court, the petitioner has challenged the criminal review petition. So,
Criminal revision hakadra?
yeah, yes, my lords.
Not ready. So this is your second revision.
Yes, my lords, we will.
Good. Petitioner files a memo seeking leave of this court to permit him to convert this criminal revision petition to criminal petition
Petition.
under section 482
480.
of CRPC. Full stop. Same is permitted. The objection is raised by the registry is sustained as this petition is not maintainable. In the circumstances, for statistical purposes, this petition is disposed. As there is a bar under 397,
Yes, ma'am.
subclause 3. No representation on behalf of petitioner. 2 weeks' time granted to comply.
Petition this case, my lord. There are minor objections, but I will comply right now, my lord. Kindly, I filed IA for suspension of sentence on bail, my lord. Kindly we consider IA, my lord.
ಇವಾಗಲೇ ಮಾಡ್ತೀರಾ?
Yes, my lord.
Learned counsel seeks permission to rectify the objection during course of the day. He is
3 minor objections, but I will comply right now, my lord.
permitted to do. Pass over.
For the petitioner, my lord, because there are a few objections. Taken upon Monday, my lord.
List this matter on Tuesday. Council seeks time to comply the objection.
Lord, seeking the permission to convert the 482, please. 497, 397 ಕೆಳಗೆ ಹಾಕಿದ್ವಿ, ಅದು not maintainable ಅಂತ ಕೇಳಿದ್ವಿ. Kindly return the certificate copies.
On why it is not maintained?
Lord.
What are you challenging? Why? The
Oh,
bar under
311
397?
application filed,
Huh?
it has been rejected, please. 311 application is filed to summon the bank manager to give
397
the
is-
evidence on the basis of the check. It is rejected.
So you're directly here.
Please,
You didn't go before the
not,
learned counsel for the petitioner files a memo seeking leave of this court. Permit him to convert this petition, revision petition to what? Criminal petition under section 482. The objection raised by the registry sustained as there's a bar under section 397 subclause 2.
please, kindly return the,
The original. Then you convert ಮಾಡ್ತೀರಲ್ಲ, it will remain the same.
other,
You
other,
change- Change
please,
the
please, please, please.
petition format change ಮಾಡಬೇಕು. All other papers
Please,
will
please.
remain. Statistical purposes, this petition is disposed.
My lord, it may be taken up at the for first place.
You have to move the court.
Please, please,
You rectify it.
Please, please.
File the proper
definitely,
petition.
we will do it, we will do it, please.
Can move it in the afternoon or tomorrow, Monday. Yes, Praveen Kumar.
I'll do now itself. Now there was 113
Counsel.
proceedings, my lord. 3
Submit
minor
you-
corrections are there. I'll
Rectify the objections during course of the day. Yesterday,
more 3 minor objections.
pass over.
Present the respondent, please.
We have it on 16th, my lord, next month, soon after vacation.
Learned counsel for the petitioner submits that the arguing counsel is unwell. Seek short accommodation. Let's call this matter on 16th.
16th.
For my respondent, my lord.
Prakash.
I'm for the respondent.
Prakash.
Last time they sought the time for filing objection, my lord.
Hmm?
They sought the time for filing objections.
Hmm.
They have not filed objection for the application filed by the respondent for release of amount. She is 60 years old, my lord, suffering from ailments.
Yaro.
Respondent,
How old?
60 years, ago, 63 years.
What is the amount?
Amount, deposited amount 17 lakhs 80,000.
Fine amount is three.
Fine amount 45 lakhs.
What is the defense taken by them?
No, they accept that 15 lakhs is, they received the amount, but for the sale agreement, oral sale agreement, my lord. But instead, that property has been mortgaged before some other person. For release of the same, they bought this amount. Check amount is 35 lakhs.
Markade. There is no representation on behalf of petitioner. Learned counsel for the respondent is present. Has filed an application for release of the amount deposited way back on 9/2/2023. Objections to this application is not filed. Petitioner is not present today. Full stop. And this court deems it appropriate to pass an order, conditional order for release of the amount. Full stop. Accordingly, I pass following order. Respondent, complainant is permitted to withdraw the amount deposited. Trial court shall release the amount in favor of respondent complainant by way of electronic transfer, so on, so.
Record,
However, the same shall be.
records illegal, my lord.
Same shall be subject to outcome of this petition. In case petitioner succeeds, he shall refund with interest. Trial court shall, this court, the registry shall send back the trial court records and secure the same after compliance of this order. G. Rama Reddy.
My lord, I'm for respondent, my lord. Kindly undertake.
Sir, provide the court order, sir. 50% deposit ಮಾಡಿದ್ದೀವಿ.
ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೀವಿ ಸರ್. ಆಮೇಲೆ CD ಇದೆ ಸರ್.
2 weeks time, my lord, undertake to ವಕಾಲತ್ತು 1 and 2, my lord. Respond.
He's so smilingly telling he is deposited.
Please, 50% court order satisfied.
Smiling that he is deposited.
ಅಲ್ಲ ವಕಾಲತ್ತು ಫೈಲ್ ಮಾಡಿ.
ಹಾಕಿದ್ದೀರಾ?
Undertake ವಕಾಲತ್ತು ಫೈಲ್. 2 weeks time.
So, number 1, condone the delay for the 2 or 3 days, admit the.
Learned counsel for the petitioner submits he has complied to the orders of this court. Learned counsel Shri
P. Nataraj.
P. Nataraju.
Please.
J.U.
Please.
P. Nataraju undertakes to filed or undertakes?
Undertake, my lord.
Undertakes to file wakalat for respondent registry to show his name in the cost list. Any objection on delay?
My lord, 2 weeks time, my lord.
138.
283 days delay ಇದೆ.
No offense ಏನು?
ಮ್ಯಾಟರ್ ಇಂಟೆನ್ಷನ್ ಇಲ್ಲ ಸರ್. ಮೈಸೂರು ಅಡ್ವೊಕೇಟ್ಗೆ ಕೊಟ್ಟಿದ್ರು, ಅವರು ಡಿಲೇ ಮಾಡಿಬಿಟ್ಟು ಇದು ಮಾಡಿದ್ರು ಅಷ್ಟೇ. ನಾಟ್ ಇಂಟೆನ್ಷನಲ್. ಕೋರ್ಟ್ ಆರ್ಡರ್ ಸ್ಯಾಟಿಸ್ಫೈಡ್ ಸರ್.
You don't understand.
ಇಲ್ಲ, ಅದು ಫೈಲ್ ಕೊಟ್ಟಿಲ್ಲ.
Offense ಏನಪ್ಪ?
ಇಲ್ಲ.
What is the offense?
ಸೆಂಟೆನ್ಸ್ ಇದಕ್ಕೆ ಒಂದು ಬೇಸಿನ ಇದ್ದಾಗ
offense.
4 ಸರಿ ಕೇಳೈತೆ ಎಲ್ಲರಿಗೂ ಕೇಳಿಸುತ್ತೆ.
138.
NA action.
2 weeks time granted respondent to file objections.
Please,
Respondent. But the amount has been deposited. ಏನಾಗಿತ್ತು ಅಂದ್ರೆ matter has been moved. But the court said you have to file an application for early hearing. Because his brother is electrician. my lord.
Court said you should file application for early.
Please, my lord, I filed an application. Now, my lord, already he has deposited, this court has ordered for, my lord, the release of the amount. But date may be fixed, since I have filed an application for early hearing on the reason that, my lord, since his brother is electric injury, my lord, due to, from last 15 years, he is in bed. Because of this, my lord, I have moved the matter, since if he deposited the amount, that, my lord, I may have permitted to release. But court said, my lord, earlier, that is, ಇವಾಗ already he has deposited, my lord, the application may be allowed by fixing a date for, my lord, the early hearing.
Kudiyeru. There is a petition. Has he deposited?
Now, my lord, it has been deposited.
Deposited?
He has been deposited. 50%.
50%. What is the amount?
Not 10 lakhs. 10 lakhs, 10,000. The deposit amount is, my lord, the 4,57,750 rupees.
What is it that you want now? What is it you want now?
My lord, no, nothing, my lord. My lord, before passing of this order for release, I have already filed an application. Since I have moved in other court, my
Right,
lord,
that's anyway granted.
please, yeah, application may be allowed. My lord, the date may be fixed, my lord, for final hearing.
Application is already allowed, sir.
ಇಲ್ಲ, sorry, please, ಅಲ್ಲ application ಏನಾಗಿತ್ತು ಅಂದ್ರೆ, for permission to, I have filed.
Same ground, without even your application on your oral request, I have permitted you to withdraw the amount.
ಇಲ್ಲ, ಅದು ಬೇರೆ ಸ್ವಾಮಿ. ನಾನು ಇವಾಗ ಅರ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೆ, ಈ
Early
ಆರ್ಡರ್
hearing.
ಹಾಕಿನ ಮುಂಚೆ ಅರ್ಲಿ ಹಿಯರಿಂಗ್, ಇಟ್ ಮೇ ಬಿ ಅಲೌಡ್.
There's no representation on behalf of petitioner. Records ಬಂದಿಲ್ಲ ಅಲ್ಲ?
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲ.
List this matter on 15th.
Please.
For dispensation is pending, Your Honor. Maintainability is kept open in the last occasion and suspension was ordered.
This is a different revision petition. So revision will be maintainable. IA 1 of 24 is allowed. Certified copy, is it? Certified copy of the impugned order is dispensed for the time being. Same shall be produced within 4 weeks. Call on. Satish Chandra.
I already deposited 50% of the amount.
Hearing for the respondent, my lord.
50% is already
Raghavendra?
deposited.
A copy ಸಿಕ್ಕಿದೆ.
I already deposited and the delay is there.
IA 2 of 24 is allowed. Delay of 37 days condoned. List for admission.
Or call for record, Your Honor, because I am ready to argue the main also.
Give it. Pardon, my lord.
ಏನಾರ ಹೇಳ್ಬೇಕಲ್ರಿ ಪಾಡನ್ ಅಂದ್ರೆ you are waiting for
ಇಲ್ಲ,
some question and answer.
No, my lord. Actually, they have lost both in trial and appellate court. Again,
Please.
they have come to high court.
Yes, call on.
Allah, that is an admit and to call the records, call for record.
ಏನು ಜೂನಿಯರ್ ಇರ್ಬೇಕ್ರಿ, ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಪ್ರಾಕ್ಟೀಸು?
7 years, my.
ಏನು ಅವ್ರು ಹೇಳ್ತಾ ಇಲ್ಲ, ಏನ್ ಮಾಡೋದು?
Allah, it is not his case, it is my case. Call for record and I am ready to argue the matter.
Admitted. I allowed your application for delay.
Yes, Your Honor.
Just for admission.
Allah, call for record because already,
When it comes for admission, I will call for records.
because already deposited the amount.
So you want the record so that he doesn't withdraw the amount.
Allah, that is, I am objected for the withdrawal.
File, please. Give him an opportunity. List for admission, October 25th.
Thank you.
Mr. Counsel, you have to make submissions for your client. ನಿಮಗೆ depend ಮಾಡ ಅವ್ರು ನಿಮಗೆ engage ಮಾಡಿಲ್ವಾ?
My senior has not come, so I am
Take
appearing.
instructions and make submissions.
Sure, my lord. Next time I will do
Are
it.
you doing justice for your client? Next case.
Yeah, for petitioner, my lord. There is a await of police report.
ಏನಾಯ್ತಮ್ಮ report? ಇನ್ನು ಬಂದಿಲ್ಲ. Still await
Yes.
report.
Yes, in order, my lord, one small correction. Instead of son, it has typed as daughter anta, second petitioner. It has to be corrected, my lord.
It's a DV Act, is it?
Yes, my lord. My lordship, after hearing for the matter, I had passed an order to pay maintenance to wife of,
To the daughter.
yes, it has to be corrected as son, my lord.
The learned counsel for petitioner submits the order dated 5/9/24. It is stated as 7,000 per month to the daughter, respondent number 2 herein. Whereas respondent number 2 is a male child, namely Muhammad
Nihal
Ahmad Amjad.
Amjad, sorry.
The same shall be read as son instead of daughter. Ordered accordingly.
Interim order has to be continued.
Interim order extended next date.
Oblige, my lord.
Alraj. Await. Maltesh. Banditya.
I appear for the respondent in the case. 39 minutes.
You're taking, your file wakalat?
No, I undertake to file wakalat.
Your name? What is your name?
Rajat.
Learned
Rajat,
counsel
R-A-J-A-T-H.
Sri Rajat
Please,
undertakes to file wakalat for respondent.
please. Yeah, for the petition.
Yes, you have any objection on delay application?
It's subject to deposit of 50%, it may be allowed.
Delay.
Subject to deposit of the 50%.
Must have already deposited.
They
Suspension
have-
ಆಗಿರ್ಬೇಕಲ್ಲ.
They have not deposited. I have clarified.
Suspension ಆಗಿಲ್ಲ.
Suspension ಆಗಿದೆ, which was again subject to hearing of this condemnation of delay as well.
No. It will not be the order. Suspension is ordered. Deposit of 50%, 5/9 before trial court within a period of 6 weeks. Personal bond, 2 lakh rupees. You can file application if on deposit. There is still time.
Right.
Year 2 of 24 is filed for delay. To condone delay of 36 days, same is allowed. Delay is condoned.
This matter pertains to section 138 of Negotiable Instrument Act for the sum of rupees 4,10,000 matters. Concurrent findings, I am the accused before the trial court matters. I have filed 2 IAS matters. One is for condonation of delay and another one is for suspension of sentence matters. There is a delay of 653 days in filing of this revision petition, my lords. The reason for the delay is, my lords, initially the petitioner has appeared before the trial court and is pleaded not guilty, my lords. But due to his health issues that pertains to pancreas diseases, my lords, he was unable to give the instruction for his counsel, my lords. For that, I am producing memo along with the Xerox copy of the medical report of the petitioner and also to suspension of sentence and also condonation of delay, my lords. And another application is for suspension of sentence, my lords. I'm ready to deposit 50% of the amount within a 6 weeks, my lords.
You have not rectified the objections?
I have rectified, my lords. I have completed all the office objections.
is this matter? Which objection is it? Why your application is not listed for suspension?
I don't know, my lords, but I have complied it, my lords. In the beginning itself, I have filed both the application, my lords.
Record. Learned counsel for the petitioner is present. Issue notice to respondent. There's a delay of 653 days, hence IA2 is filed. In consideration of IA number 2, IA number 1 is taken up by imposing certain conditions. The order of sentence. Dated 17/10/2019 in CC 30270 of 17. Passed by 15th Additional Chief Metropolitan Magistrate, Bengaluru. Confirmed in Criminal Appeal 361 of 21, dated 1/8/22 by the 64th Additional City Civil and Sessions Judge, Bengaluru, is hereby suspended. Petitioner shall be enlarged on bail subject to following conditions. Petitioner shall deposit 50% of the fine amount, inclusive of any amount already deposited, before the trial court within 4 weeks.
My lord, 6 weeks may be kindly be granted. my lords.
Petitioner shall execute personal bond for 1 lakh with like sum surety to the satisfaction of trial court. In case there is a default on non-deposit, respondent would be at liberty to execute the order.
Much obliged, my lords.
A brief for the petition in this case. Under section 138, Negotiable Instrument Act.
Same order, madam. IA number 1 for delay. Issue notice on main and IA.
So me there
pending
stay.
consideration of IA1, IA2
File the.
is taken up.
File.
What is that?
ಅದರಲ್ಲಿ ಅಮೌಂಟ್ ಎಲ್ಲ ಪೇ ಮಾಡಿದ್ವಿ ಸುಮ್ ಕೈಂಡ್ಲಿ ರಿಕ್ವೆಸ್ಟ್ ಚಾಲೆಂಜ್ ದಿ ಅನೆಕ್ಸರ್ ಎ.
What is this annexure?
Order dated 8/2/23, passed in Criminal Appeal 30/2021 on the file of court. Honorable Principal Session Judge Kodugu. ಸುಮ್ಮಿ ಅವ್ರು ನಮಗೆ ಕೊಟ್ಟಿರೋದು 2 ಚೆಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸುಮ್ಮಿ. ಒಂದು ಚೆಕ್ಕಲ್ಲಿ 1,50,50,000 ರೂಪಾಯಿ ಅಮೌಂಟ್ನ ಇನ್ನೊಂದು 30,000 ಸ್ವಾಮಿ. 2 ಚೆಕ್ಕು 1,80,000 ಮಾತ್ರ ನಾವು ತಗೊಂಡಿದ್ದೀವಿ ಸ್ವಾಮಿ. ಅವರು ಚೆಕ್ನ 4,80,000 ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ಲೀಗಲ್ ನೋಟಿಸಲ್ಲಿ ಆಗಲಿ ಮತ್ತೆ ಕಂಪ್ಲೇಂಟಲ್ಲಿ ಆಗಲಿ ಅಫಿಡವಿಟಲ್ಲಿ ಆಗಲಿ 4,80,000 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ವಿ ಅಂತ ಎಲ್ಲೂ ಕೂಡ ಅವ್ರು ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ. ಚೀಫಲ್ಲಿ ಹೇಳ್ತಾರೆ
9,60,000.
ಸ್ವಾಮಿ
9,60,000.
ಅದರಲ್ಲಿ ಸೆಷನ್ ಕೋರ್ಟಲ್ಲಿ ಆರ್ಡರ್ ಇದೆ ಸ್ವಾಮಿ.
ಏನ್ ಸೆಷನ್ ಕೋರ್ಟಲ್ಲಿ ಏನಾಗಿದೆ?
ಅನಕ್ಷರ ಎ.
Huh? ಸೆಷನ್ಸ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ?
ಸುಮ್ಮನೆ ಎದುರು ಅದ್ರಲ್ಲಿ ಸುಮ್ಮನೆ 9,60,000 ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ ಕುಶಲನಗರ ಕೋರ್ಟಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ ಸುಮ್ಮನೆ. ಈ ಸೆಷನ್ ಕೋರ್ಟಲ್ಲಿ 9,60,000 ಬದಲು 7,50,000 ಕಟ್ಟಬೇಕು ಅಂತ ಆರ್ಡರ್ ಇದೆ.
What do you want now? What do you want? ಇವಾಗ ಏನ್ ಬೇಕು?
ಇದ್ರಲ್ಲಿ ನಮಗೆ ಸ್ಟೇ ಬೇಕು ಸುಮ್ಮನೆ. ಕೈಂಡ್ಲಿ
Notice to respondent.
ಕೈಂಡ್ಲಿ ರಿಕ್ವೆಸ್ಟ್ ಸುಮ್ಮನೆ.
Pending consideration.
ಪೊಲೀಸರೆಲ್ಲ ಅವ್ರನ್ನ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ರು.
Here the order pending consideration of IA1, IA2 is taken up. It is filed for suspension of sentence. Shall leave there. A2, orders on IA2. Order of sentence dated 19/3/21 in CC 1074 of 2015. Passed by Civil Judge and JMFC at Kushal Nagar. Confirmed in Criminal Appeal number 30 of 21, dated 8/2/23 by the Principal Judge, Sessions Judge Kodagu at Madikeri, is hereby suspended. Petitioner shall be enlarged on bail, subject to the following conditions: 50% of fine amount inclusive of any amount, 4 weeks before the trial court. Personal bond 1 lakh with like sum surety. If the amount is not deposited and complied, respondent is at liberty to execute the order. Give this back to him. File that in the registry. Suspension is ordered.
Lord, there are two matters. In the first matter, my lord, I am representing respondent. And second appeal, my lord, I am representing, my lord, the petition. Because check amount is 12 lakhs.
ಒಂದೇ ಇದ್ದಿದ್ದಲ್ಲ.
Yesterday, my lord, he was taken to.
List ಆಗಿರ್ಲಿಲ್ಲ. He was arrested yesterday.
Please.
You are now, you are the earlier counsel on record, you are newly come on
No,
record.
no, my lord, I am representing, my lord, the respondent in first matter. I am the complainant, my lord. He is the accused. I am the complainant.
You are the complainant.
Please, my lord.
So
Your
case,
Honor, my lord, almost all, my lord, in previous
you are
occasion.
filed for what?
My lord, a trial court, my lord, awarded, my lord, 16,15,000. First appellate court, my lord, reduced into 12 lakhs. Check amount.
Oh, on the reduction, you are.
On the reduction, my lord, our charge only limited extent, my lord. Trial court, my lord, awarded 16,50,000. And first appellate court, without giving any reasons, it is reduced into 12 lakhs. Means
12
check
lakhs.
amount. Only to that extent.
Where is his counsel? ಏನಪ್ಪ ನಿಮ್ ವಕೀಲರು ಬಂದಿಲ್ಲ ಇವತ್ತು?
Illa Swami, atharalli last occasion, I may make one submission. My lord, when the Karthik was appeared in previous occasions, he given NOC before this court. And he himself appeared, my lord, twice an occasion, he took time to engage advocate. And remaining is observed. Almost all, my lord, in the first appeal, my lord, it took nearly, my lord, 10 adjournment.
Or whether he has complied?
No, my lord, even it is not admitted, my lord, even no notice was issued in the said case. In fact, in the respondent, my lord, I voluntarily filed, my lord, wakalat in the first matter.
Order sheet.
And I go before the trial.
ವಕೀಲರು ಇಡ್ತೀರೇನಪ್ಪ? ಹಾ?
ಮಾತಾಡಿ ಫೀಸ್ ಎಲ್ಲ ಅಮೌಂಟ್ ಎಲ್ಲ ರೆಡಿ ಮಾಡಿ ಮಡಗಿದ್ವಿ. ಕಟ್ಬಿಟ್ಟು ಬೇಕಾದ್ರೆ ಇದು ಮಾಡಿ.
In fact, morning I called Karthik.
15 lakhs. What was the transaction, Mr. Counsel?
My lord, it is a check transaction between the complainant and the restaurant. 2013, my lord, the transaction of the year 2013. He disputed the identity of the complainant itself. And he has not deposited, my lord, single pay before the trial. It's concurrent finding.
Two 2015 check.
Please, but 2000, my lord, 2013. 2015 is, transaction is 2013.
Eleven 21 order sheet.
On 31st January 2023, my lord, only ordered to club call along with, my lord, the present petition.
ಇಲ್ಲಪ್ಪ ನಿಮ್ ವಕೀಲರು ಬರ್ತಾರಾ ಇಲ್ವಾ? ವಕೀಲ್ ಬರ್ತಾರಾ? ವಕೀಲ್
Morning I called Karthik. He told that I already given NOC along with.
ಮೈಕ್ ಹತ್ರ ಬನ್ನಿ ಅಲ್ಲಿ. ಏನ್ ಹೇಳ್ತೀರಾ ಹೇಳಿ.
ಆಯರು ಮಧ್ಯಾಹ್ನ ಮೇಲೆ ಬರ್ಬೋದು ಸರ್.
ಮಧ್ಯಾಹ್ನ ಮೇಲೆ
ನನಗೆ ಮಾತಾಡಿದ್ದೀನಿ ಅವ್ರ ಹತ್ರ ಎಲ್ಲ ಇದು ಮಾಡಿದ್ದೀನಿ. ಏನೋ ಮಾಡಿ ಒಂದು ಡೇಟ್ ಕೊಡಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಒಂದು ಡೇಟ್ ಕೊಟ್ಬಿಟ್ಟು ನಾನು ಒಂದೇ ಒಂದು ಹೆಲ್ಪ್ ಆಗ್ಬೇಕು. ಕಸ್ಟಮರ್ ಪಾರ್ಟಿಗೆ ಒಂದು ಸರಿ ಖರ್ಚು ಫೇಸ್ ಟು ಫೇಸ್ ನಾನು ಮಾತಾಡ್ಬಿಟ್ಟು ನನ್ನ ಕೈಯಲ್ಲಿ ಇಷ್ಟು ಕೊಡ್ತೀನಿ ಅಂತ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೂ ನಾನು ರೆಡಿ ಇದ್ದೀನಿ. ನಂದು ಹೆಲ್ತ್ ತುಂಬಾ ಪ್ರಾಬ್ಲಮ್ ಜಾಸ್ತಿ.
ಹೌದಪ್ಪ, ಅವ್ರು ಕಾಂಪ್ರಮೈಸ್ ಮಾಡಕ್ಕೆ ರೆಡಿ ಇಲ್ವಲ್ಲ.
ಇವ್ರೆ ಕೇಳಿದ್ರೆ ಇಲ್ಲ ನಮ್ಗೆ ಅಷ್ಟೇ ಕೊಡಿ, ನನ್ನ ಹತ್ರ ಪಾರ್ಟಿ ನಂಬರ್ ಇಲ್ಲ ಅಂತಾರೆ. ನನಗೆ ಸಿಗ್ತಾ ಇಲ್ಲ ಪಾರ್ಟಿ, ಹುಡ್ಕೊಂಡು ಹೋದ್ರು ಸಿಗಲ್ಲ. ನಾನು ಅವನ ಫೇಸು ಇವತ್ತವರೆಗೂ ನೋಡಿಲ್ಲ. ಅಟ್ಲೀಸ್ಟ್ 13 ಇಯರ್ಸ್ ಅಂತ ಕೇಸ್ ನಡ್ಸ್ಕೊಂಡ್ಬಂದೆ. ಇವಾಗ ಹೆಲ್ತ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿ ನನ್ನ ಕೈಯಲ್ಲಿ ಆಗಲಿಲ್ಲ. ತುಂಬ ಇದಾಗ್ಬಿಟ್ಟು 1-2 months ಟೈಮ್ ಕೊಡಿ, ಪಾರ್ಟಿ ಕರ್ಸಿ. ನಾನು ಬೇಕಾದ್ರೆ ಅವ್ರ ಕೈ ಮುಗಿದ್ಬಿಟ್ಟು ಇಷ್ಟು ಅಂತ ಕೊಟ್ಟು ಪ್ರಾಬ್ಲಮ್.
ಎಲ್ಲ ಇಲ್ಲಿ ಡ್ರಾಮಾ ಎಲ್ಲ ಆಗೋದಿಲ್ಲ. ದುಡ್ಡು ಕೊಡೋಗಿದ್ರೆ ಕೊಡಿ, ಇಲ್ಲಾಂದ್ರೆ ನಾನು ಕಳಿಸ್ತೀನಿ ಪೊಲೀಸರ ಜೊತೆ.
ಹೇಳಿದ್ರೆ ಫೀಸ್
ಲೋಕ್ ಜೈಲಲ್ಲಿ ಕೂತ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ.
ಇದು ಮಾಡೋದಕ್ಕೆ ಇದು ಸ್ಟೇ ತಗೊಳ್ಳೋದಕ್ಕೆ ನಾನು ವ್ಯವಸ್ಥೆ ಮಾಡ್ತೀನಿ.
ಏನು ಹಾಕಿಲ್ಲ ನೀವು, ಸ್ಟೇ ಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ, ಸಸ್ಪೆನ್ಷನ್ ಆಗಿಲ್ಲ, ನಿಮ್ ವಕೀಲರು ಇಲ್ಲ, ನೀವು ಬರ್ತಾ ಇಲ್ಲ.
ನಂದು ಹೆಲ್ತ್ ತುಂಬಾ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ.
ಹೆಲ್ತ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದ್ರೆ ನೀವು ಅದು ವಕೀಲರು ಇಡಬೇಕು, ಇಲ್ಲ ಯಾರನ್ನಾರ ಸ್ಟೇಟ್ ಲೀಗಲ್ ಏಡ್ ತಗೊಂಡು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು.
ಅಪ್ಲಿಕೇಶನ್ ರೆಡಿ ಮಾಡಿ.
ಪೊಲೀಸ್ ನಿಮ್ಮಿಂದ ಓಡಾಡಕ್ಕಿದೆಯಾ ಚೆಕ್ ಬೌನ್ಸ್ ಕೇಸ್ಗೆ? ಬೇರೆ ಕೆಲಸ ಇಲ್ಲ ಅವ್ರಿಗೆ.
ಗೊತ್ತಿದೆ ಅವ್ರ ಪರವಾಗಿ.
ಏನೇನು ಹಂಗೆ ಮಾಡಿದ್ರಿ ನೀವು?
ಎಲ್ಲಾರ್ಗು ನಾನು ಸಾರಿ ಕೇಳೋದಕ್ಕೆ ರೆಡಿ ಇದೀನಿ.
ನಾಟ್ ಅಕ್ಸೆಪ್ಟಿಂಗ್. ವಕೀಲರು ಬರಗಿದ್ರೆ ಬರ್ಲಿ ಮಧ್ಯಾಹ್ನ. ಇಲ್ಲಾಂದ್ರೆ ನಾನು ಒಳಗೆ ಕಳಿಸ್ತೇನೆ ನಿಮಗೆ. If he doesn't represent through a counsel and a suspension or doesn't pay,
Please,
I will send him to JC.
please.
Satisfied with that?
Allow.
Or you want to talk for some settlement?
ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ ಏನಂದ್ರೆ
Where is your client?
today I am not keeping present.
Where is he? Bangalore or some other place?
ಬೆಂಗಳೂರು ಆನೇಕಲ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರೆ ಬೈ
Delhi?
ಆನೇಕಲ್ ಆನೇಕಲ್
Call him, tell him to come at
Please.
1:30.
Please, I will keep him by 2:30.
He wants to see him.
2:30.
So let him meet face to face.
I will call him. I will
Ah.
call him and confirm.
ಏನೋ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತಾರಂತಲ್ಲ.
ಇಲ್ಲಿ ಭಗವದ್ಗೀತೆ ಮುಟ್ಟಿ ನಾನು ಸತ್ಯ ಮಾಡಿ
ಡ್ರಾಮಾ ಇಲ್ಲ ಬೇಡಕ ಇಲ್ಲಿ.
ಅಲ್ಲ
2 ಕೋರ್ಟಲ್ಲಿ ನೀವು ಸೋತಿದ್ದೀರಾ. ನೀವು ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ಲೋ ಅದು ಗೊತ್ತಿಲ್ಲ. ರೆಕಾರ್ಡ್ ನೋಡಿ ನಾವು ಹೇಳೋದು. ಅವರ ಅಡ್ವೊಕೇಟ್ ಮತ್ತು ವಕೀಲ ಪಾರ್ಟಿ ಬಂದು ಮಾತಾಡಿ ಅವ್ರು ಒಪ್ಕೊಂಡ್ರೆ ನಮ್ಗೇನ್ ತೊಂದರೆ ಇಲ್ಲ, ನಾವು ರಿಲೀಸ್ ಮಾಡ್ತೀವಿ. ಇಲ್ಲ ಅಂದ್ರೆ ನಾವು ಪೊಲೀಸ್ ಜೊತೆ ನಿಮ್ಗೆ ಕಳಿಸ್ತೀವಿ. ಕೋರ್ಟಲ್ಲಿ ಬರಕ್ ಏನ್ ನಿಮ್ಗೆ ಕಷ್ಟ? ಕೋರ್ಟ್ ಮುಂದೆ ಬರಕ್ ಏನ್ ಕಷ್ಟ ನಿಮ್ಗೆ?
ಇಲ್ಲ ಸ್ವಲ್ಪ ನನ್ಗೆ ಹೆಲ್ತ್ ಆಕ್ಚುಲಿ ಹಾಸ್ಪಿಟಲ್ ಅಡ್ಮಿಟ್ ಆಗಿದೆ ಸರ್.
ಎಲ್ಲರಿಗೂ ಪೊಲೀಸ್ ಬಂದ್ರೆ ಹಾಸ್ಪಿಟಲ್ ಅಡ್ಮಿಟ್ ಆಗ್ತಾರೆ.
ಗ್ಯಾಂಗ್ರೀನ್ ಆಗಿದೆ.
ಅವ್ರೇನ್ ಮಾಡ್ಬೇಕು? 15 ಲಕ್ಷ ನೀವು ಅವ್ರ ಹತ್ರ ಏನ್ ತಗೊಂಡಿದಾರ? ಅದಕ್ಕೆ
ಗೊತ್ತಿದೆ, ಅದಕ್ಕೆ ನಾನು ಇಷ್ಟು ದಿವಸ ಫೈಟ್ ಮಾಡಿದ್ದೀನಿ.
ಮಧ್ಯಾಹ್ನ ತನಕ ನಿಮಗೆ ಟೈಮ್ ಕೊಡ್ತೀನಿ. ವಕೀಲರು ಇಟ್ಕೊಂಡು ಸಸ್ಪೆನ್ಷನ್ ಹಾಕಿ ನೀವು ಕೊಡಾಗಿದ್ರೆ ನಿಮಗೆ ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಡ್ತೀನಿ. ಅದು ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ಹೋಗ್ಬೇಕಾಗುತ್ತೆ.
ಸರಿ.
Call your client.
Please, please. By
Keep
2:30.
him, meet that fellow.
Please, please.
If your client is agreeable, settle it, whatever. If
please.
he is not inclined, court will pass orders on the basis of records.
Please, please.
ಕರೆಸಿ.
Please, I will keep him.
ನೀವು ವಕೀಲರು ಕರೆಸಿ. ಇಲ್ಲ ವಕೀಲರು ಬೇಕಾಗಿಲ್ಲ, ನೀವೇ ಅವ್ರಿಗೆ ಏನಾರು ಅಮೌಂಟ್ ಕೊಡಾಗಿದ್ರೆ ನೀವೇನೆ ಕೊಡ್ಬೋದು ಅವ್ರಿಗೆ ಮಾತಾಡ್ಬಿಟ್ಟು ವಕೀಲರ ಹತ್ರ.
ನಾಳೆನೆ ಕರೆಸ್ತಿರ್ಬೇಕಾದ್ರೆ ನಾಳೆನೆ ಮಾತಾಡ್ತೀನಿ.
Make him understand. That fellow doesn't understand what is. ಅವ್ರು ಹೇಳ್ತಾರೆ ಹೋಗಿ.
Notice was served to the respondent. He is not representing the sentence was suspended, my lord. I deposit 50% of the check amount.
Deposited?
Deposited, my lord.
All right, admit.
What?
Just for hearing, secure records.
Please.
Wait. Guru Raj,
In this case, so far records have not been received.
admit, secure records. Just for hearing.
I appear for the respondent.
For petitioner, my lord, as per memo of calculation dated 26/7/2024, ಅಲ್ಲಿ correction ಇದೆ. As per trial court order, criminal miscellaneous number 419 of 2019, ಅಲ್ಲಿ 6,000 ಕೊಡ್ಬೇಕು ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ. ಬಟ್ ಮೆಮೋ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಅಲ್ಲಿ 8,000 ಅಂತ ಮೆನ್ಷನ್ ಆಗಿದೆ ಮೈ ಲಾರ್ಡ್. ಫಾರ್ 5 months, ಬಟ್ ಹಿಯರ್ ಇಸ್ ಮೆನ್ಷನ್ಡ್ ಆಸ್ 6 months ಅಂತ ರೆಕಾರ್ಡ್ ಆಗಿದೆ. So we are filing fresh memo of calculation in next date, my lord.
Have you filed memo of calculation?
My lord, there is one more memo of calculation dated 22/8/2020. That's already been submitted to them also on the honorable court also. The fresh memo of calculation is filed even today, my lord, because every month the inter-maintenance piles up. On 3/9 of every month, it goes on adding. They go up with the 7th month, July's month, and comes up with a memo of calculation. How come it will match with the present date, my lord? So fresh memo of calculation is even given to them, my lord. Ma'am, today's memo. As on date, 15,000 is pending, ma'am. Today's memo of calculation.
How much is pending?
15, ma'am.
1 lakh?
15,000, 15,000.
15. Yes, do you agree?
No, my lords. The as per memo of calculation dated 27/6/2024, ಇದು fresh memo ನಾವು filing. ಇಲ್ಲಿ 6,000
ಯಾರ ಮೆಮೋ ಅಲ್ಲಿ ಮಾತಾಡ್ತಿದ್ದೀರಿ ಮೇಡಮ್?
ಇವಾಗ ಕೊಟ್ರಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್ ಬಗ್ಗೆ, ಆ ಮೆಮೋ ಬಗ್ಗೆ ಅಲ್ಲಿ 8,000 ಅಂತ ಮೆನ್ಷನ್ ಆಗಿದೆ, ಬಟ್ 6,000 ಕೊಡಕ್ಕಿರೋದು. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್
Number submission is
6,000
permitted.
ಅಂತ ಇರೋದು.
They are taking it retrospectively, my lord.
Huh?
They are taking it retrospectively. The orders of the appellate court, first appellate court, they are taking it retrospectively. The order should be considered from the date of the order, my lord. Till the order is pronounced, the interim maintenance order from the trial court will remain as it is, my lord. From the date it is, the trial court, the first appellate court grants an order, reduces the tune of the interim maintenance. It will be reduced from that date. They are taking it retrospectively, my lord. The petitioner had paid 30,000 by then, by 3/5 when the order was pronounced. I will take you to first para, my lord, of my memo of calculation.
So what was the, you challenged before the appellate court?
No, they challenged my lord.
What was the initial order by the trial?
Initial was 8, my lord. Then it was reduced to 6, my lord. Then they appealed in the revision petition. It is reduced to 5, my lord.
Modified to 6,000.
6,000 in the first appellate, my lord.
Hmm.
In revision, it is modified to 5, my lord.
By this court?
This court, my lord. So none of the orders will be retrospective, my lord. Till the date the orders are pronounced, it will be the maintenance granted in the first appellate or the trial court will remain the same, my lord.
So you have calculated how much?
According to my calculation, it is 15,000 pending as of now, my lord.
Yes, what do you say?
As per my calculation, my lord, trial court, first appellate court orders 6,000. Here mentioned 8,000, my lord.
My lord, that
And
confusion,
3/12/2020 ಇಂದ 3/5/2021 5 month ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಆಗುತ್ತೆ ಇಲ್ಲಿ ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. ಅಂಡ್ ಸೆಷನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 6,000 ಇರೋದು. 3/6/2021 ಇಂದ 3/8/2021 2 month ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಆಗಬೇಕು. ಆದ್ರೆ ಇಲ್ಲಿ 3 month ಅಂತ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಆಗಿದೆ, ಮೈ ಲಾರ್ಡ್. ಆಸ್ ಪರ್ ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್
no, my lord.
1,70,000 ಆಗಬೇಕು. ಪ್ಲಸ್ ಲಾಸ್ಟ್ ಮಂತ್ ಪೇ ಮಾಡಿದ್ದಾರೆ, September 3rd ಗೆ ಹಿಯರಿಂಗ್ ಡೇಟ್ ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಮಂತ್ 5,000 ಪೇ ಮಾಡಿದ್ದಾರೆ.
Even that is added, my lord.
When is the order made by this court?
Page number 19, my lord.
27/8/2021, my lord.
All right, according to 5,000, have you paid full amount? 5,000, they have paid full amount? If 5,000 is taken into consideration?
5,000 is taken into consideration, it reaches, my lord.
And how you are saying that the appellate court order will operate
My lord, interim maintenance is something which-
prospectively?
Not, my lord. Retrospectively, my consideration was the amount which has to be paid into trial and appellate court was not fulfilled by that time, my lord, not this.
Correct, but that is modified by the appellate court.
Exactly, my lord. It was due on that date, my lord.
That argument of yours is not considered. Trial court order is set aside. Appellate court is modified from 8,000 to 6,000. So that is what she has to pay, he has to pay, not the 8,000. Have you challenged that order? Right? That order gets set aside. Appellate court's order now will come into play.
Exactly, my lord. I'm going on with the calculation of 5,000 only as of now, my lord.
No, you have calculated 8,000 for the time from trial court to appellate court, 6,000 from appellate court to high court order. That is not done.
From the date it was challenged up to then. Exactly, my lord, I agree with that.
From the date of the order of the trial court, it becomes 6,000 due to the order of the appellate court.
They agreed, my lord.
That order is to be paid, but this court has modified it to 5,000 pending consideration. If this court does not agree with him, it will come back to 6,000 or may enhance it. So now as of that
That is
5,000,
fulfillment.
you argue the matter, that's all. On main. And this court's order again is not modified. It is temporarily done till the disposal of IA. You continue to pay that amount.
Yes, my lord.
5,000 you continue to pay,
Yes, my
all
lord.
right? Admit. List this matter for hearing. Whether the trial court, it is stayed or proceedings are going on.
Going on, my lord, it's in the stage of arguments.
All right. Continue. Admit secure records, admit call for list for hearing. Await records. Karumbaya.
They had not completed the trial court, this honorable court directions deposit ಮಾಡಿಲ್ಲ ಅಂತೆ.
Madilva. Won't execute it. Yes, he says that you have not deposited bedem. ಮಾಡಿದಾರಾ ಇಲ್ವಾ?
ಮಾಡಿ ಈ
When was the order? 3% fine amount.
ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಸೆಟ್ಲ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿ
Within 4 weeks. It's ordered on 23. What are you waiting for?
ಅದೇ ಹೋದ್ ಸಾರಿ ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಅವ್ರ ಸೀನಿಯರ್ ಹೇಳಿದ್ರು ಅದಕ್ಕೋಸ್ಕರ.
ಅವ್ರು ಹೇಳ್ತಾರೆ ಬಟ್ ಪಾರ್ಟಿ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ವಾಟ್ ದ ಲಾಯರ್ ಕ್ಯಾನ್ ಡೂ ಮಿಸ್ಟರ್ ರೆಡ್ಡಿ.
ಕರೆಸ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
ಒಂದು ವರ್ಷ ಆಯ್ತಲ್ರಿ, ಯು ಗೋ ಅಂಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ದ ಆರ್ಡರ್.
We will kindly permit me to.
Use the mic, use the mic.
I believe we had agreed for a settlement.
You are tall, so lift the mic up.
I believe we had agreed for a settlement, my lord.
Them that you have been saying from 2023 January. And on January 2023 itself, it is stated, made clear if the said amount is not deposited within the stipulated period, respondent is at liberty to execute the order of sentence. Or Madilla, you have to thank Mr. Reddy. Go and execute the order. You want to pay, in between you can pay. Otherwise, he will spend the vacation.
We'll pay, my lord.
Huh?
We'll pay the amount.
Otherwise, his vacation is decided. ನೋಡ್ರಿ ಅವರು ಇವ್ರು ಇದಾರಲ್ಲ ಕರುಂಬಯ್ಯಾಗ ಮಾತಾಡಿ.
ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಅವರೇ ಬಂದಿದ್ರು, ಅವರೇ ಹೇಳಿದಕ್ಕೋಸ್ಕರನೇ therefore I am not
passing any order. Already there is an order that you can execute.
Yes, much obliged.
Follow on. Sundaresh.
For response, Lord, in this case, petitioner not complied the order dated 23/5/2022.
What is 23/5/22?
Yes, my lord. Passed by this honorable. And also I tried to execute the warrant, but the trial court record is misplaced, my lord.
Misplaced?
Yes, my lord.
I think misplaced.
I don't know, blood, not traced out. Actually. On 25 this month, my lord, 25/9, I will advance the case, but case file is misplaced.
Trial court records misplaced, huh?
Yes, yes, my lord.
ಯಾರು ಕ್ರಿಮಿನಲ್ ಸೈಡ್ ಅಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಾರಲ್ಲ ಅವ್ರು ಕೇಳಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಹೌ ಇಟ್ ಗೆಟ್ಸ್ ಮಿಸ್ಪ್ಲೇಸ್ಡ್. ಯಾರಿದ್ದಾರೆ ಇಲ್ಲಿ? They will tell you what is to be done.
Yes, sir.
Anyway, there is already an order for you to go and execute
Yes,
it.
yes, my lord.
So I will just adjourn the matter.
Yes, sir.
There is no representation on behalf of petitioner. Counsel for respondent is present. Respondent counsel submits that petitioner has not complied with the order passed by this court. There is already an order passed on 23rd May 22, whereby the respondent is given the liberty to execute the order in case of non-compliance of the terms and conditions of the said order. He is at liberty to execute the order.
Much only.
ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ ರೂಮ್ ಅಲ್ಲಿ ಹೋಗಿ ಒಬ್ರನ್ನ ಹೇಳಿದ್ರೆ ಹುಡುಕ್ಸ್ತಾರೆ ಅವ್ರು.
ಈಗ ಮಾಡಿಸ್ತಾ ಇದೆ ಸರ್.
ನೆಹರು.
My lord, serial number 49, and for the respondent in this case, would like to draw your lordship's attention to the order on 13/9, my lords, the previous date.
Yes.
My lords, I directed the trial court to verify as to what has happened with regard to rupees 4,40,000 deposited by the petitioner.
ಏನಾಯ್ತು ಮಿಸ್ಟರ್ ಕೌನ್ಸಿಲ್?
Last occasion, I submitted the entire order sheet of the lower court, my lord, to show that the entire amount, 4,40,000 and 17,80,000, there is the entire fine amount, 22 lakhs that has been already deposited. But my learned friend's contention saying that 17 lakhs and order that has been shown in their ledger, 4,40,000 rupees, it's not shown in the ledger. That is the contention.
Correct.
Now, ನಾನು already ಕಟ್ಟಿದ್ದೀನಿ. Order sheet ಅಲ್ಲಿ ಇದೆ.
ಎಲ್ಲಿದೆ?
Order sheet I already produced last occasion. Your lordship only directed the office to verify that. Your lordship kindly, last occasion submitted that. Your lordship kindly peruse the page number 20, my lord. In my memo along with the copy of the order. 19/3/2019, my lord. I have deposited 4,40,000 rupees.
Page number?
Page number 20, my lord. Not in that. In the last occasion, I on the memo with the certificate. Yes, yes, my lord. Your lordship kindly see.
Yes,
that, page number 20, my lord.
Yes.
19/3/2019, my lord.
Yes, Mr. Counsel. Respondent.
Please, my lord.
Have you withdrawn that 17 lakhs 60?
We are in the process, my lords. We are in the process of withdrawing that.
Huh?
We are in the process of withdrawing that, my lords. We've submitted this.
You're not interested to go and find out. He has deposited what
No,
else
my
he
lord,
can
my
do?
lords, my lords may just give me a minute. My lords may look at the previous order. What has happened is the 17,60,000 is not in dispute. It was only with regard to the 4,40,000. And when we verified that with the cash branch, there was no entry in their records, which is why your lordship had directed the trial court, the office of the trial court, to verify and come back to this court whether as to the status of that payment, my lords. The issue is only with regard to the check of 4,40,000.
Registry to communicate the order dated 13/9/24 to the trial court. A report shall be furnished as to the deposit of rupees 4,40,000 as reflected in the order of the trial court records. Hold on. What else he can do when he has deposited? Order sheet reflects, unless that is.
No, I'm not casting aspersions on my learned friend, but the issue is there is no entry there. Therefore, there's no provision for a withdrawal for us.
There's an entry by the trial court in the order sheet.
There is, my lords, but the cash branch says unless there's an entry in
I have
there.
directed the trial court to give a report. We'll see.
Very well, my lords, very well.
ಯಾವಾಗ? Otherwise, again, it will come before me. It will take time. It will not come so quickly. Vacation, let the trial court find it and send. 1st October. 22nd October.
For the petition, my lord, so 138%, my lord. So check amount is 2,50,000. Before the trial court, my lord, respondent and petitioner agree to the settling the matter, 1,30,000. But the accused not able to pay the amount. That is in the appellate court clearly mentioned that, my lord, he is not able to settling the matter and conviction was passed. Both the courts passed the conviction. Now, my lord, we are ready to settling the last occasion I submitted before this court also, my lord. But I'm not able to contact the parties, my lord.
second time
Yes, I agree. Second time I took time, my lord. But it's a referent matter, my lord, before the trial. I intimated trial court advocate, my lord. Not able to.
You have deposited some amount?
ಅಲ್ಲ ಮಾಡಿದ್ದಾರೆ
ಎಷ್ಟು
50% ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಮೈ ಪಾರ್ಟ್
You withdrawn?
ಇಲ್ಲ ಮಾಡಿಲ್ಲ ಅಂತ
ಮಾಡಿಲ್ಲ ಆಸ್ ಮಲರ್ ಬಿಫೋರ್ ದ ಟ್ರಯಲ್
Won't execute it. Direct him to execute the order.
ಮಾಡಿಲ್ಲ
ಮಾಡಿಲ್ಲ
ಮಾಡಿಲ್ಲ ಸಂಜೀವ
ಮಾಡಿಲ್ಲ ಅವ್ರು ಮಾಡಿಲ್ಲ ಅಂತಾರೆ, ನೀವು ಮಾಡಿದ್ದಾರೆ ಅಂತ.
ಆಸ್ ಏನಂದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ರೆಫರೆನ್ಸ್ ಮಾಡಿರೋದು ಅವ್ರು ಹೇಳಿದ್ರು ಮಾಡ್ಯಾರ ಅಂತ ದಟ್ ರೀಸನ್ ಮಲಡ್ ಅದರ್ವೈಸ್ ಮಲಡ್ ನೀ ಆರ್ಡರ್ ಮೇ ಪಾಸ್.
Learned counsel for the petitioner and respondent are present. Is submitted by learned counsel for petitioner that he has complied the order passed by this court on 4/5/23. Whereas counsel for respondent complainant submits that the amount is not deposited and order is not complied. In view of the same, this court deems it appropriate to pass the following order. If the petitioner accused has not complied the order dated 4/5/23 by way of deposit, respondent is at liberty to execute the order.
Respondent in this case, my lord. The similar matters, my lord, is already disposed by this court, my lord. I have given a citation or order passed by this honorable court, my lord. On 7/1, criminal petition number, revision petition 714 of 2023 and 727 of 2023.
714.
Please, ma'am. In that it's already disposed of, stating that all the relatives, all are relatives, the accused are relatives. No other matter is concerned.
Is it the same transaction or different?
Different transaction, my lords.
And then how this court can, based on that, dispose?
Lakshmish and Ramesh are all brothers. And Mr. I have given a citation, order.
There it pertained to one particular check for rupees 4 lakh.
Please, my lord.
Here, what is the amount?
Here 2 lakhs, my lords.
How can it be same?
Thing is, my lord,
It may be same transaction, but different checks are issued.
Yes,
It has heard, it has to be heard.
my lords, permitted to execute this,
He has not deposited.
no, yes, deposit some amount in other two matters, my lord. In this case,
Idral compliance ಮಾಡಿಲ್ಲ. Deposit ಮಾಡಿದ್ರಲ್ರಿ. Have you withdrawn it?
for this case is no, in
Why?
other two cases is concerned, my lord. But he did
So
not.
you are permitted to withdraw. I have passed order on 22/8. Counsel for respondent is present. He is at liberty to withdraw the amount.
Last occasion, before last occasion also it's.
Admit list for hearing. Pursuant to compliance of the order of withdrawal by respondent complainant.
As date may be fixed with us after vacation.
To the respondent in this. I appeal for the petition in this case, my lord. There are 3 connected matters posted today before this honorable court. In all the 3 matters, my lord, the parties have settled the matter and already some amount has been paid by the petitioner to the respondent. In view of the joint memo filed before the trial court, I am filing the application seeking this honorable court to compound the offense in all the 3 matters.
All the amounts are paid.
Not out of this, out of total settlement amount of 17 lakhs, 6 lakhs has been paid and 11 lakhs has been deposited before the trial court. which on the permission by this honorable court, we will withdraw.
This you made the submission on the last occasion.
Yes, my lord. On day before yesterday, the matter was listed. The parties are present.
Both the parties are present before the honorable court, my lord. Uh, 52, 53, and 54 matters, my lord, before this.
Three cases.
Please, my lord.
Parties are same.
Parties are same,
Parties are same.
transactions are same, but three different checks.
Bhimaya and Ganapati. Yes, any mesreno, sir? Bhimaya. Bhimaya. So he is the accused.
Please, my lord.
Tande ಹೆಸರೇನು?
ಜೋರಾಗಿ ಹೇಳ್ಬೇಕು.
ನಿಮ್ಮ ಹೆಸರೇನು ಸರ್? Father's name? ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆಯಾ? ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆಯೇನು?
Settlement ಆಗಿದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ.
Totally 17 lakhs. How much is the amount settled? 17.
ಮೀನಕರಿ, what?
17 ಲಕ್ಷ.
17.
All three cases?
No.
Each case?
All three
6
cases
lakh?
like that. All three cases, 17 lakhs.
17 lakhs.
So all three cases you are agreeing for 17 lakhs, is it, Mr. Counsel?
Yes, my lord. All three cases.
Each case is different.
Each case, there are different check amounts, in total about 21 lakhs, but in all, they have agreed for a lump sum amount of 17 lakhs, of which an amount of 6 lakhs has been paid before the trial court on the date of settlement.
So 11 lakhs is
Deposit before the trial court before this, including this 50% of the amount before the formal court.
so 6 lakhs is paid by way of cash.
Please, my lord.
When is that paid?
They have filed the joint memo before the trial court, my lord. They have paid.
You annexed that copy of the trial?
Yes, please, my lord.
On the last date, my lord, I had filed a joint a memo, which contained the joint memo filed by the parties as well as the certified copy of the order sheet.
I have annexed the joint memo before this court, my lord. So in the joint memo, clause 2,
Yes.
wherein it says that judgment better has paid a sum of rupees 6 lakhs by cash to the decree holder on 25/7/24, 5/8/24, and 8/8/24. The remaining 11 lakhs shall be drawn from the court deposits which is deposited with the judgment debtor before the civil court. Civil judge in criminal cases number CC 814/16, 816/16, and 718/17. That is the agreed by that order, we have prepared these three revision petitions, my lord.
So this is in the execution petition.
Please note, they have also filed a civil case wherein they have filed the execution proceedings. In the execution proceeding, they have compromised the matter.
So there was only one execution petition?
Please.
So in that you say that payment of 3 lakhs? What is that 3 lakhs?
May I request, where my lord reads 3 lakhs, My lord, reading the the memo filed by me, my lord. There's no reference to 3 lakhs.
No, right, not in your memo, in the order of the trial court, in the execution petition.
Order sheet. Regarding payment 3 lakhs to judgment debtor. 17 lakhs.
They paid it in installments is what I'm giving for.
After that, 17 lakhs, 6 lakhs has been paid by JDR. In the next page, JDR, joint memo council filed
Any
memo
payment of
regarding
3 lakhs or joint.
payment of 3 lakhs. That is inclusive or exclusive?
That is inclusive. I may be permitted to read. Order, I may be permitted to read. Case is called, both parties have counsel are present, filed joint memo stating that both parties have amicably settled the matter for a total sum of rupees 17 lakh. Out of the said amount, a sum of rupees 6 lakhs has been paid by judgment debtor to decree holder on 25/7/24, 5/8/24 and 8/8/24. Remaining amount agreed to release from the court deposit deposited by judgment debtor in criminal cases by the decree holder. Hence, prays to close the case in terms of joint memo. Judgment debtor counsel files memo regarding payment of 3 lakhs to judgment debtor, a decree holder.
That was the balance amount.
Of balance amount that has been paid.
That's good. So all these three can be disposed by a common order.
Could be disposed by.
Yes, please, madam. I have filed 3 separate applications seeking this Honorable Court to compound the offense. There are 3 different checks, madam.
Nine 1071 and 1177.
1071 and 924.
924, 992, 107, 52, 53, 54, serial number.
52, 53, 54.
Please, ma'am.
These 3 petitions have been filed by the petitioner accused, questioning the judgment of conviction and order of sentence passed in CC number. 3 different cases CC number application, whereby the petitioner accused came to be convicted for the offense punishable under section 138 of NI Act. Or ಕೂತ್ಕೊಳ್ಳೋಕೆ ಹೇಳಿ. NI Act. So dash. ಊರಲ್ಲಿ different ಇದೆ ಅದು ನೋಡ್ಕೊಂಡು. In default of payment of the fine amount, accused was ordered to undergo SI for 6 months. Out of the fine amount, dash amount was ordered to be paid to the complainant as compensation in each of these cases. Agreed by the judgment of conviction, petitioner accused preferred appeals, 3 appeals respectively, in appeal numbers also, challenging the same. However, the appellate court, not finding favor with the petitioner accused, dismissed all the 3 appeals and confirmed the order of the trial court. Agreed by the concurrent judgment of conviction, petitioner in these 3 cases are before this court, questioning the legality of the said orders. Full stop. Para. During the pendency of this petition, learned counsel for the petitioner and respondent submit that the parties have amicably settled the matter and they have filed an application under section 320 of the Code of Criminal Procedure for compounding the offense. You also add 147 in this.
Please, I see.
They filed a joint memo along with the application, which was filed before the executing court in execution number 15 of 2020, whereby the parties have settled the matter for a full and final amount, total amount of rupees 17 lakhs. And the petitioner accused has deposited 6 lakhs by way of cash, which is acknowledged by the respondent before the executing court. And the order sheet of the said executing court is produced along with the memo, which reflects the same. It is submitted that the balance amount of rupees 11 lakhs out of 17 lakhs has been deposited before the trial court, correct?
Yes.
In these three proceedings,
Yes.
in CC number 814/16, 816 of 16, and 718 of 17.
In pursuance to orders of this honorable court.
Full stop. In view of the petitioner and respondent having settled the matter, and having filed the application to compound the offense, nothing further survives in the matter. As the provisions of section 147 permits compounding the offense, accordingly, this petition is to be accepted. Both the petitioner and respondent are present before the court. This court has inquired with the petitioner and respondent. They submit that they have executed the application, they filed the application and affixed their signatures. Where is the signature of the parties?
Petitioner has signed the,
Huh?
petitioner has signed, I mean, I will take the signature on all the
They
pages.
have to sign.
I said,
So the joint memo is not here, that is filed there. We don't
that memo is
sign
signed there.
Tell them to sign in all this.
Please, but
Petitioner and respondent have affixed their signature and affirm with the contents made in the joint memo filed before the executing court regard to settlement and deposit of amount as stated therein, amounting to rupees 17 lakhs. Petitioner does not have any objection in respondent withdrawing the amount deposited before the trial court. So also respondent does not have any objection in petitioner being acquitted of the charges by setting aside the judgments rendered by the trial court, affirmed by the appellate court. Accordingly, pass the following order. The judgment of conviction, an order of sentence passed by the trial court in CC number 814 of 16, 816 of 16, and CC 718 of 17, affirmed in criminal appeal number, number so and so, is hereby set aside. Petitioner is acquitted for the offense punishable under section 138 of NI Act in all these three cases stated here and above. The respondent is permitted, respondent complainant is permitted to withdraw the amount deposited before the trial court in all these three cases. Trial court shall release the amount in favor of respondent complainant by way of electronic transfer upon furnishing relevant bank details on proper identification. A respondent acknowledges the receipt of rupees 6 lakhs paid by cash, correct?
Yes.
Where is he?
But
How old is he?
Lord.
He is the complainant alone.
My lord, yes, he is the complainant.
No, tell him to come near. Mr. Raja Bhimayala,
No,
Raja Pimani, sir.
he is the accused, my lord, the respondent.
Complainant.
ಗಣಪತಿ ಅವರೇ 6 ಲಕ್ಷ ಕ್ಯಾಶ್ ಬಂದಿದ್ಯಾ?
6 ಲಕ್ಷ ಕ್ಯಾಶ್ ಬಂದಿದೆ ಅಂತ
ಬಂದಿದ್ಯಾ? 11 ಲಕ್ಷ ಕಲೆಕ್ಟ್ ಮಾಡಬೇಕು. Accepts the, acknowledges the receipt of rupees 6 lakhs by way of cash. Ordered accordingly. The records are here?
The records have been, not known, my lord. The records
Not
have
here.
been recorded. No.
Any application? ಹೌದು, each of the cases separate order sheet. Tell your parties to sign in each of the order sheet. Yeah, madam, just add the bail bond of the petitioner and that of surety stands cancelled. No representation in either side. All on.
Petitioner, Your Lordship. I may be permitted to file an application for extension of time to deposit the amount, Your Lords. 1 week time may be granted, Your Lordship.
Respondent.
We approached the court for depositing, but the court refused that the time has been expired.
When was it ordered?
Your Lordship, it was ordered on 5/8, Your Lordship. For 6 weeks.
Counsel for the petitioner and respondent are present. Counsel for the petitioner files an application seeking leave of this court to extend the time. Deposit the amount as ordered by this court. Being satisfied with the reasons assigned, cause shown. This court deems it appropriate to grant extension accordingly. Time is extended to 15th of October to comply with the order. If the said order is not compliant, complainant shall be at liberty to execute the order.
Great. 15th of October, Your Lordship.
Yeah, 5/15.
Yes, yes. Grateful.
Santosh Kumar.
But same for the respondent, my lords.
Appear for the petitioner in this case, my lords.
My lords, on last date of hearing, the petitioner advocate insisted that there is a talks of settlement which is going on, but our client has informed that there is no settlement talks. So, and on 27/2024, this honorable court had directed to deposit 50% of the amount, and the petitioner has not yet complied that particular order.
Not complied.
Not complied. They have not deposited 50% amount.
Yes, Mr.
In the trial court.
Where is the petitioner counsel?
My lords, appear for petitioner, my lords.
Deposit.
Amount is not been deposited, my lords. Trial court advocate was been informed to talk with the parties, my lords, as per my instructions.
As per instruction?
The client had instructed with the advocate appearing before the trial court to speak with the respondent, my lords. So the talks are still not at reached any settlement, my lords.
Record. Learned counsel for petitioner and respondent are present. Counsel for respondent submits that the petitioner has not complied with the orders dated 22/7/24 with regard to deposit of 50% of the fine amount. Full stop. If the said amount as ordered by this court is not deposited, respondent is at liberty to execute the order. Registry to send back the trial court records and secure it thereafter.
Right.
On behalf of the petitioner, pay for a short accommodation, Your Lordship. Senior counsel will appear in the matter.
Learned counsel. Huh? All.
A short accommodation. Interim order may be
Call
extended.
after 2 weeks. At
Interim order,
request
Your Lordship.
of petitioner.
Interim order.
Interim order extended next date.
So that
We know.
Fresh matter, check amount is 75,000. The Tribunal has ordered fine amount of 1,25,000.
Check is 75.
Oh, 70.
Appeal is dismissed.
Appeal dismissed, concurrent pending. Deposit 50% in the 75,000.
Heard learned counsel issue notice to respondent, orders on IE1. The order of sentence dated 1/7/23 in CC 724 of 20, passed by first additional civil judge and JMFC Chikmagalur, confirmed in criminal appeal 132 of 23 dated 25/1/24. A principal district sessions judge Chikmagaluru is hereby suspended. Petitioner shall be enlarged on bail subject to following conditions. 50% of check amount inclusive of any amount, 4 weeks before trial court, 1 lakh personal bond with like sum surety.
Represent the second respondent.
Bring for the petitioner, my lord. And this petition is filed challenging the order on application under section 450 and 457, my lord. Petition is accused number 4, my lord. Respondent number 2 is the complainant. Both accused number 4 and complainant has filed the application for release of the amount of rupees 15 lakhs, my lord. The application filed by the complainant was allowed and application filed by the accused number 4 was rejected, my lord. Based on that order, we have challenged in this revision petition, my lord.
So it is only between you both as to who is entitled.
Please, madam.
Please, my lord.
The request to be heard and posted on 15th or 16th, you argue.
I have some urgency, my lord. I had taken loan. No, my lord, I am paying interest to the said amount, my lord. For that reason, my lord,
Can't hear this matter now. List this matter on 15th.
Lord, can it be on 17th, my lord?
Or 15th is not working. 16th, 14th, 15th, 16th.
14th, my lord.
16th, my lord.
All on 16th.
My lord, interim order may be extended.
Interim order is extended till next date.
Much obliged.
There's no representation on either side. All on.
Hearing for the petitioner in this case, my lord, these two cases. Petition filed against challenging the order of the appellate court in enhancing the interim maintenance of proceedings arising out of DV proceedings, my lord.
There is a due of arrears of 2,26,000 rupees due, my lord, as on this date.
As directed by this honorable court, I have, on the last occasion, I have submitted, I have transferred 1 lakh
My lord,
as per the interim order.
My lord, I have.
May make, please.
I
And
have
so I was directed to deposit an
I filed a
additional
memo
sum of
also, my-
rupees 1 lakh by order dated 12th of August. That I have deposited through their account, transferred through NEFT. And 7,000 was directed to be paid as per the order of the trial court. For the month of previous month, I have transferred 1,07,000. Separately, it was transferred, and that has been acknowledged also.
My lord.
Now I was directed to continue to pay 7,000 at the rate of 7,000. So far, I have deposited 3,72,000. And they have not included 5,000, which was paid by cash during pendency of the appeal. And August, my lord has directed me to.
My lord, yes, he's only harping on what he has paid it. What is not paid because 2019 was the order. 3/9/24 mortally 60 months has to be paid. As on this date, he has paid, I have paid the calculation also latest I paid. 2,67,000 rupees is due is that. It is an interim maintenance he has to pay, my lord. What is paid after the direction, it is not that. He has come before this honorable court of directed, he paid 1,70,000 out of the arrears. And he has to pay up to date. He cannot even maintain the revision without complying the order of the both court. So what has happened, my lord? He has filed two appeal. The first appeal, he said 1 lakh is paid it. Don't take a coercive step. That is all. There was an order. Then the learned judge is retired. It has come before your lordship. Lordship was observed, and second appeal is filed on the same cause of action. And the second appeal is there are two appeal on the same set of the facts. And now this appeal, my lord, that order, the earlier order, he said not to take coercive step. Doesn't mean he does not have to pay. He has to pay. And I need not have to take a coercive step like FLW and all this thing. That is all the orders. Now what has happened? What is due, my lord? Let him pay, my lord. And the maintenance he has to pay as and when falls that. He has paid about 7,000 rupees or the year, 2 months earlier. What is the current month, my lord? He has not paid it. So that has to be paid. See what has happened, once he pays, he can take up a shelter about 2-3 months. Then he pay the partisans. He cannot even maintain the revision, my lord. The first revision is not maintainable. He has to pay the 2,67,000 rupees as on this day, the arrear. It is an interim maintenance, my lord. Nothing else.
May make.
The latest judgment of Justice Nagaratna is very clear, my lord. He cannot hold it. They have to pay with interest. So, my lord, what is paying, I am not disputing. What is paid after the direction, it is arrears which is paid. He is not doing a favor or a charity. That he is keep on telling the same thing every time it comes that he keep. Yes, my lord.
What is the arrears?
2,67,000, my lord.
How much he has paid?
He has paid 3,74,000 as on this date, total.
So over and above that, 2 lakhs is still due.
No, my our total arrears 6 lakhs. Out of that, he has paid 3,74,000. And 2,26,000 is there. I paid the entire date and the calculation also, lordship. And I served a copy on the other
What do you
side.
say? Is there anything due?
My lord, I will file a memo of calculation on the next date, any date he was given. And on the order of, as per the directions of this honorable court dated 12th August 2024, I was directed to pay 1 lakh rupees and directed to continue to pay the amount. On the previous date, I have sought for the GPR phone pay
But at
details.
regarding that,
They
I
have
filed
sent
a memo,
they have sent a memo through
I filed
mail.
a memo. She doesn't have a facilities of that. Continue
His
to pay.
phone
that
number is
given.
given, we can transfer the amount. 7,000, it's
She doesn't have a
difficult to
facilities and
transfer.
I have to. Yes, my lord. I filed a memo, my lord.
You have transferred that amount or not?
1,07,000 was transferred as per the directions of this honorable court.
To the account.
To the account, NEFT ಮಾಡಿದ್ವಿ ಒಂದ್ಸರಿ ಅದು ರಿಟರ್ನ್ ಬಂತು ಫೇಲ್ ಆಗಿ ನಂಬರ್ ಚೇಂಜ್ ಆಗಿದೆ. Next when
that is successful.
That is successful. Even on the previous date I have filed
It is
that
what
account
is
statement
paid,
also.
1,07,000 on 3/9 by the NAT, it has been credited, my lord. I have paid my memo, my lord. I served a copy also. Whatever my friend has paid it to, this is the respondent, the date I had given it. And I have filed the entire what you have paid it also. I have filed the memo also served a copy on the other side.
What is the status of that DV Act case?
They have just commenced the evidence,
That is, it's
not
for
it,
evidence.
marking of documents is not done. And in this matter, my lord, the peculiar case is that the respondent herein during subsistence of her first marriage with one Mr. Nagarendra, she has entered into marriage with this petitioner. And that Nagendra has filed a matrimonial case, MC case before the Mangalore court in 1991, 92, 93. And in that matrimonial case, she appeared and filed a written statement. Later, that petition was dismissed as not pressed. And during subsistence of marriage, her first marriage, she entered it, concealing that fact, she has entered into marriage with my client. And I have filed a proceedings before the family court in Bangalore to declare that my marriage is null and void. That decree was granted. That marriage was declared as null and void.
Your client's marriage?
Yes, my marriage. And against which they have filed appeal. It's there is a stay in that. I don't dispute that. But the fact remains that the marriage that I have produced those divorce proceedings case of previous husband during subsistence. That's why on the when the matter was before the other bench, the honorable court has asked to orally asked that the whatever the amount due till the date of decree of my case declaring nullity, you have to pay. As on that date, the 5 lakhs and add was there due. That was disposed on.
You continue to pay. We'll avoid the, what is
Because,
the status
and
of
one
that?
more thing, my lord, I want a that let the subject to result of the petition, the payment should be made because the nullity of marriage is there.
My lord.
And whatever the relationship they may propose before this honorable court, have to counter that. Because
After marriage, how many years you lived with her?
almost 20 years, my lord. 296 was the marriage. 2016, I came to know about that proceedings, about her marriage.
My lord.
Immediately, I have filed,
due respect,
a case before the family court for declaration of nullity of my marriage.
Both of you are now staying separately?
Please, my lord. Since 2016, we are living separately.
My lord.
You have withdrawn
And,
that amount?
My lord, that 1 lakh.
Directly to the account you have paid?
Yes, my
Account,
lord,
they
My
let
lord,
them
he has-
furnish the phone number which
he has
is linked to
defined
the
the-
bank account.
Defied the both orders of this honorable courts. What has happened? It is a DV Act. It is only a revision against the appeal. The revision is not maintainable. Both appeals are not maintainable on a single set of a judgment. You cannot file. And we were ready to address the arguments. What has happened? Every time when he wants to come and pay the arrears of it is a domestic, it has got nothing to do with the into marriage. After divorce, it is a division bench seized of the matters and stayed is that. That has got, it is only a section 12, but the interim maintenance given. For that, he will not argue on this. He will canvass the beating around the bush trying to prejudice. We will, first of all, your lordship has observed, the appeal is revision itself not maintainable. To hear on the maintainability, you are also reported. And meanwhile, you are given an opportunity to pay my arrears. The arrears he has today, what he has paid it about 2019, my lord, is an order. He has paid 10,000, 5,000 and now after the direction of a lordship, he has paid 1,07,000, that substantial amount. Earlier, it was a transfer from the London debt, it was paid 1 lakh. 2,67,000 rupees, the interim maintenance arrears. Let him clear, my lord. I will, your lordship may please to hear the matter on maintainability. I will argue. I will also demonstrate before your lordship, even the recent judgment, there were 4 days of work. It's his lordship has passed an order. This revision is not maintainable. I'll convince your lord. This is only, we are confined to section 12, not on Hindu Marriage Act. What is the domestic violence? My friend is totally misconceived, misdirecting. You will always tell if the marriage is that I prove beyond a reasonable doubt to that court. That competent court decided, the division bench, his lordship has appealed. He has also appealed. He heard the matter, it was stayed. That has got nothing to do with this. I will convince regarding the interim maintenance which has been filed. The first appellate court has enhanced only a 3,000 rupees more. 10 out of 7,000, 10,000, my lord. For that, they can agitate and successfully drag on from 2019. Can you imagine the harassment method, my lord? This itself is a cruelty. and it comes under the domestic violence of the petitioner before your lordship. Let him pay this amount, my lord, next date of hearing, lordship may fix it, or today also I'm ready to address the arguments.
In this,
Yes,
may I
let him
make a
fail.
submission, please, my lord?
You will
In
say
two-
you have not got the
in
citation.
2016,
I'm not hearing the main matter. Why you are
please,
wasting
my
your
lord.
energy?
No.
Write down. Learned counsel for the petitioners is permitted to file a memo of calculation with regard to the amounts paid or deposited to the account of respondent by the next date of hearing. Call this matter on 22nd October.
And whatever the arrears is there, let him pay, my lord. As
He's already
continue to pay.
continuing to pay.
Continue to pay, my lord.
And what else you want?
Yes, ma'am.
I have sought for directions to their phone pay ಇದಿಲ್ಲ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ ಜಿಪೇ ಅಟ್ಲೀಸ್ಟ್ ಫೋನ್ ನಂಬರ್ ಲಿಂಕ್ ಕೊಟ್ರೆ
ಅಕೌಂಟ್ ನಂಬರ್ ಇದೆಯಲ್ಲ ಅದಕ್ಕೆ ಯಾಕೆ ಅಷ್ಟು?
ಅದನ್ನೆಲ್ಲ ಕೊಟ್ಟಿದ್ವಿ ಎಲ್ಲ. It's a city civil court, my lord. Nowhere else. I had given the account, he has sent already once. Let him continue to send.
No, he's asking you to send GPay or Google Pay.
He doesn't have a facilities, my lord. And I have also filed a memo.
Ilva?
he is a beautician.
The memo, my lord. She doesn't have facilities, the phone pay, GPay. And what has happened earlier, mother added something they have misused and all, and she has cancelled it. She doesn't have. So that the same thing he can phone pay. Again, I filed a necessary memo and served a copy also intimated.
It's already given to him.
Yes, yes. It is
He
given
sent
to
by
him.
mail.
Send it to the same account.
Same account. Let him
Whenever you
continue
pay,
to
file a memo to this.
Calculation with regard published.
My lord,
Date.
can I make one submission, my lord? My friend Nagaraj is there, it's a serial number 100. I have to go to funeral of Suman. And I told my friend.
ಯಾವ್ದ್ರಲ್ಲಿ?
Nagaraj sir, 100, I'll take time. It can be
ಯಾವ
on
ಕೇಸಲ್ಲಿ?
serial number 10 mile, 100 mile. Nagaraj. Because 3 o'clock is a funeral,
Serial number?
100.
What do you want?
I just wanted to postpone it, it can be taken on Monday, mile.
Lordship has heard the matter, my lord.
Yes, sir, yes, sir. I only asked, I'm going for a funeral, sir, Suman's funeral.
Final hearing.
Yes,
The argument ಆಗಿದೆಯಾ?
It started, it's yet to commence it.
I give the
It just
reply also, my
started.
lord.
Midst of the arguments,
You are yet to commence.
yes,
He commenced, I give the reply also, my lord. Then he said that there is some other grounds there.
there are other matters, some citation has. It can be on Monday, my lord. I have to go to that Suman's funeral, you said, you worked with us. That's all.
If it's not part heard, I will release it.
Parted.
Part heard ಆಗಿದೆಯಾ?
Ordered ಅಂತ ಆಗಿಲ್ಲ. but
Parted ಆಗಿಲ್ಲ, ತಾವು
Lordship has
ಹೇಳಿದ್ರಿ,
heard.
lordship has told you will further hear the matter.
Learned
And in fact, both agree to argue this unfortunate case.
ಬರ್ಕೊಳ್ಳಿ. Counsel for petitioner and respondent are present. Counsel for petitioner seeks time on the ground of a bereavement of a friend. Hence list this matter on 21st October. Third parted ಆಗಿಲ್ಲ.
Grateful man.
21st.
My lord, item number 70, there are two matters. One is complaints revision.
Adjourn ಆಗಿದೆ. It's adjourned.
The state would have informed me, I'm waiting. I don't know whether they have taken the 10:30. What matter, mine matter, my lord.
10:30 ತಗೊಂಡ್ರ?
At least date will.
Date ಕೊಟ್ಟಿರ್ತೀವಿ. Date ಕೊಟ್ಟಿರ್ತೀವಿ. All cases now dates are given. But your friend,
This, no, even I may appear for the accused, whatever it may be. This courtesy, you would have to intimate me. Otherwise, why should I have to wait from 10:45 it came?
I agree with you.
No, I satisfied my lord. If the date has been fixed, I understand.
Date ಕೊಡ್ತೀವಿ ಎಲ್ಲ ಕೇಸಲ್ಲಿ, ಬಟ್ ಕರ್ಟಿಸಿ ಇಲ್ವಲ್ಲ, ಏನ್ ಮಾಡೋದು?
At least from here on.
Court tells everybody, sir, but they don't inform what to do. Your friends, this court makes it a point to tell each of the advocates so that they don't have to come and wait till 5 o'clock. But our ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ನಾವೇನ್ ಮಾಡೋದು? They tell we will inform.
Petition had to be heard. If respondent takes time, suppose in such case, sometimes interim order is there, non-extension or extension, I will be suffered first.
And such orders,
Not here. Even
such situations, this court will not grant adjournment. This is
day of the date fixed matter.
this is a matter coming up for what? Final hearing,
No, admission.
admission. So it is already, interim order is already granted. That is why we have adjourned the matter.
And avoid DCRI. But
ಅದನ್ನು ಆಗಿದೆ.
Petitioner, my lordship. The offense under section 138 of NA Act, my lordship, petitioner by accused.
Counsel issue notice to respondent.
20% already deposited before the first appellate court.
A2. Order of sentence dated 21/9/23, CC 887 of 18. 10th additional civil judge JMFC at Mysuru. Confirmed in criminal appeal 367 of 23, dated 5/8/24. 4th additional district and sessions judge Mysuru. Suspended. Subject to following condition, petition shall be released on bail. 50% inclusive of the amount deposited before the trial court, 4 weeks. 1 lakh personal bond like same surety. If amount not deposited, respondent at liberty to withdraw.
Please.
Yes, Madam Archana.
My lords, I've been calling her. She's just sent a message saying her sugar is high and that she's not able to talk. That is what, and she's saying she's not well because she couldn't arrange the money.
That is respondent.
She's there outside.
Kodima. She was brought by way of a warrant,
Please, my lords. I
NTW
filed
or bailable warrant?
available.
Bailable warrant.
So I filed an application.
PW available. 39 lakhs 5,000. ಎಲ್ರಿ ನಮ್ಮ ವಕೀಲರು? What to do better? Not coming, not interested.
Sorry, my lord. Okay, no, no, no.
Is undertaken on twice occasion to pay some amount. So for the past 2012, my lord, he is harassing like anything. Even though he was convicted and then appeal came to be dismissed. Then this honorable court passed an interim order, is not complied. Even first appellate court, she has not deposited the amount.
So nothing is paid.
Nothing is paid for. Single NP is not paid. Even I filed an appeal before the, that is the session court for enhancement of the conviction order as well as the imprisonment. So wherein she has not received the summons also. Then after vacating the interim order by the honorable court, so I pursued the matter in the court below, wherein she has not traced out. The NBW is still pending.
Your lordship was kind enough to grant her two adjournments, my lords. But now it appears that she doesn't want to settle.
What is the sentence ordered?
Sentence at 30 lakhs, check amount is 39 lakhs.
Can say
Since the 3 months, madam. That is, so we filed an appeal for enhancement for 2 years.
Three months, my lord.
3 months.
You have not filed any appeal.
What, ma'am?
You did not file any appeal.
Yeah, appeal is pending for enhancement. It is pending in the district court, the city civil court at Mayan.
Leave ಆಗಿದ್ರೆ
Not like it.
for enhancement.
For enhancement, wherein she has not received the notice. She is always absconding. Whenever I take the notice, even the police also not cooperated.
But have served it here when she was present.
They made a mistake.
All right, now you see the sentence as ordered is only 3 months in default.
In default,
He has already undergone 50 days imprisonment.
15 days.
50 or 15?
15.
50 ಅಂತ ಬರ್ದಿದೆಯಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ.
ಐವತ್ತಿಲ್ಲ.
50 is
Oh,
what she
50.
told last time.
50 days. So almost 2 months.
2 months.
So if we want her to be in JC, this court will order. If you want the amount, we'll order, list this matter after vacation
Vacation.
and give her some more time because she is expecting some money from somebody from Bombay. If you're interested in money or you're interested in setting her in
I'm
JC?
totally interested in money, my lord. I don't want to put her in
But-
jail.
Learned Counsel, Srimati Archana came acting as amicus for petitioners present. There is no, the petitioner is not present. And neither she has paid the amount as promised on the previous date of hearing. Also submitted by Learned Counsel for respondent that no amount is paid till date. Considering the submissions of counsel for petitioner, time is granted till 15th of October to make the payment. If the amount is not paid, respondent would be at liberty to execute the order.
Obliged.
Or yearly payment, at least is make some state payment initially. Right, that law will take its own.
Petition this case, my lord. I complied the office objections, my lord. The trial court convicted the petition for offense punishment 279 304A, my lord.
Learned Counsel. Two 279-304A.
Yes, my lord. The trial court sentenced the petitioner to undergo 1 year, 1.5 year, my lord. The petitioner filed an appeal with the Honorable Sessions Court and the same came to be dismissed, my lord. Hence this petition, my lord.
Counsel for the petitioner submits he has rectified the objections. The registry to verify. In the meanwhile, issue notice to respondent.
The sentence may be suspended, my lord.
Orders on IA1. State illa.
State, my lord.
Then CGP is there to take notice for respondent. Orders on IE. The execution of the sentence will be suspended. Dated 34/22, CC 7848 of 2018, passed by 4th MMTC at Bangalore and confirmed in Criminal Appeal 4924. Sorry, Criminal Appeal 626 of 22, dated 4/9/24 by 60th Additional City Civil and Sessions Judge Bengaluru. Subject to the following conditions. Petitioner shall deposit the fine amount as ordered by the trial court. Shall execute personal bond for a sum of rupees 50,000 with like sum surety. Shall not leave the jurisdiction of the state without leave of court.
Obliged.
Complied the office petitions, my lord. The 138 proceedings, my lord. Sought suspension of sentencing. Check amount is 3 lakhs, my lord. And I'm seeking suspension of sentencing.
Learned Counsel for the petitioner Submits he has rectified the objections. Registry to verify. And meanwhile, issue notice to respondent. Orders on IA1. The order of sentence dated 15/4/23 in CC 316 of 21. Principal Civil Judge JMFC Chintamani. Confirmed in Criminal Appeal number 30 of 23 dated 18/7/24 by Second Additional District Sessions Judge Chikbalapura sitting at Chintamani suspended. Petitioner shall be enlarged on bail subject to following. 50% inclusive of the amount already deposited. 4 weeks for trial court. 1 lakh personal bond with like sum surety.
Grateful.
Appeal for the revision petitioner in this matter, my lords. My lords, this is the matter yesterday. The revision petitioner was produced in pursuance of direction issued by my lordships. My lords, I have filed the IA copy acknowledgement. I may be permitted to submit.
Don't appear in the morning, please.
My lords,
Don't appear.
I had to file IA, my lords, to recall the NBW. In the meantime, my colleague could not appear. I apologize for that, my lords. I have filed an IA recalling the NBW.
Now you have filed.
Please, my lords, I
What
may
is
be
that?
permitted to submit the acknowledgement which I have filed in the counter for my lordship's perusal.
Huh?
I may be permitted to submit the acknowledgement which I have filed before the counter in the morning.
What is your name?
I filed wakalat also today, my lords.
Where is the wakalat?
I have filed it in the registry. I'm producing the acknowledgement, my lords.
All right. What about payment of the amount?
My lords, I may be permitted to seek for whatever possible extension. In the application, I have prayed for recalling the warrant as well as indulgence in
There is
extending.
a question of recall of warrant when he's already been arrested.
My lordships, here we have.
ತಂದು ನಿಲ್ಸಿದರೆ ನೀವು recall ಅಂತೀರಲ್ಲ.
My lords,
You filed 70 clause 2.
I read with 482, I have filed my lords because my lordships can exercise powers other that.
Huh?
My lords, here we have an exceptional situation where the revision petitioner himself could not appear before my lordships. That was my lordship's observation in that order dated 17/9/24. That he could not instruct his counsel also from the last 1 year.
Right.
My lords, considering that, 2 weeks time, if my lords, I shall make the payment of 50% before my lordships or DD or so, he can withdraw.
He is not inclined. Did you speak to your client?
I spoke to my client, my lords.
Willing to pay?
My lords, I have no other way to believe him because now whatever possible means he has, I asked him to bring today itself the DD. What he says is that he would do it.
What is
without-
his avocation?
My lords, he was running a transport business earlier. Now it is no more. He's only one son who is there. He's not there along with him. He resides in Bangalore and he is in Anekal. My lords, he has limited resources. What, as far as my instructions, he may be able to pay 50% in next 4 weeks, he said. I said, I will request my lordships, if my lordships so permit, even 2 weeks, if lordships permit, my lords, I shall request him to do the needful. Otherwise, my lordships take further action as per the. Let's say even respondent counsel, I informed the same. Let's, I requested him to
Mr. Ravindra Deshpande. What has to be done when they are brought on record after arrest, issuance of NBW? Really,
I shall file the necessary application.
how to recalls? Recall will be that once warrant is issued and you keep him present, it can be recalled when it is not executed.
Please, please.
Police have already executed. I would have sent him to JC yesterday. Considering his status, I told him to present him today and you are present yesterday. You ought to file an application for bail.
Please, please. Kindly be passed on, my lords. I shall make the necessary.
Pass over, sir, again second time.
My lords, yesterday, they might have moved they ought to have moved the end of the list. Before, they would have brought to the, my lordship's notice
Who
that
has to
he
move?
is being produced.
Who has to
yesterday.
move?
Learned counsel.
Oh. Which council?
My lords, in that case, how would my lordships would have the file on board, because yesterday they produced when matter was not
It's
posted.
for you to do. You're the accused counsel. What is this?
My lords, I was not there on record that point of time. Only.
Maybe that is for him. It is his headache.
Please, my lord.
It is
I am-
not for the court to run behind this file.
Oblige, oblige.
NBW is issued because he is not absent.
Please, my lord.
What kind of submission you are making? You're putting the blame on the office and counsel and government advocate are not concerned with the private matters.
My lords, I'm not putting any blame on anyone, my lords, but since.
He should have called his lawyer or he should have made arrangement to file an application to set him at enlarge him on bail by filing application to post the matter. If
That he
had
did not
for-
do. So
then-
because of that, my lordships did not have the file. That's true, my lord. And only in the afternoon. he
File
could-
application.
Please, my lord. I shall do the needful.
Let him file bail application. We'll consider that.
Please.
Speak to him if he's willing to pay some amount.
Not he-
Also got some medical problem. We'll grant some time.
not
If
they,
it doesn't pay.
not they seek, my lord, the 4 weeks time to deposit 50%. Let him deposit not 50% of the check amount. Then, my lord, will take.
File mart. Your
Please.
presence may not be
Please.
required.
Please.
You are held up.
I shall
Please,
do it.
please.
Great.
You have detained the police officers from yesterday behind this fellow without doing their law and order issue. What is this?
I'm sorry, my lord. I only received the instruction in the evening at 4:45, my lord. So whatever possible I could do as my duty. So
No, when I
I
tell
seek my
you,
lordship's indulgence.
when I tell you, it is not you, it is
Please,
your
madam.
client.
I understand.
And when you came to know about it yesterday, you ought to exercise your
Please.
discretion to file for the bail application, not 70 clause 2.
Please, great.
Please.
Where is Prasad? There is no representation on behalf of either side. All this matter on.
To respond in this case, your lordship. Your lordship, the matter was not settled.
Not settled.
No, your lordship, I request.
Agilva? Agidya.
No, your lordship.
Michael Matadi?
ಸೀನಿಯರ್ ಹೇಳಿದ್ದಾರೆ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ
Agide.
ಆಗಿದೆ
We have received no such intimation, your lordship. So, your lordship may kindly list this matter after 21st of October, your lordship. Senior is out of station. She'll
All
be back by.
Learned counsel for the petitioner and respondent are present. Counsel for respondent submits that there is no settlement. This matter on 22nd. Await records.
Grateful, your lordship.
ರಾಮಕೃಷ್ಣಪ್ಪ ರಾಮಯ್ಯನ ನಿಮ್ಮ ಹೆಸರು ರಾಮಕೃಷ್ಣಪ್ಪ ರಾಮಯ್ಯ
Okay, not.
Huh? Ram Krishna. So probably on 30th or 1st, I will pass the order. Some minor corrections are to be done.
Matter is very urgent, my lord.
I understand. You have already completed. List on 1st. Yes, Mr. Nimesh Renu, brother, what is your?
Umesh.
Advaita.
Umesh.
Umesh. You are Umesh. Petitioner is also Umesh.
That is also Umesh.
Yes, sir. This is, which is this matter?
408 and 409 Melody is convicted for a 2-year sentence, Melody, and fine of rupees 5,000, Melody.
ನಿಮ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಅವ್ರದ್ದಾಗಿಲ್ಲ, ನಂದಾಗಿದೆ.
ನಿಮ್ದು ಆಗಿದೆಯಾ? You have any further arguments?
Only reply is there. ಅವರು ಮಾಡಿಲ್ಲ ಅವತ್ತು, ಟೈಮ್ ತಗೊಂಡು.
Section 197 not complied is your argument.
This one not complied. Then my lord, misappropriation amount is.
You are ready in the matter?
Lord, 230.
Have you read the papers?
No.
Otherwise, don't waste time half-heartedly. Should come fully prepared. Papers idea.
Papers, either.
And you argue on Monday, why 2:30? You come prepared fully, go through the.
Monday.
After vacation. Because Monday other several matter, because 2 days is there, man. I moved several matters.
And I'll release it and you argue. Counsel for the petitioner and respondent are learned CGP are present. Huh? Final disposal at the.
ಪಾಠದಂತ ಆಗಿಲ್ಲ.
Pathadaagilla.
It was final disposal by the honorable judge.
Earlier.
Racha. Earlier I argued.
Earlier bench.
Justice Racha, my lord.
Final hearing ಆಗ್ಬೇಕಾಗಿತ್ತು.
Hearing
Final
disposal
disposal
ಅಂತ.
Counsel for the petitioner and learned CGP are present. Learned CGP seeks time. Let's call this matter on. You have to see on 197.
Yes.
Pass over. ಏನದು offense? This is that Maruti. Pretty fail, ಕೊಡಿ. You were supposed to find out.
Madam. Maruti van is released, my lord. Name of applicant, who is the owner of the Maruti van.
Yes, madam, you're in this case? Ask her if she's in this case. This lady?
No.
Not in this case.
Amicus curiae Javid was appearing for.
Then what remains?
So already released me. Nothing is,
You have a copy of this?
no, I
Pretty much. Read it.
will make one Xerox and
Read it.
but, third paragraph. ಸದರಿ ಸ್ವತ್ತುಗಳು ಅರಣ್ಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಸ್ವತ್ತುಗಳಾಗಿರುವುದರಿಂದ ಪೊಲೀಸ್ ಇಲಾಖೆಯಿಂದ ಅರಣ್ಯ ಇಲಾಖೆಗೆ ಹಸ್ತಾಂತರವಾಗಿರುತ್ತದೆ. ವಾಹನ ಮಾಲೀಕರು ಮಾನ್ಯ ಜಿಲ್ಲಾ ಸೆಷನ್ ನ್ಯಾಯಾಲಯ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ನಂಬರ್ 250/2006 ಪ್ರಕಾರ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿ ಬಿಡುಗಡೆಗೆ ಮಧ್ಯಂತರ ಆದೇಶದಂತೆ ಉಲ್ಲೇಖ 1ರ ದಿನಾಂಕ 1/9/2006 ಉಪ ಅರಣ್ಯ ಅಧಿಕಾರಿಯವರ ಆದೇಶದಂತೆ KA 19 MC 0786 ಮಾರುತಿ ಓಮ್ನಿಯನ್ನು ವಾಹನ ಮಾಲೀಕರಾದ ಸಫಿಯಾ ಮೊಹಮ್ಮದ್ ಸಲೀಂ ಮಿತ್ತೂರು ಇಟ್ಕೋದು ಗ್ರಾಮ ಭಟ್ಕಳ ತಾಲೂಕು ಇವರಿಗೆ ಬೇಲ್ ಬಾಂಡ್ ಮೇಲೆ ದಿನಾಂಕ 5/9/2006 ಬಿಡುಗಡೆ ಮಾಡಲಾಗಿರುವುದು ದಾಖಲೆಗಳಿಂದ ಕಂಡುಬರುತ್ತದೆ.
5/9/2006.
ಎಸ್ ಮೈ ಲಾರ್ಡ್, 5/9/2006 ಅದು ಅವತ್ತೇ ರಿಲೀಸ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
Then why they have gone and filed appeal in 2010?
Thereafter, my lord, next para ಅಕ್ರಮವಾಗಿ ಅರಣ್ಯದ ಉತ್ಪನ್ನವಾದ ಸೊ ಸಾಗಾಟ ಪ್ರಕರಣವು ಸಾಬೀತು ಆಗಿರುವುದರಿಂದ ಉಪ ಅರಣ್ಯ ಸಂರಕ್ಷಣಾಧಿಕಾರಿ ಮಂಗಳೂರು ಇವರ ಆದೇಶ ದಿನಾಂಕ 21/9/2010 ಆದೇಶದಲ್ಲಿ ಸದರಿ ಮಧ್ಯಂತರ ಬಿಡುಗಡೆಗೊಳಿಸಲಾದ KA 19 MC 786 ಮಾರುತಿ ಓಮ್ನಿಯನ್ನು ಮತ್ತು ಇತರೆ ಸ್ವತ್ತುಗಳನ್ನು ಸರ್ಕಾರದ ಪರ ಮುಟ್ಟುಗೋಲು ಪಡಿಸಿಕೊಳ್ಳಲು ಆದೇಶವಾಗಿರುತ್ತದೆ. ಸ್ವಾಧೀನಪಡಿಸುವ ವಿಚಾರದಲ್ಲಿ ಸದರಿ ಆದೇಶದ ವಿರುದ್ಧ ಫಿರ್ಯಾದುದಾರರು ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಕ್ರಿಮಿನಲ್ ರಿವಿಷನ್ ಪಿಟಿಷನ್ 20/2016 ದಿನಾಂಕ 8/3/2016 ಆದೇಶದಂತೆ ವಾಹನವನ್ನು ಮುಟ್ಟುಗೋಲು ಪಡಿಸಲು ತಡೆಯಾಜ್ಞೆಯನ್ನು ತಂದಿರುತ್ತಾರೆ. ಹಾಗೂ ಈ ದಿನಾಂಕದವರೆಗೆ ವಾಹನ ಮಾಲೀಕರು ಸದರಿ ವಾಹನವನ್ನು ಸರ್ಕಾರದ ಪರ ಬಿಟ್ಟು ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. That means it is in the position of applicant, owner of the vehicle ಎಂಬ ಮಾಹಿತಿಯನ್ನು ತಮ್ಮ ಅವಗಣನೆಗೆ ಸಲ್ಲಿಸಲಾಗಿದೆ. It is in the position of owner. ಮಾರುತಿ
One submission, my lords.
What is this order? I don't understand. There was a confiscation of that vehicle.
Yes.
After that, appeal is filed by the.
Stay is there, my lord. Stay is there. ತಡೆಯಾಜ್ಞೆಯನ್ನು ತಂದಿರುತ್ತಾರೆ.
ಯಾವುದಕ್ಕೆ ತಡೆಯಾಜ್ಞೆ?
ಇದು
Stay of what?
The confiscating the order or government, confiscating this
by which court?
In this revision petition.
Order of that confiscation was challenged in the appeal.
Yes.
First criminal appeal before the appellate court.
So as per this order, he issued.
Appellate court, he has challenged that. That came to be dismissed. You are aware?
No, my lords, one submission, Mr. Javed is held up elsewhere. He seeks for a passover. my lord.
No, see, appellate court has dismissed the petition appeal filed by the owner of the vehicle wherein that release was not ordered and confiscation was made.
Yes,
That confiscation came to be confirmed.
yes,
Means the confiscation with the authority remains. Correct?
yes.
Then how it will go back to the party? The release, what you said, is of the year 2006, whether it was taken back again.
My lord,
And
that,
this court, after filing the petition, revision petition grants stay of appellate court order.
yes, yes.
What's the purpose of stay when already the vehicle is not released? That is, does not inure to the benefit unless thereafter she has taken it.
But as per
Stay
this,
of that order is granted.
Yes.
Means whatever confiscation order sustained by the appellate court,
yes,
dismissed by the appellate court is stayed.
stay is that.
Stay means it does not come back to the petitioner
Yes,
because he was seeking for the vehicle to be released.
yes, my lord.
So the vehicle is still, as per this, should be with the authorities.
Authority,
Now you are saying the authorities has released,
yes.
then nothing
But
will
as-
survive in this petition.
No, in the year 2016 itself,
16 or 6?
16, my lord. 5/9/2016,
Six and
ಬಿಡುಗಡೆ ಮಾಡಲಾಗಿದೆ.
you said 6 earlier.
Earlier, my lord, 16, 6, 2006,
Mister, 5/9/2016.
not 2006, my lord.
6 or 16 now.
6, my lord. ನೋಡಿ. ದಿನಾಂಕ 5/9/2006 ಬಿಡುಗಡೆ ಮಾಡಲಾಗಿರುವುದು ದಾಖಲೆಗಳಿಂದ ಕಂಡು ಬರುತ್ತದೆ. ಹೌದು sir.
16 ಅಲ್ಲಲ್ಲ.
ಅಲ್ಲ ಅಲ್ಲ 2006.
Sir, I think in a good mood for humor. You didn't understand what I said. ಹೇಳಿ ಮೇಡಮ್ ಅವ್ರಿಗೆ ನಾವು ಏನ್ ಹೇಳಿದ್ವಿ ಅಂತ. ಈಸ್ ನಾಟ್ ಇವನ್ ಸ್ಮೈಲಿಂಗ್. ಗುಡ್ ಹ್ಯೂಮರ್ ಅಲ್ಲಿ ಇದ್ದೀರೇನು ಜೋಕ್ ಮಾಡಕ್ಕೆ?
ಅಲ್ಲ ಅಲ್ಲ ಬೈ ಮಿಸ್ಟೇಕ್ ಬೈ ನಾಟ್
16 ಅಲ್ಲ ಅದು 6 ನೀವು
6
ಆದ್ಮೇಲೆ ಅಪೀಲ್ ಇರೋದು 2010.
ಹೌದು.
So even if it was released, then maybe she has not informed to the counsel who has filed the appeal. What I told you last time is to find out whether the vehicle is still with the party.
Yes.
And that lady is not contacting, that's why the amicus curiae is appearing. Owner of the vehicle.
So as per the order 2006, the vehicle was with the owner. But thereafter revision petition appeal filed. So confiscated order is there. I will confirm, my lord. Now, the vehicle in whose position, I will confirm.
Scrap ಆಗಿರ್ಬೇಕು ಇವಾಗ.
I will take it.
What is
He said he's held up 2:30 ತಗೊಳ್ಳಿ ಅಂತ.
2:30? This has to be closed, that's all. I don't,
Yes.
it's a waste of time of the court.
ಕೊಟ್ಟಿದ್ದಾರೆ ಮತ್ತೆ ಇದು ರಿವಿಷನ್ ಕಾನ್ಫಿಸ್ಕೇಟ್ ಆಗಿದೆ.
Return the vehicle.
ಅದೇ
ಆರ್ಡರ್ ಪ್ರಕಾರ ಇದೆ. Thereafter
vehicle return ಆಗಿ she must have enjoyed a vehicle, she must have sold the vehicle in 2006. Vakil is probably going on with the case.
maybe
After the appeal being dismissed, he has filed revision. She must have signed, I don't know how. Because as on filing, date of filing the appeal
yes.
itself, about the vehicle was released. Because appeal is itself of the year 2010.
2016.
Revision is of the year 16.
But at that time, they filed the application for release, my lord. They were dismissed. They filed the appeal on that application, my lord. On the basis of that application, vehicle is released, my lord. But that is.
Confiscate ಆಗಿದೆ.
That is.
2:30. Let us see what information Mr. Javed has. Madam, 2:30 ಆಗಿದೆ.
Lords, one submission, my lords. Serial number 112, my lords.
1-1?
2. Trial.
Ah.
PCR await ಅಂತಿದೆ.
Await records.
Maybe a date may be given.
Await records after vacation date will be given.
Lordship on submission.
Obliged.
Serial number 989 of 2021. Parted ಅಂತ ಆಗ್ಲಿ ಸ್ವಾಮಿ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಪಾರ್ಟೆಡ್ ಅಂತ ಆಗ್ಲಿ ಅರ್ನ್ ಮಾಡಿದ್ವಿ ಇಯರ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ ಅದು 21/10 ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಪಾರ್ಟೆಡ್ ಅಂತ ಆದ್ರೆ ನಿಮ್ಮ ಮುಂದೆನೆ ಮಾಡ್ತೀವಿ ಸ್ವಾಮಿ.
ಇಲ್ಲ ಅದು ರಿಲೀಸ್ ಆಯ್ತಲ್ಲ ಮೇಡಮ್, ಪಾರ್ಟ್ ಹರ್ಡ್ ಆಗಿಲ್ಲ.
ಇಲ್ಲ
ಪಾರ್ಟ್ ಹರ್ಡ್ ಆಗಿಲ್ಲ. ಪಾರ್ಟ್ ಹರ್ಡ್ ನೀವು ಪಾರ್ಟ್ಲಿ ಹರ್ಡ್, ಬಟ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಪಾರ್ಟ್ ಹರ್ಡ್ ಇನ್ ದ ರೆಕಾರ್ಡ್.
ಪಾರ್ಟೆಡ್
I am not interested if you don't want to argue. Yes.
116, 116.
116.
Required or argued. Dhananjay Kumar and myself.
Which is this matter?
That is pertaining to the will, my lord. Divergent finding.
Oh, this is our second appeal.
Husband and wife both executed
I
will.
have not yet prepared the,
Very well,
and give a date maybe on that day.
very well.
Heard further learned counsel for the appellant and respondent. You need not wait.
Please. Great.
Sorry, Mr. Muley. Sorry, I was unable to.
No worries.
Yes.
104 minutes, serial number.
Yes, sir. Really, sir.
Next week, madam.
Okay. Appearing for the petitioner.
Please, madam.
Petitioner, call this matter on.
Appearing for the respondent, my lords. Amount deposit may be released, my lords. 2,50,000 has been deposited.
ಮಾಡಿದಾರಾ?
ಮಾಡಿದ್ದಾರೆ sir.
20% ಮಾಡಿ.
Honorable court has ordered for 50%, my lordship.
He's
They
got a
have
marriage
deposited.
fixed next week. Marriage ಆದ ಕೂಡಲೇ ಮಾಡು. Because ಮಗಳು ಮದುವೆ ಮಾಡು.
ಬ್ಯಾಲೆನ್ಸ್ ಅಮೌಂಟ್ ಕೊಟ್ಟಿಲ್ವಾ? ಕೊಟ್ಟಿಲ್ವಾ ಬ್ಯಾಲೆನ್ಸ್ ಅಮೌಂಟ್?
ಇನ್ನು 30% ಮಾಡ್ಬೇಕು.
3,75,000.
Time is there or over?
ಆಗಿದೆ. No, time is over, my lords.
ಮಗಳು ಮದುವೆ ಇದೆ.
And he has to execute the order.
ಅಲ್ಲ ಕೇಳ್ತಾ ಇದೀವಿ, ಮಗಳು ಮದುವೆ ಇದೆ, ಮುಗಿದ ಕೂಡಲೇ ಮಾಡ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ವೀಕಲ್ಲಿ ಇದೆ.
Counsel for petitioner is present, so also counsel for respondent. 104
minutes.
Let me just pass that order for withdrawal. Counsel for, you have made application or oral?
Oral submission.
Oral request for withdrawal. Amount deposited shall be permitted to be withdrawn, subject to outcome of this petition in case of petitioner succeeds. Balance amount ಮಾಡ್ರಿ.
ಮದುವೆ ಮುಗಿದ ಕೂಡಲೇ
ಮದುವೆ ಅಂತ ಇಟ್ಕೊಂಡು you'll execute the order at the time of marriage. What you will do?
ಕೇಳ್ತಾ ಇದೀವಿ. ಮದುವೆ ಇರೋದ್ರಿಂದ ಅವನಿಗೆ ಆಗ್ತಾ ಇಲ್ಲ.
It's your choice and your risk.
Court officer. Court officer. Court officer.
ಸರ್ ಒಂದ್ ನಿಮಿಷ ವೇಟ್ ಮಾಡಿ ಸರ್.
ಮೇಡಮ್ 104 ಯಾವತ್ತು?
ನಮ್ಮ 22ನೇ ತಾರೀಕು ಸರ್. 22nd 23rd. ಹೇಳಿ ಸರ್.
Serial number 60, madam.
ಇದೆಲ್ಲ ಸಂಜೆಗೆ ನೋಡಿದ್ರೆ ಅಪ್ಲೋಡ್ ಆಗಿರುತ್ತೆ ಸರ್, ನೋಡ್ಕೊಂಡ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ.
Serial number 60.
24/10.
Okay, thank you, madam. Thank you.
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ಗೆ ಹಾಕಿ.
ನಮ್ಮ 83 ಯಾರು ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ? 15.
Harvard bench matter, serial number 1.
Your Lordship, for respondent, Your Lordship.
Yes, madam.
Please, Your Lordship.
What happened? Where is the petitioner?
Your Lordship, as earlier submitted, Your Lordship, 397.3 under provision 397.3, Your Lordship. They have filed a revision petition. This is the second revision petition which they have filed, Your Lordship.
Here.
So maintainability is not at all maintainable. As they have earlier submitted, Your Lordship, they wanted to file review, but revision is, again, they have filed a revision.
Oh, in the revision, what is filed, they are seeking a review. This is the
Please,
matter in which that Amar Korea was appearing.
Some
yes.
another counsel earlier, Your Lordship, he's from Bangalore only, he appears, Your Lordship, as that matter is referred from legal service, ಹೇಳಿದ್ರು.
Correct. So this becomes second revision. Is now nomenclatured it as a review. I don't know how that is also maintainable. Going on from past 3 weeks. The petitioner, Vishwanath.
Vishwanath Vichgati from Dharwad, Your Lordship. As they are seeking set off.
Correct, I have dismissed this matter on merits. He is trying to now re-argue the whole case on the ground of set off.
Please, Your Lordship. As in appellate court, Your Lordship, set off is granted, but however, they have again filed a revision petition before this honorable court.
Correct. There is no representation on behalf of petitioner. The matter is called at 2:49 PM. All this matter. On 21st, madam.
Please, Your Lordship.
21st October.
Please, Your Lordship.
One more Italam. Oh, that is hearing. What is that? Wait. Yes, Mr. Mrutyunjay.
Please be. Please be.
I am for privateer.
Lord, Lords, pass an order. My lords, pass an order. As per Annex 18. As per Annex 18. In respect of election. Lord, in respect of elections who will federation.
Yes, 13(2)(a) was ordered to be followed.
Yes.
Yes, what happened? Why are you here again?
Members are concerned.
Sorry? What is it?
But the members are concerned. The society is registered for the first time. Society is registered for the first time. Whether will be followed or 13 be followed or.
Mr. Counsel.
I had filed a writ appeal before this honorable court. May I request page 117, Lord. Page
Sir,
117.
one of you argue, what is that?
Lord,
One of you
Lord,
argue and you see that you are.
I'll just. Lord, since my senior Lord, DL finding along with me,
You must have logged in two.
we'll close one system, Lord.
Why this is listed?
May I request, my Lord, kindly see, my Lord, page.
Why this matter is coming up before me? What is this? What is the order sheet? First matter. Why it is posted before me? Mr. Mrityunjay. Yes, why this matter is posted before me when I have already disposed of the matter earlier? And you are now seeking.
Lord, I had filed a writ appeal before this. My Lord, may I request, my Lord, page 117, my Lord. Court, my Lord, division bench directed me, my Lord, seek review of the order by filing a separate petition, my Lord, by virtue of the orders passed by the Honorable Supreme Court in Shivdev Singh's case. Page 117, my Lord.
Yes.
My Lord, para 3. My Lord, the division bench, my Lord, extracts the orders they were seeking. My Lord, the Shivdev Singh's AR 1960 Supreme Court 190.
Who's appearing? Bethurmant, KL Patil?
Yes. I am for Kevin. I take notice for Kevin.
You'll take notice in this matter?
For Kevators, I will take notice.
Yes, what do you
Respond
say?
number 7, I have filed Kevat.
Yeah, what has happened now?
Election has not yet taken place. It is in the process.
Berkoli. Learned counsel for the petitioner, Sri Mrityunjay Tata Bangi is present. along with learned counsel Sri K.L. Patil for caveator, respondent number 7. Learned AG is directed to take notice. Who appears? Madam, you will take notice?
Please, Your Lordship, I will take.
HCGP or AG?
HCGP, please. Your Lordship.
HCGP.
AG, the respond number 1.
1, 2, 1. You only take notice for 1.
Please, only 1, Your
Registrar
Lordship.
of-
Others are election authorities.
Madam, your registrar cooperative society, you should be representing. That is a agency.
Register, respond number 4 also.
Milord, 134.
1, not
3
4.
were all-
4 is returning officer. 1, 4, not. Again, the election officer who appears.
Bharam Gowda.
134. Who appears for the cooperative society returning officer? Who appears for cooperative societies?
Bharam Gowda, Your Lordship.
Bharam Gowda.
Learned HCGP for 1, 3 and 4. Learned counsel Sri Bharma Gowda for 2, 4, 5. Notice to respondent number 6 and 8 to 11.
Mayor.
For
8 to
7, Mr.
11, Milord, are the petitioners. 8 to allow the Milord notice. I am permitted to serve senior. Those are the original petitioners.
I'm sorry, I'm not able to hear you.
Issue. Milord, respondents 7, 8, 9, 10 and 11 are the original writ petitioners. Only 7 has lodged the caveat. Milord, along with the notice, Milord, I am permitted to serve for our.
Along with the notice ordered, counsel for petitioners permitted to take out notice on the counsel. For respondent, which number? 6, 8 to 11. Follow on.
Milord, may I request in the first week after vacation?
Yes, we'll have it on 16.
Please.
Hmm? 16. Madakala.
Grateful.
You have to rectify your system, not audible.
Yes.
I'm appearing for petitioner, my lord. Page number 32, my lord.
There are 3 objections which you have to rectify. In code prayer, what is the other one? Age, minor objections are there, Marty. What is this offense?
My lord, 138 checkpoints case, my lord.
You are seeking for suspension.
Yes, my lord, the punishable 4 lakh to 5,000 total
Correction,
amount.
Marty, I will take it up.
Martis pass.
There are some objections rectified, minor.
Password.
Pin code and prayer and all. Pass
Pass
over. Counsel for petition permitted to rectify the objections. Pass over.
Petition in this case, Your Lordship, appellant. This is 138 proceedings, Your Lordship. 138 proceedings. The check amount is 36 lakhs, Your Lordship. In this case, the petitioner was a landlord and the complainant was the tenant. They entered into rent agreement, Your Lordship. The petitioner accused was constructing an apartment.
Or heard learned counsel for the petition. issue notice to respondent on main and IA. On main, IA number 2. It's filed seeking dispensation of certified copy of the impugned order. Same is dispensed for the time being, 4 weeks time granted to file the certified copy. Orders on IA number 2, 1. Order of sentence dated 18/7/23 in CC 53235 of 22. Passed by 14th Additional Chief Metropolitan Magistrate, Mayor Hall Unit, Bengaluru. Confirmed in Criminal Appeal 25221 of 23, dated 3/9/24. Passed by 74th Additional City Civil and Sessions Judge, Mayor Hall Unit, Bengaluru's hereby suspended. Petitioner shall be enlarged on bail subject to the following conditions. Petitioner shall deposit 50% of the fine amount inclusive of any amount already deposited.
Beg your lordship for check amount.
What is the check amount?
Check amount is 36 lakhs, your lordship. Fine amount is 41 lakhs.
Okay, check amount. Inclusive of any amount already deposited within 4 weeks. Today. Petitioner shall execute personal bond for 1 lakh like sum surety to the satisfaction of trial court. It is made clear if the amount is not deposited as ordered within the set time period, respondent would be at liberty to execute the order.
Much of that. Hearing for petition. Sorry, not sir, morning.
This is that Maruti van.
Please, please, Milords.
So he says that whether you have any instructions.
No, Milords. Milords, as per the order, Milords, it was subsequently confiscated by the said authorities, Milord.
Again.
Please, Milord, in
For
the,
the
by the
seconds.
order dated 24/9/2010, Milords. 24/9/2010, Milords.
24?
24/9/2010. The order was passed by the Adhikrita Adhikari Hagu Upa Aranya Samrakshanagalu Mangaluru Vibhaga Ivara Nyayalaya Mangaluru. By his order dated, it has been confiscated. One Maruti
Again confiscated.
in 2010, Milords, 24/9/2010. The same order was challenged by the petitioner hearing in the criminal appeal
163.
163.
Correct. That came to be dismissed.
That come to be dismissed, Milords, by confirming the same order. Confiscation order confirmed and my appeal was dismissed. On that appeal, I am before this honorable court with
Correct,
this
but
revision
what's the
petition.
point of this court granting you
It
a
was granted in the,
stay?
yes, my lord, 8/3/2016.
What's the reason of this court granting you stay?
Interim order, not to directing to the release of the vehicle, Milords. Interim order state, the earlier order confiscation order, Milord. But already they have taken the vehicle, Milords.
No, impugned order, what you challenged was the order of the appellate court.
Appellate court,
That order stay, you don't get any benefit.
no benefit, Milords. Actually, the competent authority, deputy conservator forest officer,
That should have been stayed.
that order has to be.
Then you would have got back the vehicle.
Please, Milords.
So now
This appeal order
the order that is granted in 2016 by this court
is of no use.
of no use.
No use, Milords.
But you did not even bring it to the court's notice that you don't have the vehicle, petitioner.
Please, Milords.
The further proceedings stay agide. For this honorable.
Huh?
Further proceedings was stayed by this honorable court.
What further proceedings?
Interim application, Milords. It is on.
Appellate court orders.
Entire proceeding is only for release of vehicle, sir,
Yes.
not for the main prosecution of
It is
the.
order
Office
challenge under
of
the
Vehicles.
interim application.
This lady who's the owner of Maruti Omni van
Please.
filed an application for release of vehicle under 451, 457.
Yes.
Under Forest Act, my lords.
No, that is the offense is Forest Act, but the
Please, ma'am.
application is filed under what? For release of that vehicle.
Release of vehicle, my
Okay.
lords.
You are unable to contact this
No, my
person.
lords.
So this is the letter given, latest letter, my lord.
ಅದು ಕೊಡಿ ಅವ್ರಿಗೆ. Just read that.
They
letter.
given 18/9/2024 only they given.
Please give it to him. Read, understand that what it says. This talks about the confiscation and release of vehicle in 2006. Please read it. Even it's in
Please, ma'am.
Kannada. For my benefit also read it once again.
ಖಾತ್ರಿ ಸ್ವತ್ತುಗಳನ್ನು ಅರಣ್ಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸ್ವತ್ತುಗಳಾಗಿರುತ್ತದೆ. ಪೊಲೀಸರು ಇಲಾಖೆಯಿಂದ ಅರಣ್ಯ ಇಲಾಖೆಗೆ ಹಸ್ತಾಂತರವಾಗಿ ಇರುತ್ತದೆ. ವಾಹನ ಮಾಲೀಕರು ಮಾನ್ಯ ಜಿಲ್ಲಾ ನ್ಯಾಷನಲ್ ನ್ಯಾಯಾಲಯ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ನಂಬರ್ 250/2006 ಪ್ರಕಾರ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿ ಬಿಡುಗಡೆಗೆ ಮಧ್ಯಂತರ ಆದೇಶದಂತೆ ಉಲ್ಲೇಖ 1 ದಿನಾಂಕ ಸೋರಂದು ಉಪ ಅರಣ್ಯ ಸಂರಕ್ಷಕರ ಆದೇಶದಂತೆ KA 1976 ಮಾರುತಿ ಒಮಿನಿ ವಾಹನ ಮಾಲೀಕರಾದ ಸಫೀನಾ ಮೊಹಮ್ಮದ್ ಸಲೀಂ ಮಿತ್ತೂರು ಇಟ್ಟುವ ಗ್ರಾಮ ಒಂಟಾಲ ತಾಲೂಕು ಇವರಿಗೆ ಬೇಲ್ ಬಾಂಡ್ ಮೇಲೆ ದಿನಾಂಕ ಸೋರಂದು ಬಿಡುಗಡೆ ಮಾಡಲಾಗಿರುವುದು ದಾಖಲೆಗಳಿಂದ ಕಂಡು ಬರುತ್ತದೆ. ಅಕ್ರಮವಾಗಿ ಅರಣ್ಯ ಉದ್ಯಾನವನ ಹಲ್ಲಟ್ಟಿ ಸಾಗಾಣಿಕೆ ಪ್ರಕರಣ ಸಾಬೀತು ಆಗಿರುವಂತಹ ಉಪ ಅರಣ್ಯ ಸಂರಕ್ಷಣಾಧಿಕಾರಿ ಮಂಗಳೂರು ಇವರ ಆದೇಶ ದಿನಾಂಕ 21/9/2010 ಆದೇಶದಲ್ಲಿ ಸದರಿ ಮಧ್ಯಂತರ ಬಿಡುಗಡೆ ಗೊಳಿಸುವಾಗ KA 19 MC 786 ಮಾರುತಿ ಒಮಿನಿ ಮತ್ತು ಇತರೆ ಸ್ವತ್ತುಗಳನ್ನು ಸರ್ಕಾರದ ಪರ ಮುಟ್ಟುಗೋಲು ಪಡಿಸಿಕೊಳ್ಳಲು ಆದೇಶಿರುತ್ತದೆ. ಸ್ವಾಧೀನಪಡಿಸುವ ವಿಚಾರದಲ್ಲಿ ಸದರಿ ಆದೇಶ ವಿರುದ್ಧ ಫಿರ್ಯಾದಿದಾರರು ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿ ರಾಜ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಕ್ರಿಮಿನಲ್ RP ನಂಬರ್ 20/2006 ದಿನಾಂಕ 8/3/2010 ಆದೇಶದಂತೆ ವಾಹನದ ಮುಟ್ಟುಗೋಲನ್ನು ಪಡಿಸಲು ತಡೆಯಾಜ್ಞೆ ತಂದಿರುತ್ತಾರೆ ಹಾಗೂ ಈ ದಿನಾಂಕದಂದರೆ ವಾಹನ ಮಾಲೀಕರು ಸದರಿ ವಾಹನವನ್ನು ಸರ್ಕಾರದ ಪರ ಬಿಡುಗೊಡಿರುವುದಿಲ್ಲ ಎಂದು ಮಾಹಿತಿಯನ್ನು ತಮ್ಮ ಅವಗಾಹನೆಗೆ ಸಲ್ಲಿಸಿರುತ್ತದೆ.
What did you understand by that?
The vehicle is not released in favor of petitioner.
ಮತ್ತೆ ಇವ್ರು ರಿಲೀಸ್ ಆಗಿದೆ ಅಂತೀರಾ?
2006 ಅಲ್ಲಿ ರಿಲೀಸ್ ಆಗಿರೋದು.
Right, ಅದರಾದ್ಮೇಲೆ after 2006.
2010 order dated, it has confiscated, my lord.
Again in 2010, 24/9/2010, it is confiscated once again. After that, whether it is released is the question. Please tell that person to find out. I don't know, your authorities are unable to understand the court order. Have you understood?
Yes, ma'am.
2006 release ಆಗಿರೋದು ಆದ್ಮೇಲೆ 2010 ಅಲ್ಲಿ again they have confiscated.
Yes.
That order is challenged by way of appeal. Now one more appeal number is mentioned there.
Confirm.
Please,
250. That is not available in my records.
it is available, my lords. It is very
State
much
court is
available.
confirmed the
What
order.
is that appeal?
It is very much available, my lords.
Where?
Order of
That is order passed by the session court, my lords, on 22 August 2006, my lord. Criminal appeal number 250/2006. 22 August 2006.
ಎಲ್ಲಿದೆ ಅದು? Page number?
78, my lords. It is Xerox copy, my lords.
70?
78, my lords.
78.
Paper book or
Paper book ಇದೆಯಾ?
in records.
47 is the last page I have.
Here I have given all the annexures, my lord, all the lower court records.
Pudimadu. So after this 2006 order, they have released the vehicle
After
In-
that, my lords,
in September 2006
please, my lords,
pursuant to this order,
please, my lords.
but again confiscated.
Confiscated by the order dated 24/9/2010, my lords,
Ah,
which is by the conservator forest, my lords,
ah,
authorized person.
all right,
This order came to be challenged in criminal appeal 163, my lords.
correct. And you have got a stay.
No, criminal appeal before the session court, my lord, first appellate
That
court.
is dismissed.
That is dismissed, confirming the earlier 24/9/2010 order, my lords.
Confiscation is confirmed.
Confirm, my lord. Upon that order, I am before this honorable court. Here, this honorable court has granted stay only to the criminal appeal of 163, my lords, first appellate order, not the order passed by the competent conservator officer.
We don't know whether that, that is what I'm telling you now. Find out from the officer, post the criminal appeal, which came to be dismissed.
Yes.
Prior to that, when they confiscated on 24/9/2010,
Yes.
whether the vehicle came to be released again in favor of the petitioner.
Yes.
Because by the stay granted by this court, I don't know how it is going to benefit.
Not benefited.
Doesn't make any sense. You find out. Is this matter?
Sir.
It's not what heard. This matter in the second. Is it on 16th, 15th, 16th?
Please, need it.
ಅರ್ಥ ಆಯ್ತೇನು ಮಿಸ್ಟರ್ ಲಕ್ಷ್ಮಣ್?
ಗೊತ್ತಾಯ್ತು.
So if that is now gone back to
Yes.
the petitioner and stay is ordered, maybe we can dispose it off by that statement that now the petitioner has taken back the vehicle. It will not
I
survive.
have to find out.
This application will not survive. Because what the petitioner is aggrieved is that the vehicle was not given to her by virtue of that order of trial court.
Yes. That I will find out.
Call on. Date.
Obligations.
I am for the respondent complaint in this case.
Sir.
79.
Naya.
NI Act 138. In this case, my lord, the complainant that
TCR,
there is
madam, what is this defective TCR? Correct records ಬಂದಿಲ್ವಾ? Yes, madam, your
ಯುಎಸ್ಸಿ ಕೊಟ್ಟಿದ್ದಾರೆ ನಮ್ಗೆ ನಾನು ನೆಕ್ಸ್ಟ್ ಡೇ ವಕಾಲತ್ ಮಾಡಿಸ್ತೀನಿ ಒಂದು ಡೇ ದಯವಿಟ್ಟು ನಿನ್ನೆ ಸಾಯಂಕಾಲ ಕೊಟ್ಟಿದ್ದಾರೆ.
that matter. This is that exhibit D2 not forthcoming.
not put. 7 is most important because they have denied the transaction between the complainant and the respondent, that is the respondent and petitioner. But respondent number, document, that is exhibit P7 is most important. There was a pre-conciliation proceedings in that there was they have admitted. Subsequently, when I filed this petition, that petitioner herein has denied the transactions.
All right, now she wants to engage another counsel. Grant her time. The party, the petitioner,
This is a 2009, she has received 1,50,000 from that respondent is also present.
ಏನಮ್ಮ ನಿಮ್ಮ ಹೆಸರೇನು? ಶ್ರೀಮತಿ ವಸಂತ ಲಕ್ಷ್ಮಮ್ಮ is present.
ಮಾತಾಡ್ಬೋದಾ ಸರ್?
ಇಲ್ಲಮ್ಮ, ನೀವು ವಕೀಲರು ಇಟ್ಕೊಂಡ್ರೆ
ಇರ್ಲಿ.
ಇಡಾಗಿದ್ರೆ ನೀವೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಾಗಿದ್ರೆ ಮಾಡ್ಬೋದು.
ಈ ವಿಷಯನೇ ಗೊತ್ತಿರ್ಲಿಲ್ಲ ಸರ್, ಬಂದಿದ್ದೆ ಮೊನ್ನೆ ದಿವಸ ನನ್ಗೆ ಈ ವಿಷಯ ಗೊತ್ತಾಗಿದ್ದು. ಕೋರ್ಟ್ಗೆ ಇದ್ ಮಾಡಿರೋದೇ ಗೊತ್ತಿಲ್ಲ ನನ್ಗೆ.
ಅಲ್ಲ, ನಾವು ಮಾಡಿಲ್ಲ, ದಟ್ ಈಸ್ ದೇ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಆಕ್ಚುಲಿ.
ಕೇಸ್ ಹಾಕಿರೋದು ನಿಮಗೆ ಗೊತ್ತಿಲ್ವಾ?
ಕೇಸ್ ಹಾಕಿದ್ದು ನಮ್ಮ ಹಸ್ಬೆಂಡ್ ಇದ್ ಮಾಡಿದ್ದು ಸರ್, ನನ್ಗೆ ಏನು ಗೊತ್ತಿರ್ಲಿಲ್ಲ. ಅವ್ರು ನನ್ ಚೆಕ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ರು. ನಾನ್ ಗೌರ್ಮೆಂಟ್ ಆಫ್ PWD ವರ್ಕ್ ಮಾಡೋದು. ಬಟ್ ಅದು ನನಗೆ ಆಮೇಲೆ ಗೊತ್ತಾಗಿತ್ತು ಸರ್. ನನ್ಗೆ ಆಮೇಲೆ ಗೊತ್ತಾಗಿ ನಾವು ಸ್ಟಾಪ್ ಮಾಡಿದ್ರು. ಅದು ಇವಾಗ ಗೊತ್ತಾಯ್ತು ಸರ್ ನನ್ಗೆ ಅದು. ಅದರಿಂದ ನನ್ಗೆ ಈಗ ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ವಕೀಲರು.
ಆಯ್ತು, ನೀವು ವಕೀಲರು ಇರ್ತೀರಲ್ಲಮ್ಮ, ಲೆಟ್ ಹಿಮ್ ಕಮ್ ಅಂಡ್ ಆರ್ಗ್ಯೂ. ನಿಮಗೆ ಇದೇ ಮುಂಚೆ ಗೊತ್ತಿರ್ಲಿಲ್ವಾ ಕೇಸ್ ಬಗ್ಗೆ?
ಕೇಸ್ ಗೊತ್ತಿತ್ತು ಸರ್, ಅವಾಗ ನಮ್ಮ ಹಸ್ಬೆಂಡ್ ಸತ್ತೋಗ್ಬಿಟ್ರು. ನಮ್ಮ
ಮೇಡಮ್,
ಹಸ್ಬೆಂಡ್
ನೀವು ಎವಿಡೆನ್ಸ್ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲಮ್ಮ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 2006
ಆಮೇಲೆ ಅದು ಸ್ಟಾಪ್ ಆಗಿದ್ದು ಗೊತ್ತೇ ಇಲ್ಲ ಸರ್ ನನ್ಗೆ ಆಮೇಲೆ.
ಆಲ್ ರೈಟ್, ಐ ವಿಲ್ ಗ್ರಾಂಟ್ ಯು 2 weeks, 2 ವಾರ ಕೊಡ್ತೀವಿ ಟೈಮ್. Is present before the court physically, seeks time to engage another counsel. Accepting her request. Matter is listed, this matter on 21st October to facilitate the petitioner to engage another counsel. Learned counsel for respondent along with the respondent are present. He has deposited any amount?
No. Actually, we have paid the amount, but she has not paid anything. Even about 1 week back, she has called respondent stating that we are ready to pay 1 lakh.
All right. You come on 21st. Lawyer karkamanima.
For the review petition,
Pass out.
So I may be permitted to file a bail petition for the revision petition.
Bail petition.
Please, ma'am. Copy has been served on the other side, my lords. Revision petitioner is ready to comply with any conditions that my lords may use.
Barcode. Learned counsel. What is your name, Mr. Counsel?
Vinayak Kulkarni, my lords.
Where's your wakalat?
Wakalat is filed in the counter, my lords. Acknowledgement I have filed before my lordships in the morning. My lords, here is a
Learned
copy of-
counsel Sri Vinayak Kulkarni has filed wakalat after obtaining NOC from the previous counsel. Registry to show his name in the cost list. Register ಆಗಿದೆಯಲ್ಲ. On behalf of the accused, the petitioner is produced before this court in execution of the warrant. In execution of the non-bailable warrant not issued by this court. 27/9.
79.
79.
17.
And you have said 27/9.
Police, there's a typo error. 79.
17/9/24. By Shri Prabhu KL, PSI, Prabhakar, Head Constable number 11687, Narayan Swami, Head Constable 8570 from the Vidyaranapura Police Station. Vidyaranapura Police Station. Learned counsel for the petitioners filed an application under section 439 Code of Criminal Procedure and under section 483 of Bharatiya Nagarika Suraksha Samhita for enlargement of the petitioner on bail. Counsel for respondent submits he would not have much objection if a conditional order is imposed directing the petitioner accused to deposit substantial amount of the check. Exhibit P1, as he has succeeded in 2 courts, despite which he is unable to enjoy the fruits of the orders. Full stop. Being satisfied with the reasons stated by the petitioner in the application, you are also supposed to file an affidavit or memorandum of facts when you file any application. Every time you come up with something,
Verification he has signed with us.
he is now produced here, you could have taken his affidavit or you should have filed your memorandum of facts. High Court rules contemplate that. This court is of the opinion, considering the medical condition and the age of the petitioner, that he be released and enlarged on bail. Accordingly, I pass the following order. The application is allowed. Petitioner shall be enlarged on bail subject to the following conditions. Petitioner shall deposit 50% of the fine amount within 4 weeks from today, inclusive of any amount already deposited before the trial court. Full stop. Petitioner shall execute a personal bond for a sum of rupees 1 lakh to the satisfaction of trial court, along with like sum surety to the satisfaction of trial court. Petitioner shall not leave the jurisdiction of the state without leave of the court. Shall appear before the court as and when directed, either by this court or the trial court. It's made clear that any violation of this order or breach or non-payment of the amount as ordered here, the respondent would be at liberty to execute the order. All this matter on. You need time for surety?
Please, my lords.
You have surety now present.
No, I don't have my lords.
ಮತ್ತೆ ಹೇಳ್ಬೇಕನ್ರಿ.
Lords, as of now, we don't have any idea exactly what duty he would.
You are appearing for him, you should speak to him and find out.
Please, my lords.
The petitioner shall be released immediately. On his bond, surety shall be furnished after a period of 2 weeks.
Great.
Counsel for the petitioners also filed application under 70 clause 2, read with section 482 Code of Criminal Procedure. This application cannot be entertained, same is dismissed in view of bail having been granted.
But in this case, my lord, 138 proceedings, my lord, now. Check is amount for 4 lakhs rupees, my lord. Now warrant has been issued, my lord. Office objection, sir.
Objections comply ಮಾಡಿದ್ರ?
Complaint ಮಾಡಿ.
Learned counsel for the petitioner submits he has rectified the objections registry to verify the same. And meanwhile, issue notice to respondent. Then 138, you know?
Of the 138. Check is 4 lakhs rupees, my lord.
Right. Orders on IA number 2. And the pending consideration of IA number 1. There's a delay, is it?
There is a delay of 8 days in filing.
Pending consideration of IA number 1, IA 2 is taken up, imposing conditions. The order of sentence stated. Pension young order by application filed.
12/9/20.
Order of sentence dated 12 September 2023 in CC 5025 of 17. Passed by Additional Civil Judge JMFC Hassan, confirmed in Criminal Appeal 222 of 2023, dated 14/6/24. By the Second Additional District and Sessions Judge Hassan is hereby suspended. Petitioner shall be enlarged on bail subject to following conditions. Deposit of 50%.
My lord, is very
Inclusive
poor
of
partner,
any
my
amount
lord.
already
25%.
deposited within 4 weeks before the trial court from today. Personal bond for ₹1 lakh with like some surety to satisfaction of trial court.
Right.
Made clear if the amount is not deposited,
Ready.
respondent would be at liberty to execute the order.
Coolie, my lord, therefore.
Huh?
Coolie ಅವರು ಅದಕ್ಕೋಸ್ಕರ.
ಏನು?
Is a coolie, my lord.
ಹಾ,
ಅದಕ್ಕೋಸ್ಕರ.
ಮತ್ತೆ ಏನ್ ಮಾಡ್ಬೇಕು?
25%, my lord. He is very poor person. 4 ಲಕ್ಷ ಇದೆ. 1 ಲಕ್ಷ ಏನಾರ.
ಯಾಕೆ ತಗೊಂಡ್ರಿ ಮತ್ತೆ 4 ಲಕ್ಷ?
4 lakhs. 25% comes to 1 lakh.
Why did you take that amount?
ಅದು, my lord,
What is your defense?
my lord, my defense is that, my lord, both are friends, my lord. He has engaged the petitioner. He has instructed, requested the petitioner to sell the missionaries, my lord. That is Gulagara missionaries, my lord.
Yeah.
Crusher missionaries, my lord. For my lord, in this connection, my lord, he has issued security, my lord. However, my lord, some parts have been sold. Remaining parts are not able to sold, my lord.
Where have you said all that in your suspension application is condition not to pay? Nothing is stated. Have you deposited any amount earlier?
No, my lord, because before the trial court, my lord, seeing the pathetic condition of the petitioner, my lord, their, my lord, stay was being granted, suspended, without there being any deposit.
Appellate court.
Appellate court.
All right, make it 25%. Considering the fact that the petitioner is a coolie within 4 weeks, 25% party.
Lord, for the petitioner, my lord. 138 proceedings, my lord.
Yes, sir.
Well, previous date, the respondent has not been appearing for past few dates. The last time they had appeared, we had paid a sum of ₹50,000 before this honorable court itself, my lord. And there's a deposit of 80,000 in the trial court as well. But since then, they have not been appearing, my lord.
Yaru respondent.
Respondent, yes.
I've already appointed amicus curiae. We'll appoint amicus curiae then if he doesn't appear.
Very well, ma'am.
You are accused.
Yes, ma'am.
You have deposited the amount?
My lord, 80,000 is deposited in the trial court, my lord, 20%. 50,000 was paid to the respondent.
Who's the advocate appearing? Bharati or Sundaresh?
Once Sundaresh had come last time when we had paid 50,000 before Justice Srishananda.
Ah.
Since then, after receiving the money, he has not turned
So
up. my lord.
NOC is given by Bharati, is it?
Yes, my lord. Yes, my lord. Because that was a submission he made when he entered an appearance.
Anybody is from the High Court Legal Services Committee? Where is Javed? Huh? Barkoli, there is counsel for petitioner is present. There is no representation on behalf of respondent. Continuously. Hence, on the previous date of hearing, this court adjourned the matter today. Noted that if there is absence of respondent or the counsel, amicus curiae would be appointed accordingly. Learned counsel Srimati Archana KM is hereby appointed as amicus curiae to assist this court on behalf of respondent. Registry to show her name in the cause list. List this matter on 22nd October. Registry to furnish one set of free copy. The learned amicus curiae. 21st.
Yes.
Petition.
Case and counter case.
Ah.
226 convicted the accused under section 226 in CC number 5 of 2009. CC number 57 counter case acquitted. Accused was
84.
acquitted.
Which is the other case? Only one case.
Case and counter case. One case is CC number 5 of 2009. 2009. So counter case is 50 CC 57 of 2009. In CC number 5 of 2009, accused was convicted under section 326. And in CC number 57 2009, the accused was acquitted.
No, CC
The
number
offense-
5,
Yes, ma'am.
1 and 2 were convicted.
Yes.
Here the petitioner is who? Which accused?
Petitioners are accused 1 and 2. 1 and 2.
And in this, both the case conducted by the same prosecutor. That was the,
So what I told you to find out.
my lord, there are two options, my lord. Counter case, which is acquitted, the accused was acquitted in CC number 57 bar 2009. It may be sent back to trial court for retrial. Otherwise, your lordship may pass a judgment. Only two options.
No, he is relying on that full bench judgment.
Please, my lord.
So the question of retrial doesn't
Arise at all.
this issue of to be conducted by two different public prosecutors is not by the Supreme Court.
No, my lord, it is not there.
Supreme Court has nowhere said that it has to be conducted by two different prosecutors.
No. Lord, in those two judgments, Nathilal as well as Sudhir's case, that issue is not there. That is for the full bench of this honorable court, that is held, my lord, it must be, my lord, by two different prosecutors. No, full bench, my lord, extensively held, my lord, how, my lord, the procedure is to be followed as far as, my lord, that case and counter case is concerned.
It's just that paragraph relied on.
Lord,
5 mil. 5
Which paragraph you relied? 5.
full bench decision, my lord. My lord, para 18, my lord, finally it is the summary. Para 18, page number 35, my lord. In the memo which I produced. Para 18, lordship finds it, no?
18.
So in this case, the accused is convicted in both the matters.
But accused, my lord, by the trial court is convicted, my lord, but PO Act is invoked, my lord, they were released. But state preferred an appeal. In the appeal, my lord, the first appellate court convicted them, my lord, even for 326. But the trial court, my lord, acquitted him. There is no mention as to, my lord, whether they have been acquitted or not. They say the trial court only would say that in view of the, my lord, injuries, my lord, sustained, that would not come in the, my lord, purview of, my lord, section 326. So therefore, my lord, they have been convicted only for 324 and other offences.
We convicted, take me to the trial court order.
Please, my lord. The trial court order, if your lordship kindly see. Page.
3.
Please. At para 22 may kindly see, my lord. Page 52. 52 may kindly see, my lord. Page 52. Para 22. Lordship and Lordship get it, my lord?
Yes,
Please. Para 22 I am reading, my lord.
22, na?
From
Ah.
view of any angle,
Yes.
the accused persons have not elicited any contradiction or discloses the omissions in the evidence of prosecution. Witness in view of proving the case of prosecution, but the injury number 1 sustained by CW1 is not coming within the purview of section 320. And hence it has been reduced into section 324 of IPC from 326 of IPC. Hence, I answer to point number 4 partly affirmative and point number 1, 2, 3 and 5 in the affirmative. In view of the above discussion and answer to point number 1 to 5, I proceed to follow the following. Acting under section 248 surplus 2 of CRPC, the accused number 1 and 2 are hereby convicted for the offences punishable under section 341, 324, 504, 506, read with section 34 of IPC. Then, my lord, as far as, my lord, the then sentence part is concerned, next kindly see. Page 55. Para 6 also. ಅಂಶ 1. ಆರೋಪಿತರ ವಿರುದ್ಧ ರುಜುವಾತಾದ ಆರೋಪ ಭಾರತೀಯ ದಂಡ ಸಂಹಿತೆ ಕಲಂ 341, 324, 504, 506 ಸಹವಾಚಕ 34 ಶಿಕ್ಷಾರ್ಹ ಅಪರಾಧ ಆಗಿರುತ್ತೆ. ಈ ಅಪರಾಧಗಳು 2 ವರ್ಷದವರೆಗೆ ಶಿಕ್ಷೆ ಅಥವಾ ದಂಡವನ್ನು ವಿಧಿಸಬಹುದಾಗಿದೆ. ಆದರೆ ಆರೋಪಿತರ ವಯಸ್ಸು ಮತ್ತು ಅವರ ಕುಟುಂಬದ ಹಿನ್ನೆಲೆಯನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ 1ನೇ ಆರೋಪಿಗೆ 65 ವರ್ಷ ವಯಸ್ಸು, 2ನೇ ಆರೋಪಿಗೆ 60 ವರ್ಷ ವಯಸ್ಸಾಗಿದ್ದು ಗ್ರಾಮೀಣ ಹಿನ್ನೆಲೆಯಿಂದ ಬಂದಿದ್ದು ಅನಕ್ಷರಸ್ಥರಾಗಿರುತ್ತಾರೆ ಹಾಗೂ ಬಡತನ ಕುಟುಂಬದಿಂದ ಬಂದಿರುವುದು ಮತ್ತು ವಯಸ್ಸಿಗೆ ಬಂದ ಮಕ್ಕಳಿರುವುದರಿಂದ ಒಂದೊಮ್ಮೆ ಆರೋಪಿತರನ್ನು ಜೈಲಿಗೆ ಕಳಿಸಿದರೆ ಅವರ ಕುಟುಂಬಕ್ಕೆ ಸಮಾಜದಲ್ಲಿ ಕಪ್ಪು ಚುಕ್ಕೆ ಉಂಟಾಗುತ್ತದೆ. ಇದರಿಂದ ಆರೋಪಿತರು ಹಾಗೂ ಅವರ ಮಕ್ಕಳ ಮೇಲೆ ತೀವ್ರ ಪರಿಣಾಮ ಉಂಟಾಗುತ್ತದೆ. ಈ ಹಿಂದೆ ಆರೋಪಿತರ ವಿರುದ್ಧ ಯಾವುದೇ ಅಪರಾಧ ಸಾಬೀತಾಗದೇ ಇರುವುದರಿಂದ ಈ ಹಂತದಲ್ಲಿ ಆರೋಪಿಗೆ ಅಪರಾಧ ಪರಿವೀಕ್ಷಣಾ ಅಧಿನಿಯಮದ ಅಡಿಯಲ್ಲಿ ಲಾಭ ನೀಡಲು ಅರ್ಹರಾಗಿರುತ್ತಾರೆ. ಆದರೂ ಆರೋಪಿತರ ಕೌಟುಂಬಿಕ ಹಿನ್ನೆಲೆ ಮತ್ತು ಅವರ ಚಾರಿತ್ರ್ಯದ ಬಗ್ಗೆ ಪರಿವೀಕ್ಷಣಾಧಿಕಾರಿಗಳಿಂದ ವರದಿಯನ್ನು ತಯಾರಿಸಿ ಪರಿಶೀಲಿಸಿ ಆರೋಪಿಗಳ ವಿರುದ್ಧ ಶಿಕ್ಷೆ ವಿಧಿಸುವಿಕೆ ಬಗ್ಗೆ ಆದೇಶ ಮಾಡುವುದು ಅವಶ್ಯಕವಾಗಿರುತ್ತದೆ. ಹಾಗಾಗಿ ನಾನು ಅಂಶ 1ಕ್ಕೆ ಸಕಾರಾತ್ಮಕ ಉತ್ತರಿಸಿರುತ್ತೇನೆ. ಮೇಲೆ ವಿವರಿಸಿದ ಕಾರಣಗಳಿಂದಾಗಿ ಕೆಳಕಂಡಂತೆ ಮಾಡುವ ಆರೋಪಿತರು ಸಲ್ಲಿಸಿರುವ ಅಪರಾಧ ಪರಿವೀಕ್ಷಣಾ ಅಧಿನಿಯಮ ಕಲಂ 4 ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಲಾಗಿದೆ. ಆರೋಪಿತರು 6 ತಿಂಗಳವರೆಗೆ ಯಾವುದೇ ಕಾನೂನು ಬಾಹಿರ ಚಟುವಟಿಕೆಯಲ್ಲಿ ಪಾಲ್ಗೊಳ್ಳದಂತೆ ಅಂತಹ ಮುಚ್ಚಳಿಕೆಯನ್ನು ಹಾಗೂ ತಲಾ 10,000 ರೂಪಾಯಿಗಳ ಜಾಮೀನುದಾರಿಕೆಯನ್ನು ನೀಡಲು ಆದೇಶಿಸಲಾಗಿದೆ. ಅಪರಾಧಿ ಪರಿವೀಕ್ಷಣಾಧಿಕಾರಿಯಿಂದ ಅವರಿಗೆ ಸೂಚನೆಯನ್ನು ಕಳಿಸಿ ಆರೋಪಿತರ ಚಾರಿತ್ರ್ಯದ ಬಗ್ಗೆ ಈ ದಿನದಿಂದ 2 ತಿಂಗಳೊಳಗೆ ಹಾಜರುಪಡಿಸಲು ಆದೇಶಿಸಲಾಗಿದೆ. ಆರೋಪಿತರು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಕರೆದಾಗ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರಾಗಿ ತಮಗೆ ವಿಧಿಸುವ ಶಿಕ್ಷೆಯನ್ನು ಅನುಭವಿಸಲು ಸಿದ್ಧರಿರತಕ್ಕದ್ದೆಂದು ಆದೇಶಿಸಲಾಗಿದೆ. ಜಾಮೀನುದಾರರಾದ ಸೋ ಅಂಡ್ ಸೋ ಇವರು ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಹಾಜರಿದ್ದು ತಮ್ಮ ಪ್ರಮಾಣ ಪತ್ರ ಹಾಗೂ ತಮ್ಮ ಜಮೀನಿನ ಪಹಣಿಯನ್ನು ಹಾಜರುಪಡಿಸಿರುತ್ತಾರೆ. ಅದನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಜಾಮೀನುದಾರರ ಹೆಸರಿನಲ್ಲಿ ಸರ್ವೆ ಸೋ ಅಂಡ್ ಸೋ ಏಕರೆ ಜಮೀನು ದೃಢಪಟ್ಟಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಜಾಮೀನುದಾರಿಕೆಯನ್ನು ಪುರಸ್ಕರಿಸಲಾಗಿದೆ. ಅದರಂತೆ ಮುಚ್ಚಳಿಕೆಯನ್ನು ಪಡೆಯಲು ಕಚೇರಿಗೆ ಆದೇಶಿಸಲಾಗಿದೆ. So they have been let off by the PO by invoking PO Act, against which will not the state preferred an appeal. In criminal appeal 88 of 13, there the learned session judge found that the reducing the offense to 324 is not correct and held that 326 is made out and convicted them at page 24.
Running page 24.
Yes.
The appeal preferred by the appellant, prosecution to section so and so is hereby allowed. The orders passed by the trial court by releasing the accused person probation of offender set hereby set aside. The accused persons are convicted and sentenced to pay a fine of rupees 300 each for so and so. For major offense, my lord, that is for 326, my lord, page 26L.
So for,
326 is concerned.
no,
The
this,
accused persons are
offense-
further convicted.
First
and
one.
For my lord,
For 341, sentenced to pay fine of 300.
300 only, my lord. If by default, my lord, then they have to undergo simple imprisonment
Right.
for 1 month.
Yes, right.
Default.
Ah.
And as far as 504 is concerned, Lord, fine of rupees 500 each.
Hmm.
As far as 324, simple imprisonment for 6 months. 324.
Hmm.
Lord, as far as Lord 506 is concerned, they have been convicted for 1 year. SI. But in so far as 326 is concerned, convicted for 2 years.
Hmm.
SI 2 years and fine of rupees 2000 each. Not against which will not the petitioners before this.
So your contention is the entire procedure followed is vitiated,
Because of my lord,
not following the procedure.
Yes. Lord, since my lord, the full bench would say that Lord, if at occasion failure of justice, my lord, trial vitiates. When my lord that act
Not brought to the notice.
please, my lord,
That judgment of full bench was not brought to the
my
notice.
lord. Either by the prosecution or by the my lord, the defense said nobody was brought to the knowledge of the my lord, prosecution, the judge of the trial court. But however, the trial court was aware that there was a counter case. It is not that not the trial court was not at all aware about the counter case. It was aware. The trial court was aware about the counter case issue. It has come in the evidence.
When did the trial happen and the proceedings evidence happen? In which year? 2009.
9, my lord.
When is the judgment of the full bench?
My lord, judgment of the full bench 2012, my lord, that is 2000, I'm sorry. Ida? CL.
It's in 2012.
12.
So it was not available as on date of that order.
But however, before the appellate court, it was available.
Correct. When is the appellate court order?
But appellate court order, it was preferred in the year 2013, disposed of in the year 2016. Subsequent to the judgment.
All right. I'll reserve it past the orders.
Please.
Heard. Learned counsel for the petitioner and learned HCGP for the state. Reserved for orders.
Please.
Notes are available. Notes. Minute, 1 minute.
Your Lordship, I appear for the petitioner.
Yes,
The offence is under section 138 of the Negotiable Instruments Act.
that is Harish Ganapati. Was not present on the last occasion also.
On last occasion also, Your Lordship.
We'll have it after vacation. Learned counsel for the petitioner is present, no representation on behalf of respondent. To provide one more opportunity to the respondent, call on. Shaukat Ali.
For petitioner, Lords, kindly pass this matter, Lords, senior is in court of 15, Lords.
My lord, the accused was convicted under section 584, 58 and 9, read with section 11 of Karnataka Prevention of Cows Slaughters Act and
This
Cattle
heard,
Prevention
partly
Act.
heard, not heard yet.
Not
Yet,
yet, Lords.
Have it after vacation. Counsel for the petitioner seeks time. Learned CGP is present, call on after vacation. Hegde. It's Mr. Hegde.
Last occasion matter was partly heard. This is arising out of the Domestic Violence Act.
DV Act.
Yes, DV Act.
Is it
Petitioner
heard?
before your lordship.
Was it heard partly?
Insofar as criminal revision petition 938 is concerned, both are arising out of the same orders. One is for residence order and restraint order, another for maintenance.
Husband and wife.
Husband, it is not admitted. That is the dispute. That itself is the dispute.
No, that there is no need of being a relationship of husband and wife to invoke the provisions of DV Act.
DV Act, my lord, at least minimum basic requirement is necessary to say that they are the husband and wife.
No.
If that is not established, then they cannot be called as a husband and wife.
Which law says so?
Domestic violence,
Read it.
2F,
Read it.
2F.
Now then the Supreme Court thereafter has passed even for live-in marriage.
That is right.
You are
Here-
living
here
in
is
the nature of a marriage.
Correct, absolutely correct. There is no dispute with regard to that.
Nature of
Here,
marriage.
correct, correct.
You're
No
not-
doubt
we are-
about it.
We are not sitting on the Hindu Marriage Act of section 4-5.
No, that is also required insofar as the marriage is concerned. Your lordship may kindly see the wording.
DV
2F,
Act. DV Act.
DV Act. And my lord, before coming to that, I make myself clear insofar as the facts are concerned. The fact is that, my lord, the respondent claimed to be the wife, and she has categorically mentioned in the petition that her marriage
It would
has
be possible for me to dictate now because you're going to only begin arguments. You take it after vacation and argue.
I'll leave it to this court.
Not possible now.
Immediately after
But
vacation.
matter is partly heard, that is the reason it may be.
Not partly heard, and I just heard you, but not partly heard.
No, no, last occasion, in fact, I have taken your lordships to the judgment also.
Anyway. All right. Then
After
the
vacation.
counsel for the petitioner and respondent are present. Due to paucity of time, list this matter on 15th. 15ನೇ ತಾರೀಕು.
15 October.
October.
ಆಗ್ಬೋದು. 15th October.
A. Ravishankar. Jaikar Shetty. There's no representation on either side. The matter is called at 3:57 PM. Call on.
Petitioner, my lord. Kindly, after vacation, my lord, please. Senior is inconvenienced because of.
Learned counsel for the respondent is not served. ಏನಾಗಿದೆ ಅವ್ರಿಗೆ? You're accused.
Yes, my lord.
Respondent has never appeared.
Not there, my lord. I'm sorry, my lord.
Advocate ಯಾರು ಇಲ್ವಲ್ರಿ? Right, but 17, somebody has to be. Have you deposited the amount?
No, my lord.
Two lakh 50,000.
Yes, ma'am.
Have you deposited?
No, ma'am.
No. Because no order must have been made directing you to deposit. Learned counsel for the petitioner is present. It is seen, despite service of notice to respondent, there is no representation on behalf of respondent. Under the circumstances, it becomes necessary to appoint an amicus curiae to assist to the respondent, assist this court on behalf of respondent. Learned counsel Sri Javed.
I'm sorry, my lord, I was in fast.
No problem. Now we'll appoint amicus,
Please.
then hear you.
I've also advised them, my lord, if they are there, square it up. I told my.
You want to
counterpart-
pay up?
I advised them, my lord, I don't know. Because the party is not in touch with me, the advocate was in touch with my,
1 lakh only, I think.
yes. 2 lakhs and odd is the,
2,50,000. If his respondent is from Bangalore only, Mysore,
Mysore, my lord.
they're in touch?
Party is not in touch, my advocate is in touch. So I advised him to call him and if he could square it up.
Sri
In the
Javed.
meantime, your lordship may appoint amicus.
ನೋಡಿ ಅವ್ರ ಹೆಸರು ಜಾವೇದ್, yes sir. Is hereby appointed as amicus curiae to assist this court. Registry to show his name in the cost list. One set of copies shall be furnished by learned counsel for the petitioner. All on 22nd October.
Set ಮಾಡ್ಬಿಟ್ಟು. Where is it?
No, Nayak. Yes. Then yesterday, day before in the ಇವತ್ತು ಬಂದಿರಲ್ಲ.
These two revision petitions are interlinked in respect of an Innova car. The complaint Ravindra Singh held in the complaint that
Which matter you are arguing now? First matter?
first matter.
Hmm.
It is a coup between the Manjunath and Ravindra Singh. And
Second matter, ಯಾರು? Second one.
For the respondent, one in first case, my lord.
Yes. Yes.
In this case, the first case, the complaint held that with intent to sell the vehicle, Innova vehicle to the complainant, he took the advance sum of rupees 2,50,000 to discharge his debt and liability. He issued the check.
Complainant wanted to sell.
The accused intent to sell his Innova car. He took the advance sum of rupees 2,50,000 and to discharge that he could not able to sell the car. In return, whatever the amount is taken as advance, to return that amount, he issued the check. That is the allegation made by the complaint in first matter. That in fact, in the other case, connected matter. Complaint submits that during the month of June 2011, there was a sale transaction of Innova car bearing so and so.
So Innova car belonged to whom?
Belongs to me, but I got purchased the Innova car in the name of Manjunath. Since I don't have any property to show before the bank authorities, I got purchased the Innova car in the name of Manjunath. I got obtained the loan from the bank in the name of Manjunath in the connected matter complaint. Taking advantage of the RC stands in the name of Manjunath, he filed a private complaint before the jurisdictional magistrate and in turn referred to the police, where my vehicle is seized in the month of January 2011. The car is not with me. RC is not standing in my name. The police, jurisdictional police, Manjunath and this complaint colluding each other, and where I was kept in illegal custody and got obtained the checks. That two checks had been misused by both the complainants, Manjunath and this complaint.
Those two checks were given by you?
By me. Forcefully, they have collected from me in the illegal custody of police station.
Yes, when it was collected?
In the month of June 2011, they were collected the checks. This complaint is in a president of Sudeep Fans Association. He colluding with the other complaint and created a coup and colluding with the jurisdictional police and collected the checks in the police station and filed a complaint stating that I have intent to sell my vehicle to this present complainant and I could not able to sell the car. In the month of June, the allegation is that I have intent to sell the car. I have taken the 2,50,000 as an advance. In the January itself, my vehicle had been seized and kept in police station. When it is not believable, the version of the complaint, when the vehicle is in police custody, RC is not standing in the name, how we could possible to give advance of rupees 2,50,000 to me? May kindly see the same is admitted in his cross-examination. May kindly see the cross-examination.
Where is Mr. Naik? Where is your friend, Mr. Naik, madam?
My lord, I don't know where.
He has to also argue in the midway after he will take.
Yes, my lord.
He cannot take time after I hear you both.
Kindly the vacation.
Yes, my lord.
Because all of you together, it is a connected matter. You have to argue together.
Senior sir is not today.
The last question, he was here. You were not here.
I also came by that time.
What to do now? You can't do it in piecemeal. Just it
After
after
vacation,
vacation.
kindly.
Have you paid any amount?
I paid 20% in the time.
Lower court, my lord, not in this high court, my lord.
High Court, has it imposed at all anything?
Yes, my lord, 20% of the
ಇಲ್ಲಿ ಆಳ್ಕಿರೋದ್ ಮಾಡಿಲ್ವಾ?
ಮಾಡಿಲ್ಲ, my lord.
ಮಾಡಿದ್ದೀವಿ, ಇನ್ನೊಂದ್ರಲ್ಲಿ.
ಇಲ್ಲಿ court, high court ಅಲ್ಲಿ ಮಾಡಿರೋದು ಮಾಡಿಲ್ಲ, my lord.
Deposited. In another case,
ಬರ್ಕೊಳ್ಳಿ ನಾವು. Counsel for petitioner Shri Harish Kumara
yes.
is present. Learned counsel Srimati Usha. Madam, you are Usha?
Yes, my lord, Usha, MS.
Yes, is present in criminal RP 1274. But in the connected matter, counsel for respondent Shri N.R. Nayak is not present. Since the matter is connected and according to the counsel for petitioner, it is a single transaction out of arising. The presence of counsel for respondent would be required in the criminal RP 1273. Let's call this matter on provocation.
Petitioner counsel will be taken up after vacation. Not for a
I
conviction.
have not heard you.
Not yet heard.
Third counsel for petitioner seeks time. Learned CGP is present. Call on. Abu Bakr Shafi.
Appear for petition. Offense 138 of NI ಆಗ್ತದೆ. Check amount 3 lakh.
You are ready to argue
Yes.
because respondent is not here. Where is respondent? He has given NOC or he has come on record as on NOC?
NOC
ಇವ್ರು ಬಂದಿದ್ದಾರಾ?
one time ಬಂದಿದೆ.
Counsel for petitioner is present, no representation for respondent. Call on. Naveen Reddy.
The offense is under section 138 of.
That I appeal for the respondent. Both of you are ready?
Ready?
Yes.
Lord, the respondent complainant has filed a private complaint against the accused petitioner herein for the offense punishable under section 138 of NIA, alleging that
32 lakhs.
yes, my lord, the check amount is 32 lakhs.
10,000.
31 lakhs 20,300.
2014.
Yes, my lord. Alleging that there was a due in a business transaction between the complainant and accused regarding the supply of cement bags. To discharge that liability, he has issued the check, and that check was, when the check was presented, it was dishonored for exceeding arrangement. That is the allegation of the complainant. My lord, at the first instance only, before the trial court, the accused has raised an objection regarding maintainability of the complaint. Your lordship may kindly see the main allegations and contention of the complainant that the complainant has supplied the cement bags to a partnership firm named as Mrs. Grade Mix, A partnership.
grade mix.
Grade mix, yes,
Hmm.
my lord. And the accused arraying herein is a partner, representing as a partner of the partnership firm.
Hmm.
But at the time of issuing of notice, as well as at the time of filing the complaint, the partnership firm was not arrayed as a party to the proceedings.
Yeah, the records is there. So according to you, it's a partnership firm.
Yes, my lord, that is admitted. And so far as the cause title of the complaint is concerned,
P1.
wherein it is clearly stated that B. Narasimhamurthy, partner, grade mix. And the
Well, in
contents,
complaint, it is said so.
yes, my lord, cause title nalli,
Grand mix partner.
grade mix. Instead of grade mix, they are stated as grand mix.
Grade mix. The check is drawn.
Check is drawn in the name of grade mix. Mr. B. Narasimhamurthy, the person who arrayed as accused in this matter,
Who are the partners in this firm?
Mr. B. Narasimhamurthy and one Gautam.
Who is the signatory on the check?
Signatory is B. Narasimhamurthy. He signed as a partner of grade mix.
Shivkumar anta idanಗಿದೆ.
Alla. Shivajyoti and Associates.
Shivajyoti.
That is the complainant. Shivajyoti and Associates is complainant.
Issued in favor of Shivajyoti.
Issued in favor of Shivajyoti and Associates. Complainant a proprietorship concern. So far as the signature is concerned, your lordship may kindly see. For grade mix as a partner, Mr. B. Narasimhamurthy has signed the check.
EC 27201. Given the wrong file. CC 27201. ಎರಡು ಹೆಸರು ಬೇರೆ ಇತ್ತು.
Two 27201 of 2014.
ಅದು ನೆಕ್ಸ್ಟ್ ಇರುತ್ತೆ ಅದೇ ಎಕ್ಸಿಬಿಟ್ P2.
P1.
P1 is power of attorney.
P2 is
P2. Grade mix.
Grade mix as a partner is signed.
As a partner.
As a partner.
Shivajyoti, it is issued.
Yes, ma'am.
It cannot be disputed anyway.
Yes, my lord. And so far as the legal notice is
The
concerned,
issuance of,
only sole proprietor, both the
no, the check is issued by one grade mix.
represented by Narasimhamurthy, accused.
as a partner.
There is no dispute at that regard. Is a
And your
sole
lordship may kindly
proprietor.
see the legal notice, exhibit P5. The notice itself is very clear that the notice issued to one Mr. B. Narasimhamurthy, partner, grade mix. And the averments made in the notice also, my lord. In the first paragraph, you are aware that my client is authorized to stock its all kinds of cements in the name and style, Shivajyoti and Associates, dealing with Vasudatta and ACC Cement as dealer in wholesale and retail bags, etc. And doing the business in the above furnished address, you being customer of my client, and you have representing as a partner of grade mix. doing business in cement at so and so address. Here also they have clearly stated that Grade Mix is a partnership firm and he representing as a partner of a partnership firm doing business with the complainant and he issued the check on behalf of the firm also. But the complainant has not issued any notice to the partnership firm as well as all the accused who are all responsible for day-to-day affairs of the partnership firm.
Yes, Chennai, there are partners.
Ibru idare. B. Narasimhamurthy and one Mr. Gautam. I have produced the exhibit D1, that is the partnership deed.
You have replied to this notice?
No, my lord, that notice was not served on me. Admittedly, the address furnished at the notice, the second address, is a complex not belonging to is not residing in that address. And it is very clear that in the notice itself, he has stated that Grade Mix is running business at number 138 Kudrugere village, Jala Hobli, Avare Helta. But they have not issued any notice to the business address of the partnership firm.
Number 138?
Number 138 is the residential address of Mr. B. Narasimhamurthy Mela. That was disputed by the accused.
So that is not the address.
It is his residential address.
Right.
Residential address of the B. Narasimhamurthy, one of the partners of the firm.
So that's the correct address.
That is correct address. So far as the address of the firm is concerned, they have not issued any notice to the address of the firm.
All right. Yes.
And Your Honor may kindly see, to maintain the prosecution against a firm, as per section 141 of the Negotiable Instrument Act, arraying of firm is a condition precedent, Mela.
Yes, you want to read 142?
141, Mela.
Yes.
Offenses by companies. If the person committing an offense under section 138 is a company, every person who at the time of the offense was committed was in charge of and was responsible to the company for the conduct of the business of the company, as well as the company shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly, provided that nothing contained in this subsection shall render any person liable to punishment if he proves that the offense was committed without his knowledge or that he had exercised all due diligence to prevent the commission of such offense. Provided further that where a person is nominated as a director of a company by virtue of his holding any office or employment in the central government or state government or a financial corporation owned or controlled by the central government or the state government, as the case may be, he shall not be liable for prosecution under this chapter. Notwithstanding anything contained in subsection 1, where any offense under this act has been committed by a company and it is proved that offense has been committed with the consent or connivance of or is attributable to any neglect on the part of any director, manager, secretary, or other officer of the company, such director, manager, secretary, or other officer shall also be deemed to be guilty of that offense and shall be liable to be proceeded against and punished accordingly. Explanation. For the purpose of this section, company means any body corporate and includes a firm or other association of individuals, and a director in relation to a firm means a partner in the firm. Here also, in this case, the check was issued by a partner of a firm on behalf of the firm.
Yes.
So far as the findings of the trial court as well as the appellate court is concerned regarding the aspect of maintainability, they came to conclusion that your lordship may kindly see Ink page number 43 of the petition, man.
Ink page number,
43 of my petition.
what is that?
That is the judgment of the trial court. The findings given by the trial court regarding the aspect of maintainability of the complaint.
Forty-five.
43, my lord. 43 to 45, the finding was given.
43. Which para?
Paragraph number 19, my lord.
Yes, please read.
So far as the technical aspect is concerned, it is the arguments of the land counsel for the accuser that in Exhibit P5 legal notice, complaint has admitted that accused is the partner of grade mix. Further, it is also coming to the evidence of the complainant that accused is one of the partner of grade mix, relying upon Exhibit D1 partnership deed. It is contended that along with the accused one Gautam, who is the son of the accused, is also partner of the said firm. Therefore, without implementing partnership firm, complaint itself is not maintainable. As it could be seen that as per Exhibit D2, that is the bank statement of accounts pertaining to the accused, various payments have been made to the complainant firm and last payment on 2/4/2013 by way of check bearing number so and so paid. Apart from that, various payments made as per Exhibit D2 discloses that there was no any dispute between the parties with regard to supply of cement and payments. Only when the check in question was issued by the accused is bounced, that too during the course of a cross-examination of the complainant, the accused has raised a plea that partnership firm is also necessary party and all the parties are to be included. It is also to be borne in mind that admittedly the accused has admitted transaction. It is also proved by the complainant that the impugned check was issued for discharge of the liability. Under such circumstances, now the accused cannot take up the defense that since all the partners have not been made as party and partnership firm, therefore complaint is not maintainable. This is the finding assigned by the trial court, my lord. Further, my lord, in paragraph number 21, it is pertinent to note that one of the partners for Exhibit D1 is none other than the son of the accused himself. Therefore, the contention of the accused cannot be accepted. Apart from that, the Honorable Supreme Court, in the case of Mainuddin Abdul Sattar Sheikh versus Vijay D. Salvi, Criminal Appeal number 1472 of 2009, has held that the person who has issued the check shouldering the responsibility of the company is liable to be prosecuted under Section 138 of NI Act, irrespective company is being made as a party to the proceedings. Your Lordship may kindly see herein the decision relied on by the complainant before the trial court, that is reported in 2015.
ಯಾವ್ದು?
Yeah,
Abdul Sattar.
2015. ಹೌದು sir.
Abdul Sattar.
That is not applicable to this case, sir. Because in that case, the check was issued by a director of a company on individual capacity pertaining to his individual account. Wherein in paragraph number 10, ma'am. In the present case, it is an admitted fact that the drawer of the check was the respondent who had drawn the check bearing number so and so for rupees 74,200 on a bank account maintained by him towards the refund of the booking amount. Therefore, he was the drawer of the check. The case of the appellant, apart from being supported by the provision of Section 138 of NI Act, also gets buttressed by the judgment in Pija Agrotech Limited and other sources. So and so, where this court has dealt with the scope of Section 138 and held that it is very clear that in order to attract the provisions thereof, a check which is dishonored will have to be drawn by a person on an account maintained by him with the banker for payment of any amount of money to another person from out of that account for the discharge in whole or in part of any debt or other liability. It is only such a check is dishonored which would attract the provisions of Section 138 of the above act against the drawer of check. Here, my lord, it is very clear that the check was issued by a director of a company. belonging to his individual account on his individual capacity. This decision is not applicable to this case, my lord. In my case, the check was issued by a partner representing as a
So
partnership.
read
firm.
the facts of the case.
The facts of the case, my lord.
Para 2 will note it.
The brief facts necessary to dispose of this appeal are that in the year 1999, the appellant had booked a flat at Kargar project proposed to be developed by Mrs. Salvi Infrastructure Private Limited through the accused respondent by paying him rupees 74,200. In acknowledgement of the said amount, the accused respondent issued 2 receipts to the appellant for a sum of rupees 59,000 and 14,200 respectively. By the year 2003, as alleged by the appellant, the aforesaid project of the respondent did not materialize. After much persuasion, the accused respondent drew check number so and so for rupees 74,200 in favor of the appellant of an account maintained by him with his banker towards refund of the aforesaid booking amount. The check was drawn by the respondent in his individual capacity and not in the capacity as a director of Mrs. Salvi Infrastructure Private Limited or as proprietor of Salvi Builders and Developers. When the appellant presented the said check on 1/8/2003 to his bank for realization, the same was returned unpaid. Hence, the appellant sent notice of demand dated 25/8/2003 through his advocate under section 138B of the Negotiable Instrument Act to the respondent. As the accused respondent failed to pay the amount within 15 days of the notice of demand, the appellant filed a complaint under section 138 of the NIM. The facts of the case clearly discloses that the accused has issued the check in this case in his individual capacity.
So this judgment is relied to convict.
Yes, ma'am. The trial court relying on the judgment took a view that the complaint is maintainable.
Yes.
And not consider the judgment relied on by me. That is the further Swami, Adrale, in the very same paragraph in section 21. Adrale, last 2 lines. No doubt, the decision reported in the case of Messrs. Halapanava Agrochemicals versus Messrs. Jaji Pesticides. It is held that unless all the partners are made as parties, complaint is not maintainable. Further, it is also held that check issued by one partner without impleading other, complaint is not maintainable. But in the instant case, there was no any dispute previously between the parties with regard to the payment and also the liability of the accused. Here, without considering that aspect, the trial court goes on considering the aspect of merit. Your Honor,
Have the other same.
Yes, Swami. Halapanava. Wherein in paragraph number 8, my lord, of the judgment.
Yes.
I have perused the evidence of the complainant examination in chief by way of affidavit. In para 4 of the said affidavit, it is contended that lastly, the accused has issued a check dated 15/7/2003 as a partner of the firm, Messrs. Jaji Pesticides, drawn on the bank of Gulbarga for a sum of rupees so and so in favor of the complainant, promising the complainant and the same will be honored on its presentation. This averment made in the affidavit clearly goes to show that the said check has been issued by the respondent accused not in his individual capacity, but as a partner of a firm, Messrs. Jaji Pesticides. So also I have perused exhibit P1 check dated 15/7/2003 for a sum of rupees 1,82,430. Looking to the drawer of the said check, it is mentioned as partner, wherein the respondent accused has signed the said check. These materials produced in the case clearly goes to show that the check issued in this case is not in the individual capacity, but representing the partnership firm. When that is so, the complainant ought to have arrayed the partnership firm as well as partners who are responsible for the conduct of the day-to-day business of the said partnership firm. But admittedly, firm is not made as a party in this case. Looking to the principle stated in the decisions relied upon by the learned counsel for the respondent accused, it clearly goes to show that in the absence of arraying the company or the firm, the complaint filed against the director or the partners only as not maintainable in law. I have also perused the oral evidence and adduced in this case. The trial court, without appreciating the judgment of this honorable court, came to a conclusion that though it is admitted
Yes.
and holding that it was held in the judgment that without arraying a partnership for the complaint is not maintainable, then it's given a go by to the decision matter. And the decision was also passed by the honorable court, relying on the decision of the honorable Supreme Court.
A.C. Narayanan. Which case?
In the case of Anita Hada.
Anita Halda's case.
Yes, my lord. Anita Hada versus Messrs. Godfather Travels and Tours Private Limited. Wherein, my lord, the honorable apex court clearly held that in paragraph number, my lord, 43, my lord. In view of the aforesaid analysis, we arrive at the irresistible conclusion that for maintaining the prosecution under section 141 of the Act, arraying of a company as an accused is imperative. The other categories of the offenders can only be brought in the dragnet on the touchstone of vicarious liability, or the same has been stipulated in the provision itself. We say so on the basis of the racial laid down in C.V. Parekh, which is a 3-judge bench decision. Thus, in view expressed in Sheraton Agarwal, does not correctly lay down in law and accordingly is hereby overruled. Here in this decision, my lord, the Honorable Supreme Court is very clear that for maintaining the prosecution as per section 141 of NI Act, arraying of company is mandatory. And the same was followed by the another judgment of the Honorable Supreme Court. Case of N. Harikrishnan versus J. Thomas.
Yes.
In the paragraph number 23, my lord, of the judgment.
23 now.
23, my lord. The scheme of the prosecution in punishing under section 138 of the NI Act is different from the scheme of the CRPC. Section 138 creates an offense and prescribes punishment. No procedure for the investigation of the offense is contemplated. The prosecution is initiated on the basis of a written complaint made by the payee of a check. Obviously, such complaints must contain the factual allegations constituting each of the ingredients of the offense under section 138. Those ingredients are that a person drew a check on an account maintained by him with the banker, that such a check when presented to bank is returned by the bank unpaid, that such a check was presented to the bank within a period of 6 months from the date it was drawn or within the period of its validity, whichever is earlier, that the payee demanded in writing from the drawer of the check the payment of the amount of money due under the check to payee, and such a notice of payment is made within a period of 30 days from the date of receipt of the information by the payee from the bank regarding the return of the check as unpaid. It is obvious from the scheme of section 138 that each one of the ingredients flows from a document which evidences the existence of such an ingredient. The only other ingredient which is required to be proved to establish the commission of an offense under section 138 is that in spite of the demand notice referred to above, the drawer of the check failed to make the payment within a period of 15 days from the date of receipt of the demand. A fact which a complainant can only assert but not prove, the burden would essentially be on the drawer of the check to prove that he had in fact made the payment pursuant to the demand. By the nature of the offense under section 138 of the Act, the first ingredient constituting an offense is the fact that a person drew a check. The identity of the drawer of the check is necessarily required to be known to the complainant and needs investigation and would not normally be in dispute unless the person who is alleged to have drawn a check disputes the very fact. Here also, my lord, in this case, it is very clear from the allegations made in the complaint as well as in the legal notice and also the examination in chief filed by way of affidavit filed by the complainant that the Mr. B. Narsim, a partner of a partnership firm, was running a business along with the complainant, my lord. That has not been disputed and they have also.
It's not disputed by you also.
Not disputed.
First of all, 2010, my lord.
All right, let us.
Let it come.
Yes.
And also, my lord, in paragraph 20 and 21 my lord, of the judgment.
Yes.
The offense of the section 138 of the Act is capable of being committed only by the drawer of the check.
Where are you reading?
Paragraph number 20, my lord.
Of the judgment?
Judgment, my lord. The very same judgment now I referred. That is N. R. Krishnan versus J. Thomas. Regarding the prosecution maintenance section 138 of NA Act. So far as 141 is concerned, paragraph number 20, my lord. The offense under section 138 of the Act is capable of being committed only by the drawer of the check. The logic of the High Court that since the offense is already taken cognizance of, there is no need to take cognizance of the offense against Dakshin is flawed. Section 141 stipulates the liability for the offense punishable under section 138 of the Act when the person committing such an offense happens to be a company. In other words, when the drawer of the check happens to be a company, relevant portion of section 141 reads as follows. I have already read section 141, my lord. Next, paragraph number 21, my lord. This court in Anita Hada, the earlier judgment which I referred, my lord.
Yes.
AR 2012 SC 2795, had an occasion to examine the question whether an authorized signatory of a company would be liable for prosecution under section 138 of Negotiable Instrument Act without the company being arraigned as an accused and held as follows. In view of our aforesaid analysis, we arrive at the irresistible conclusion that for maintaining the prosecution under section 141 of the Act, arraigning of a company as an accused is imperative. The other categories of offenders can only be brought in the dragnet on the touchstone of vicarious liability, as the same has been stipulated in the provision itself. Yet the High Court reached a conclusion that the revision filed by the petitioner is not maintainable because Dakshin did not choose to challenge the trial court's order. The High Court failed to appreciate that the liability of the appellant, if any in the context of the facts of the present case, is only statutory because of his legal status as a director of Dakshin. Every person signing a check on behalf of company on whose account a check is drawn does not become the drawer of the check. Such a signatory is only a person duly authorized to sign the check on behalf of the company, drawer of the check. If Dakshin drawer of the check is sought to be summoned for being tried for an offense under section 138 of the Act beyond the period of limitation prescribed under the Act, the appellant cannot be told in view of the law declared by the Apex Court in Anita Hada that he can make no grievance of that fact on the ground that Dakshin did not make any grievance of such summoning. It is always open to the Dakshin to raise the defense that the initiation of prosecution against it is barred by limitation. Dakshin need not necessarily challenge the summoning order. It can raise such a defense in the course of trial. Here also, my lord, in my case, your lordship may kindly see page number 44 of my
Judgment.
My petition, my lord. That is the judgment of the trial court. Page number 44.
Yes.
Wherein the first line, ma'am. That too, during the course of cross-examination of the complaint, the accused has raised a plea that partnership firm is also necessary party and all the partners are to be included. This is the one of the finding recorded by the trial court, my lord.
Yes.
The decision of Mr. N. Harikrishnan versus J. Thomas is very clear. I already read, my lord. I can raise at the time of trial also. But that is the time when the accused can set up his defense by effectively cross-examining the complainant. At that particular point of time, I have raised that defense. And the appellate court has also confirmed the judgment passed by the trial court without appreciating the
evidence on record, as well as the judgment referred by the accused, my lord. Wherein the judgment of the appellate court, your lordship may kindly see. Page number 24 of my petition, my lord, ink page number.
Yes.
Paragraph number 12B. I have gone through the above said citations of the Honorable Supreme Court and Honorable High Court of Karnataka in the decision reported in AR 2012, SC 2795 in the case of Anita Ada versus Godfather Travels and Tours Private Limited. Their lordships of the Honorable Supreme Court have held that in a complaint for dishonor of check, other directors of company and as well as the company has to be arraigned as an accused, and it is a condition precedent. However, in the case on hand, it is to be seen that the appellant firm is not a company. Here, the appellate court has taken a view that firm is not a company, hence the decision of the Honorable Supreme Court is not applicable to the case. Where your lordship may kindly see, the act itself is very clear. The explanation in section 141, company means a firm and the director means a partner also.
Yes.
And regarding the admission is concerned, admission of the complainant is concerned regarding the partnership firm. My lord may kindly see the deposition of PW1.
Yes. PW1?
PW1, my lord. One Mr. Sangaya V. Hiramat, claiming to be the general power of attorney holder of complainant.
DW1.
PW1, my
Sangaya V. Hiramat.
The proprietor of the complainant has not examined in this matter. One Mr. Sangaya V. Hiramat examined.
The proprietor?
Proprietor is Mr. One.
Sworn statement ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು.
Panchaksharaya M.
Chakshayaram is a GP holder of his brother.
This man is acting as power of attorney holder.
Power of attorney holder. He examined as PW1. In his affidavit also, in paragraph number 4 of the affidavit, he clearly stated that I submit that the accused is running business in the name and style as Grade Mix, as partner of the said Grade Mix.
Yes.
In the legal notice, in the affidavit, chief affidavit, as well as in the complaint, it is an admitted fact that Mr. B. Narsimurthy, who arraigned as accused in this matter, is representing as a partner of a partnership firm named as Grade Mix. And now, your lordship may kindly come to the cross-examination portion. Page number 13 of the deposition.
Yes.
Paragraph number 2, my lord. Surprisingly, here, he stated that Grade Mix ಸಂಸ್ಥೆಯು ಪಾಲುದಾರಿಕೆ ಸಂಸ್ಥೆ ಎಂದರೆ ಸುಳ್ಳು. Grade Mix ಸಂಸ್ಥೆಯು ಪಾಲುದಾರಿಕೆ ಸಂಸ್ಥೆ ಎಂದರೆ ಸುಳ್ಳು.
ಇಲ್ಲಿ para number 2.
Para number 2. Further,
Cross-examination. ದೂರಿನಲ್ಲಿ ಆರೋಪಿಯ ಹೆಸರು ಪಾಲುದಾರಿಕಾ ಸಂಸ್ಥೆಯ ಗ್ರ್ಯಾಂಡ್ ಮಿಕ್ಸ್ ಎಂದು ಉಲ್ಲೇಖಿಸಲಾಗಿದೆ ಎಂದರೆ ನಿಜ. He admitted. ಗ್ರ್ಯಾಂಡ್ ಮಿಕ್ಸ್ ಸಂಸ್ಥೆಗೆ ಆರೋಪಿ ಮತ್ತು ಗೌತಮ್ ಎಂಬ ಪಾಲುದಾರರು ಇರುವ ಬಗ್ಗೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. But he has not denied. He deposited that I don't know. But PWN admitted that in the complaint it is stated that Grade Mix is a partnership firm. ದೂರನ್ನು ದಾಖಲಿಸುವಾಗ ಫಿರ್ಯಾದಿ ಕೊಟ್ಟ ಮಾಹಿತಿ ಬಗ್ಗೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಎಂದರೆ ಸುಳ್ಳು. ಅದೇ ಪ್ರಕಾರ ನನ್ನ ಸಾಕ್ಷಿ ಪ್ರಮಾಣ ಪತ್ರದ ಪ್ಯಾರಾ ನಂಬರ್ 4ರಲ್ಲಿ ಆರೋಪಿಯ ಪಾರ್ಟ್ನರ್ ಎಂದು ಉಲ್ಲೇಖಿಸಿದೆ ಎಂದರೆ ನಿಜ. ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿ ಫಿರ್ಯಾದಿ ಆರೋಪಿ ಸಂಸ್ಥೆ ಪಾಲುದಾರಿಕೆ ಸಂಸ್ಥೆ ಗೊತ್ತಿದ್ದರೂ ಎಲ್ಲ ಪಾಲುದಾರರನ್ನು ಪಾರ್ಟಿಯಾಗಿ ಮಾಡಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸುಳ್ಳು. ಫರ್ದರ್ ಮೇಲೆ ಇನ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 3 ಸಾಮಾನ್ಯವಾಗಿ ವ್ಯವಹಾರವನ್ನು ಮಾಡುವ ಪೂರ್ವದಲ್ಲಿ ಸಂಸ್ಥೆಯ ಬಗ್ಗೆ ಎಲ್ಲ ಮಾಹಿತಿಗಳನ್ನು ಪಡೆಯುತ್ತೇವೆ ಎಂದರೆ ನಿಜ. Here he clearly admitted. We'll collect all the information regarding the purchaser.
Next.
ಆರೋಪಿ ನಮ್ಮ ಸಂಸ್ಥೆಗೆ ಚೆಕ್ ಮುಖಾಂತರ ಮಾತ್ರ ಹಣವನ್ನು ಪಾವತಿ ಮಾಡ್ತಿದ್ರು. That is, this aspect is concerned clearly shows that the PWN admitted that Great Mix is a partnership firm and Mr. Narsimurthy is a partner. And so far as the personal knowledge and capacity of the PW1 to lead the evidence is concerned, I have raised my defense mala during the course of cross-examination. That is, he is not having any personal knowledge about the entire transaction. And no power was assigned in the so-called general power of attorney, that is Exhibit P1 produced by him, to prosecute the case on behalf of the proprietorship concern, complainant proprietorship concern, against the accused herein. So far as that aspect is concerned,
Exhibit P1 ಇರಬೇಕಲ್ಲ, power of attorney.
ಇದೆ sir.
Authorization and power of attorney.
Power of attorney is there.
Yes.
Nowhere in the power of attorney it has been mentioned that a power was assigned to him to prosecute a case against the accused person in respect of this case, because he was not the person who presented the complaint as a power of attorney holder. At the first instance, the proprietor himself has presented the complaint, and thereafter, Mr. Sangha, the PWN examined as a witness claiming to be a power of attorney holder.
Yes.
The page number 13 of deposition only. 13, PW1, deposition of PW. First paragraph. ಈ ಕೇಸ್ನ ಫಿರ್ಯಾದಿ ನನ್ನ ಅಳಿಯನಾಗಬೇಕು. ನಾನು ರೇಣುಕಾ ಎಂಟರ್ಪ್ರೈಸಸ್ ಸಂಸ್ಥೆಯ ಪ್ರೊಪ್ರೈಟರ್. ನಾನು ಮತ್ತು ಫಿರ್ಯಾದಿ ಸಿಮೆಂಟ್ ವ್ಯಾಪಾರವನ್ನು ಮಾಡುತ್ತೇವೆ ಎಂದರೆ ನಿಜ. ನಾನು ಮತ್ತು ಫಿರ್ಯಾದಿ ಪ್ರತ್ಯೇಕವಾಗಿ ಸಿಮೆಂಟ್ ವ್ಯವಹಾರವನ್ನು ಮಾಡುತ್ತೇವೆ ಎಂದರೆ ನಿಜ. ಶಿವಜ್ಯೋತಿ ಅಸೋಸಿಯೇಟ್ ಸಂಸ್ಥೆಗೆ ಸಂಬಂಧಪಟ್ಟ ಎಲ್ಲ ವ್ಯವಹಾರವನ್ನು ಫಿರ್ಯಾದಿಯು ನೋಡಿಕೊಳ್ಳುತ್ತಿದ್ದ ಎಂದರೆ ಸುಳ್ಳು. ಕಳೆದ 15 ವರ್ಷಗಳಿಂದ ನಾನು ಫಿರ್ಯಾದಿ ಸಂಸ್ಥೆಯ ವ್ಯವಹಾರಗಳನ್ನು ನೋಡಿಕೊಳ್ಳುತ್ತೇನೆ. ಫಿರ್ಯಾದಿ ಸಂಸ್ಥೆ ಪ್ರೊಪ್ರೈಟರ್ಶಿಪ್ ಸಂಸ್ಥೆಯಾಗಿರುತ್ತದೆ. ಸದರಿ ಸಂಸ್ಥೆಯ ದೈನಂದಿನ ವ್ಯವಹಾರಗಳನ್ನು ನೋಡಿಕೊಳ್ಳಲು ಫಿರ್ಯಾದಿ ನನಗೆ ಯಾವುದೇ ಅಧಿಕಾರ ಪತ್ರವನ್ನು ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. ಆದರೆ ಅವರು ನನ್ನ ಅಳಿಯನಾದ ಕಾರಣ ಯಾವುದೇ ದಾಖಲೆಯನ್ನು ನನ್ನ ಹೆಸರಿಗೆ ಮಾಡಿಕೊಟ್ಟಿರುವುದಿಲ್ಲ. ನಿಶಾನೆ P1ರಲ್ಲಿ ನನ್ನ ಸಂಪೂರ್ಣ ವಿಳಾಸವನ್ನು ಉಲ್ಲೇಖಿಸಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಿಲ್ಲ. ನಿಶಾನ P1ರಲ್ಲಿ ಈ ಕೇಸನ್ನು ದಾಖಲಿಸುವ ಬಗ್ಗೆ ಆಗಲಿ ಅಥವಾ ಕೇಸನ್ನು ಮುಂದುವರಿಸಿಕೊಂಡು ಹೋಗುವ ಅಧಿಕಾರವನ್ನು ನೀಡಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಿಶಾನೆ P1ರಲ್ಲಿ ಈ ಪ್ರಕರಣವನ್ನು ನಡೆಸಲು ಫಿರ್ಯಾದಿಗೆ ಯಾವ ರೀತಿಯ ತೊಂದರೆ ಇದೆ ಎಂದು ಉಲ್ಲೇಖಿಸಿರುವುದಿಲ್ಲ ಎಂದರೆ ನಿಜ. 5/11/2014 ನಿಶಾನೆ P1 ಮಾಡಲಾಗಿದೆ ಎಂದರೆ ನಿಜ. ನಿಶಾನ P1 ಮಾಡುವ ಪೂರ್ವದಲ್ಲಿ ಆರೋಪಿ ಮತ್ತು ಫಿರ್ಯಾದಿ ಸಂಸ್ಥೆಗೆ ಈ ಪ್ರಕರಣ ನಡೆದಿದೆ ಎನ್ನುವ ವ್ಯವಹಾರ ಆಗಿದೆ ಎಂದರೆ ನಿಜ. That means prior to the execution of the exhibit P1, power of attorney, he was not aware about the transaction between the complainant as well as the accused man. And he himself admitted that though he was looking after the affairs of the proprietorship concern, complainant proprietorship concern since 15 years,
no document was, no power of attorney was executed in his favor. And for the first time during the pendency of the case before the trial court, the power of attorney was executed in his favor. And the power of attorney was very clear that it is the main averments were absent in the power of attorney, that the impediment which the principal was having to depose before the court, that was admitted by the PW1. Yes, he was not having any personal knowledge, and the complainant, Shivajyoti Associates, the proprietor of Shivajyoti Associates, never stepped into the witness box. That apart, my lord, they have relied on, apart from producing the bills, the invoices said to be issued by the complainant in favor of the accused.
Yes.
The accused has produced Exhibit D2, a bank statement, to show that he has paid the amount. And Exhibit P70 was produced by PW1. A document said to be a ledger extract of the complainant proprietorship concern, maintaining the account pertaining to the business transaction of grade mix. Your lordship may kindly see, this is a self-made statement, and this was not audited by any of the auditor. And that was admitted by the PW1 in his class examination that
This must be the statement produced along with the returns probably.
Subsequently.
yes, my lord, no
Subsequently
returns
is
was
raised-
produced.
Is raised cross-examination.
I put
you
a
are not,
suggestion during the course of cross-examination
stated
in
in
this
the-
regard.
income tax returns, therefore subsequently is produced.
Your lordship may kindly see
Exhibit 73 and 70.
the deposition of PW1, that is page number 16, my lord, wherein I have put some suggestions to the PW1 regarding this statement as well as the income tax return. Tenth line from the bottom of page 16, my lord. 10th line from the bottom.
Yes.
ನಿಶಾನೆ P70 ನಾನು ವೈಯಕ್ತಿಕವಾಗಿ ಮಾಡಿದ ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಂದರೆ ಸುಳ್ಳು. ಈ ಪ್ರಕರಣಕ್ಕಾಗಿ ನಿಶಾನೆ P70 ಸೃಷ್ಟಿ ಮಾಡಿರ್ತೇವೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಿಶಾನೆ P70ರಲ್ಲಿ ಉಲ್ಲೇಖಿಸಿದ ಹಣದ ಬಗ್ಗೆ ಆರೋಪಿ ಸಂಸ್ಥೆ ನೀಡಿದ ಚೆಕ್ಗಳ ಪ್ರಕಾರ ನಾವು ಹಣವನ್ನು ಪಡೆದಿರುತ್ತೇವೆ ಎಂದರೆ ಸುಳ್ಳು. ನಿಶಾನೆ P72ರ ಪ್ರಕಾರ ಸಿಮೆಂಟ್ ಅನ್ನು ನಾವು ಆರೋಪಿಗೆ ಸರಬರಾಜು ಮಾಡಿಲ್ಲ ಎಂದರೆ ಸುಳ್ಳು. ಆರೋಪಿ ಜೊತೆಯಲ್ಲಿ ಆದ ವ್ಯವಹಾರದ ಬಗ್ಗೆ ವರಮಾನ ತೆರಿಗೆ ರಿಟರ್ನ್ಸ್ ನಲ್ಲಿ ಉಲ್ಲೇಖಿಸಲಾಗಿದೆ. 31,20,300 ಆರೋಪಿಯಿಂದ ಬರಬೇಕಾದ ಬಗ್ಗೆ ವರಮಾನ ತೆರಿಗೆ ರಿಟರ್ನ್ಸ್ ನಲ್ಲಿ ಉಲ್ಲೇಖಿಸಲಾಗಿದೆ. ವರಮಾನ ತೆರಿಗೆ ರಿಟರ್ನ್ಸ್ ಅನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಬಹುದು. But he has not made any attempts before the trial court to produce those documents before the court,
Is produced.
or not produced any certificate from the auditor confirming the statement of this so-called ledger extract, that is Exhibit P70. From seeing from the contents of the document, it is very clear that it is a self-made document of the complainant. So far as that aspect is concerned, I would like to rely on a decision of our Honorable High Court in the case of Vijay Lakshmi versus Mohammed Pasha. Really, I am sorry, Malay, I failed to get another copy. One copy is there. Wherein the Honorable High Court clearly held that in paragraph number 4 of the
judgment, my lord. In the criminal complaint on behalf of the complainant, the power of attorney holder R. Narayan Rao adduced evidence as PW1. He produced and marked in all 11 documents. Out of that, exhibit P1 is the power of attorney. Exhibit P2 to P8 are documents relating to deposit of check and its dishonor. Exhibit P9 to P11 are the books said to have maintained by the complainant firm with reference to credit transaction of its customers. The relevant entries with reference to transactions with respondent relating to dishonored check is said to be at exhibit P9A, P10A, P10C, and P11C. The respondent effectively cross-examined PW1. However, neither oral nor documentary evidence was produced in support of his defense. An attempt was made to demolish the prosecution witness. In fact, the respondent attempted to demonstrate that the entries contained in exhibit P9 lecture books are erroneous. They are falsely inserted in the said book, that the said entries do not support the claim of the complainant to seek recovery of amount under the check, which was disputed with the complainant in the bank. Heard the learned counsel for the appellant and contesting respondent perused the lower court records and also grounds urged in this appeal. On going through the same, it is seen through the complainant that though the complainant has stated that the accused was due in a sum of rupees 71,356 towards outstanding balance for supply of cements, the bills under which the cement was supplied is not produced and marked in the court below. The entry as seen at exhibit P10A is the ledger book for the year 2006-7 would indicate that at the relevant time of that entry, running bill of the complainant's firm is of the series of 310, 319, 320, whereas the bill which is inserted in between two entries in that is with reference to supply of cement is of the value of so and so under bill number so and so. Though the complainant rely upon the said entry to substantiate his claim, copy of said bill is not produced and marked. The place where it is inserted in said ledger does not indicate that the said entry in exhibit P10 G9, the complainant is registered dealer of cement. It is further seen that exhibit P11 there are two entries which are with reference to the dating of rupees 15,345 towards alleged arrears interest as well as entry of rupees 8,000 indicating cash in paid to the accused respondent herein by cash. Assuming for a moment such transaction have taken place, the complainant ought to have furnished the voucher for having rupees 8,000, though there is a debt entry for having applied interest per period of so and so towards amount said to be due. The complainant has to show the principal amount due on which interest is calculated applied in. In absence of any of these essential details based on which the complaint is seeking to demonstrate the check was given not being on record, the court below has rightly rejected the evidence of complainant so far as it pertains to exhibit P9, 10, and 11, and has rightly rejected to accept these three books as books which are maintained by the complainant in a day-to-day business transaction with reference to credit sale made in favor of various persons where names are referred in the register. In that view of the matter of reasons given by rejecting the complainant filed by the appellant appears to be just and proper. Therefore, the absence of acceptable material substance, the alleged transaction resulting in dishonor of check not being properly established, the question of admitting this appeal does not arise. Here, my lord. The Honorable Court clearly held that mere furnishing of a loose papers or sheets or books of entries without auditing the same cannot be considered.
All right. Sir? Yes, sir.
Lord, I appeal for the complaint. Lord, the accused is taken a defense that complaint is not maintainable. One aspect. He is not issued the check for discharge of legal.
Continue on Monday. All right. Okay. Last one. I list it on Monday, 2:30. If time permits, I will take it because already the board is full on Monday. So you complete your argument so that we can pass orders. Yes. All other matters may not be taken. I think it can be adjourned. ಯಾವುದು? 16. Time ತಗೊಂಡ್ರಿ. Part heard ಆಗಿದೆಯಲ್ಲ? Do it after vacation. 23rd or 24th. All other matters you can take dates.
Read serial number 113. Sought dispensation of the amount lent.
Huh? You sought for?
Partly heard and dispensation of the.
Partly heard.
And the
24,
other
how
side-
it can
other-
be?
Other side repeatedly did not appear. After hearing for some time, and when your lordship questioned them as to how the manipulated judgment would prevail. But after that, it did not appear.
They have not come.
They have not come.
Whether it is by me or some other judge, functus officio will come into place.
Yes.
Because after the judgment, it was recalled and passed.
Yes, my lord, recorded past in this.
Take it, go before the next bench.
It is third bench, my lord.
No, I cannot make it
This-
as part heard because I have not heard the other side. There's no point.
Lordship can take it on Monday.
Already 150 matters on Monday. All right. Matters is there? 1 to 4 matters only. Others are adjourned. You give a date. You have to take what date. Don't give anything on 30th and 1st. All after vacation.
Madam. Madam. Madam.
कॉल कर दो.